Well, good evening. Happy Friday. Good evening. Good evening. Or depending on when you're listening, good morning, good afternoon, good day, good night, happy morrow. Whatever phrase or parlance, if you accept my parlance, you are used to. Hey guys, how you doing? How's your week? Hopefully the audio is not being audio issues, and hopefully we're doing okay. We shall see, I guess. That Kit McGuire making a comment, very, very good. That thumbnail was disturbing. I thought so as well until I gathered why it was designed the way it was. Because we had a court day canceled because of the heat. So that was the lawyers, taking part in a little bit of doing what they can to try and manage the fact that we had a little bit of excessive heat in the courtroom that cannot ever manage its temperature. So hopefully you guys are doing well. Hopefully you had a good week. Hopefully all is going swimmingly in your neck of the woods, wherever that might be, wherever you're tuning in from. Let's check in with folks before we get rolling, because we've got a lot to cover tonight. For those of you wondering if I'm going to go back all the way through the week and through all the week's testimony from the Karen Reed trial, I am not. That would be, I just don't know that we're going to get the same level of impact. I can summarize, and we can do that when we get rolling, but realistically, I am too excited about the fact that we have ARCCA witnesses on the stand finally. I say finally because I feel like ARCCA is the boogeyman in this trial, and I've been wanting to listen to 4 witnesses. Okay, Shannon Burgess, Dr. Welcher, Dr. Wolfe, and Dr. Rentschler, because the engineer in me loves the good science and the experiments, and someone's got to make this thing work the way my brain processes it working. And that's what I am hoping to learn. And as we knew from all the pretrial hearings, when Hank Brennan says that he's not afraid of something or that he welcomes something, we are generally left with the impression, given the experience and observing how he litigates the case, that it is perhaps the opposite every single time. It's like magic. Oddly enough, the mini mischief one is really into magic right now. So she was showing me the magic trick before we got on the show. And I couldn't figure it out. She was showing me a magic card trick to pick the card, and then all of a sudden she was like, "This is your card." I said, "That actually is my card. How did you do that? Why were you communicating with the spirit realm? Like, how did you?" I was watching the cards. She didn't do the best shuffling, but I didn't spot where she did the flag. People are reporting issues with sound again. Let's go ahead and do this. We are going to do those 2 things. Hope that the sound picks up and gains up a little bit. And perhaps that might do it. I don't know. Other than that, let me double check and make sure that there's no noise gate or anything on. Give me 1 second while I try to fix the things. Perhaps that might be it. Audio is now quiet. Why is the audio now quiet? It shouldn't be. Let me fix this. Now people are saying that's better. We're going to leave it like that. Okay? We're going to leave it like that. I'm going to keep my hands off the buttons. Keep the hands off the buttons. Not going to touch anything. Nothing touched. Please, just stay still. Don't do anything, computer. Don't restart. Don't put me into a tech turmoil like you always do, you machine of devilry. It has been frustrating. It has been. But again, I haven't had very much time to do very much of anything. I've been in court again a lot this week. I was in court today. Good outcomes again. I'm not going to say that out loud, because if I say that out loud, I'm going to curse myself. I'm going to jinx myself. I don't want to do that. we're going to say that we are preparing adequately for the hearings that we have going on, and therefore, in doing that, we're doing okay. So before we get into too much, like I said, I've been waiting. The little engineer in me has been waiting for four engineers, four people that can get up and explain physics and science and math and data, and I've been waiting for all the data and science that the prosecution's been saying, and instead I feel like we got finger paint and cosplay. I will say, with charts and things that gave me conclusions but didn't do a very good job of explaining why I should reach those conclusions or understand those conclusions. So I've been waiting because there's been a whole lot of pretrial litigation over ARCCA and whether ARCCA would be permitted to testify at all. And not just whether they'd be able to testify, but to what scope they'd be able to testify. So we shall see. We're going to go through, but that's where the focus of tonight is going to be, is on listening to Dr. Wolfe. Dr. Wolfe was on the stand all day today. And he is returning again on Monday for the resumption of Alan Jackson's redirect. So we got direct examination, cross-examination, and now we are in the middle of Alan Jackson's redirect. So we actually have a pretty fair opportunity to view what information both sides really wanted to highlight for the jury and how the Commonwealth wanted to try and undermine that. But as we get rolling in here, I can see there's 1,200 views. So before I get too much further, please, the 1,200 of you that are here right now and the people that are watching on replay, hit the like button. You don't think it does a lot? It actually does a whole lot. It does a lot for the channel. It does a lot for people that are watching the content. It does a lot for the people that are looking for places to watch the content and recaps. So please hit the like button. It takes you 2 seconds. For those of you who are watching on your phone, you can actually just minimize the screen, and it's right there. Click that. So it would be very, very much appreciated for you guys to do that, because I always forget to ask until it's way too late. Other news, before people in the chat start asking, Ian Runkle is out of pocket temporarily, but he might make an appearance. There might be a wild Runkle. I can't guarantee a hammock appearance. I can't guarantee a completely appropriate appearance. We know that whatever appearance is made, if made at all, he's just going to show up, probably at a very inopportune time. Rather, the only time that he wants to ever show up, which is all the time. Playing up the chat, Wolfe Kiara. Dr. Wolfe had such a geeky, lovely charm. He was pretty fascinating. Sandy liked him too. Dr. Wolfe was amazing. Did you watch any of it? You're watching cold. I watched on 2x at times, 3x for the remaining. For those of you wondering what Hank Brennan sounds like on 3x, 3 times speed, I am not going to subject you to that. I won't. Suffice it to say, it's like Alvin and the Chipmunks with the sarcasm and condescension you would imagine out of a teenager. Whew, it was Sam's Galaxy, but it was car paint, underpants profit. It was very fascinating. Speaking of Dr. Welcher. Patty P, Rob saw you in Andrea's chat today. Yep, I was watching, opining a little bit, and I will be able to give my own interjection here as we watch it again. Just getting caught up. Alvin. Yeah. Brennan at 3x. No, thank you. It was something else. Oh, EDB on 3x is also pretty funny. It's funny when she yells on 3x. That's my favorite. Yeah. Say Rescue Randy. I didn't know there was a Rescue Randy. So we learned a lot today, which was great. Because this, for those of you who are wondering, and for those of you who have seen it already, what you observed today is what I expected and anticipated out of any expert that was coming to give an opinion on forces, trajectories, accident reconstruction. So we're going to get into all of it. All right, make sure we get caught up, and then we can do that. Other thing that I thought was interesting was Dr. Wolfe in this trial. I watched the first trial, and in the first trial, I thought he was good. In this trial, with more of an opportunity for him to be prepared, and for him to have his slide deck presentation ready to go, I thought I was far more impressed by the delivery. Way more impressed by the delivery. Where is it? Emily calls Dr. Wolfe Dr. Dimples. I'm not surprised. I'm not surprised. Rescue Randy has entered the chat. Rescue Randy was entered the chat. But Rescue Randy hit by the bumper Betty. Is 3X on premium? No, 3X, I think, well, I don't know if it's premium or not, but it's only on my phone. And yes, I have premium because I can't watch commercials or the ads that interject, especially when I'm trying to keep up with live testimony. So I've kind of valued that in my calculation as being worth the cost. So, shall we get rolling with the beginning of the Science Daddies? Crash Daddies? You guys call it Crash Daddies, right? I can't logically refer to expert witnesses Crash Daddy. I will though joke, like, talk science to me. Like, no, the I can't. I want the Crash Daddy remarks. No. Oh, no, I can't. In other news, before we get rolling with that, yes, I saw a news update. Hang on, let's do this. I want to do this. We haven't done this in a while, right? I know we want to get to the Karen Reed coverage, but there's been a lot of Karen Reed coverage. There's a couple of stories that we can close the loop on. One of them is Tom Girardi. Tom Girardi. For those of you who don't remember Tom Girardi from The Real Housewives, Tom Girardi from Girardi Keese, who embezzled a ton of money from his clients, who filed for bankruptcy, who in the process of filing for bankruptcy was then prosecuted, who in the course of that prosecution tried to assert a defense of that they lacked mental competence, and the judge was like, nah, bro, you can understand what you're doing. Tom Girardi was sentenced. Tom Girardi, hang on, the chat's going to wonder with the question. Let's see, Tom Girardi. Let's do a picture that people might recognize, just to show the chat who we're talking about here. So for those of you who watch Real Housewives of whatever season or episode or state or location, I don't know. Beverly Hills, maybe? Was that true? His pants fell down at court? No. Oh, people are asking for a swoop. We can do a swoop. We can swoop to this. First fun topic. That's not a real topic, but kind of a real topic because, you know, we need topics. There we go. Yeah, Beverly Hills. So Tom Girardi, sitting next to Erica Jane. Tom Girardi was an attorney, and a very prominent attorney in LA, who was a plaintiff's counsel in a lot of very, very, very famous large tort claims, Lion Air, various stuff. Turned out that Tom Girardi was embezzling money from the client trust fund. And not just doing that, he was doing that for years. Millions and millions of dollars. Buying diamonds and earrings and stuff out of the trust fund. It was pretty wild. So Tom Girardi was actually sentenced because he went all the way through his trial. Said, no, I wasn't competent. I didn't understand what was happening with the money that was coming out of the trust account. Even though, you know, he knew it was happening because he was still involved in the law firm and all of the above. So let's find a decent article. There we go. You know what? We'll look at the DOJ press release. Former plaintiff's lawyer Tom Girardi sentenced to more than 7 years in prison for swindling tens of millions of dollars from injured clients. The press release. Los Angeles. Disbarred plaintiff's attorney Thomas Vincent Girardi was sentenced today to 87 months in federal prison for leading a years-long scheme in which he embezzled tens of millions of dollars of settlement money that belonged to his clients, some of whom awaited payment for treatment of severe physical injuries. Girardi, 86, formerly of Pasadena, who now resides in Seal Beach, was sentenced in the U.S. District Court. Judge Staten also ordered to pay $35,000 fine and $2,310,247 in restitution. ordered that he be surrendered to the federal authorities by no later than July 17th. Jury found him guilty in August of 2024 of 4 counts of wire fraud. This is a quote from the U.S. attorney who handled the case. This self-proclaimed champion of justice was nothing more than a thief and a liar who conned his vulnerable clients out of millions of dollars, says U.S. Attorney Bill Saley? Sure. My office will go vigorously prosecute corrupt lawyers and those who assist them in criminal activities. Okay, where are the rest of the prosecutions then? Because he continued in the practice of law when several people should have noticed that things were not running properly. He had a lot of connections, a lot of authority, a lot of power. Thought he could outsmart his victims and investigators. He did for 12 years plus. So I will say that that is something. But yeah, basically just kept on using new settlement proceeds to fund payments for past settlement proceeds, which is not how you're supposed to do that. I was very interested in that case because I had covered the bankruptcy proceedings for quite some time, and I wanted to see that loop closed on Tom Girardi. And now that loop is closed, and I feel good knowing now that that case is resolved with a conviction and a sentence that is a little light-handed given all the allegations. 7 years seems to be a little bit light, but again, given his age, he's 86, 87 years old. That's a life sentence for someone of that age. That is not good. And then apparently his son-in-law pled guilty, or as LA Times is reporting, that his son-in-law pled guilty to a federal charge in Illinois. 1 count of contempt of court for defying a Chicago judge's order concerning distribution of settlement funds. Okay. So that's Girardi. And then we get to close one more loop. The other loop we get to close today is the loop concerning, we covered the possibility. Actually, let me swoop. We're going to close another loop. Look, we get more swoops because we close loops. That rhymed. That was rhythmic. It rhymed. Well, let's see. This one comes courtesy of the Mod Squad sending me this notification. Let's see. Because I had let this article, or this had kind of fallen by the waysides. JOANN Fabrics. Remember we talked about their bankruptcy filing and how all of a sudden the stores were just going to not be there anymore? Turns out Michaels has acquired a bunch of their IP and the private label brands. So we talked about how JOANN Fabrics as an entity was going to likely be divvied up and that there would be certain things that would be on the market. So the real estate would go back into leaseholds and people might be able to purchase the physical property and inventory. People might be able to purchase some of it. And then there might be someone who would want to acquire the intellectual property and some of the more valuable assets of JOANN Fabrics, and in comes Michaels. So June 5th, the Michaels companies today announced that it has successfully completed the acquisition of the intellectual property and private label brands of JOANN, including the development of the beloved Big Twist brands. I don't know what that brand is, but I imagine some people in the chat might, as part of the Michaels portfolio. In addition, Michaels is expanding its fabric, sewing, and yarn assortment, adding over 600 products across new and existing brands, including sewing and quilting supplies, fabric, yarn, specialty threads, sewing machines, and more. You guys didn't know you were going to get a Michaels ad read, did you? Honestly, neither did I. The acquisition and expanded product assortment reflect progress as Michaels continues to reimagine the customer experience. Why are there reimaginings of everything? Why is this the it word of all things? We are going to reimagine the customer experience. We're going to reimagine litigation. We're going to reimagine courthouses. We're going to reimagine all the things. It's just buzzwords. Why can't we just speak normally to people? So they're honored to welcome JOANN customers into their creative community. Honestly, this is a very logical acquisition too. I'm not surprised by this. This is very smart. I just didn't know that Michaels would have had the capital to make the acquisition. So looks like we're going to have some more fabric availability for those fabric crafters in the chat. I know there are several of you. So look at that. 2 stories closed, and they were complete asides. Didn't know we'd get that today, huh? Yeah, because we thought we were going to be stuck on Karen Reed. So boom, there. Sorry. I'm sorry. I'm feeling punchy this evening. I'm not sure why. Maybe it's because I was yelling in court. Today was a yelling in court day. A very loud and boisterous day. I think I scare attorneys that see me for the first time. Because when I talk to them, like when I'm negotiating or discussing things, I'm talking very calm. I'm not playing the part. I'm not the litigator in that moment. At that point in time, I'm just the attorney on the other side. But when I have to make a point in front of a judge, and if I have to drive that point home, I get a little theatrical. Yeah, sometimes probably a little bit too much. I don't know that I ever get downright condescending, though. At least I try not to. I just don't think that's effective. But every now and then you got to yell. It just happens. All right. Playing catch up, and then we'll get to our content for the evening. So swoop to catch up. FYI, I put the swoops in there to help you guys know where it is that we're having the channel stops and where you want to jump forward or not. I can't imagine Rob yelling in court. We will say that I can get and I can take my tone and put it into a very resonant stage that has taken years to acquire. Every lawyer, when they first start out, is very timid in court. And over the years, some people stay timid. I did not. I realized that if a judge is going to possibly ignore me, and if I could be a little bit louder and get the attention of the judge so they couldn't possibly ignore me, I was going to do that. So that's what we do. And it's not really yelling. It's more just projecting these courtrooms are a lot larger than you think. The number of times in my career that I have had a judge say, Mr. Morton, if you could come to the podium and speak to the microphone because they can't hear you, because you think your voice carries throughout the courtroom, but there's a whole lot of fabric in that courtroom and it's a long span. So I just started speaking loud enough that I didn't have to have a judge tell me that I had to speak up. And I figured that was the better way of going about it. And for so far, it's been working out all right. I've been kind of pumped with it. Rob to Dr. Wolfe, talk nerdy to me. Yeah, talk nerdy to me. Mostly harmless fuzzball? Absolutely. Nexus Lexus, do I do vocal exercises? No. Should I? Yes, I probably should. Never understood. Every now and then I do. Rob, your room looks cluttered. Is that office or rec space? It's combo. It's combo space. So there's the jury on the wall. There's the 3D printer. There's things that need to be organized and cleaned that are not cleaned. There's actually a unicorn. Oh my God, I'm going to scare the hell out of people that have never been here before. There's actually a unicorn hoodie that I put on when I need comfort or need to make people laugh. So the room is cluttered. It serves two purposes. It's a home office, studio, creative design center. There's a computer setup for the kids to do 3D printing and 3D modeling. So it needs some work, but I don't have a lot of time to put a lot of love to it. Double check. Getting caught up. Sorry. Let's see. Jury has no box yet. Yeah, I don't have a lot of space in this space. Ooh, printed taillight. Yeah, we got to. I might print a taillight and see if I can't just completely destroy it. I don't know why I would want to do that. But I'm now kind of curious, given the fact that we've seen someone do it. Oh, Nexus Lexus. There are several screen grabs of me in that hoodie. A lot. A whole lot. That hoodie came courtesy of Who was it that sent me? Wolfe? Yeah. Yeah. The screen name is eluding me because I've had it for 2 years. Anyways, I have that. I've got the jury of robots. We can do the jury of robots as we get to the testimony. We'll do that as a swoop for the testimony. The unicorn has lights. It has lights. It does. I am a child. I am a full practicing litigator. I am a full-time litigator. I'm in court all the time. I love my job. I've been doing this for more than 15 years, trying cases. But I am still a child. Because you have to be in order to do this for long enough. If you took your life so seriously all the time, what's the line from that movie? It was Van Wilder. Oh my gosh, Van Wilder. Why am I even thinking about that? Van Wilder. Don't take your life too seriously. You never make it out alive. Okay. Viking Wolf. Yes. Viking Wolf by blood. Yes. Yes. She sent it to me. So, getting caught up. Tough Cookie, thank you for gifting memberships. Very much appreciated. For those that are now members, please go check out the shop streams where I think I actually wear the hoodie. I don't know. Oh, I also have, in case I need courage, I have a courage hat. Do you want to see the courage hat? We can see the courage hat. So I have the courage hat too. Just in case, for those really scary witnesses or scary times. Thank you, Tough Cookie, for the memberships. Shay B, audio comes and goes. Hopefully it's sorted now. Tammy Fayette, that looks like a kid's playroom. Cool. Yeah, it is. It's an adult's playroom, too. Like I said, it needs cleaning, but so does the whole house. So par for the course. Occipit Boner. Screen names. Lally and Brennan should be Aperture's crash dummies. I would never suggest harm to befall anybody, but the certain experiments made more sense than others. Baby steps. Thank you for gifting memberships. Very much appreciated. Emily Aaron's thoughts on Devers, Lady Cop's false memories. People are going to read that the way they want to read it. I don't know why the defense called her. I do a little bit. I think that I don't know. I don't know how much of that's going to be remembered. I really think that it's going to come down a lot to ARCCA versus Aperture. Emily Hart, Rescue Randy should have chose another job. Poor guy. Rescue Randy didn't have very much of a choice. He was made for that. Justice Obsessed. I was glued today. Blues Clues versus Mythbusters. That's really funny. It took me a solid second to get there, but I did. That's really funny. Creed M, how does Crash Daddy stack up against Paint Daddy? Well, it's a decision for you guys to make. And what's funny is Dr. Wolfe isn't really supposed to directly combat all of Dr. Welch. I mean, it's like a 1-2 punch. So we'll have to see. Camilla, thank you for gifting memberships. XCDA, Swoops make me happy. Thank you. Thank you, XCDA. Cherry Lackey, thanks for becoming a member. Much appreciated. Odin's Martyr, I wish they had explained that cooling the acrylic lens made it more brittle and shows active bias avoidance. That probably should be cleaned up on a redirect. But at least now we understood where Hank was going with the did you use or freezer in the prior remarks. Nurse Coy, I want to see EDB geek out about ARCCA, and now Rob. I got to see EDB geek out about ARCCA, now Rob. Yeah, we're going to geek out. It's going to be fun. AG, happy Friday. I turned 34 today. Happy 34th birthday. Happy birthday indeed. Teacher said I'm going above and beyond with my steno theory, and she's very happy with my progress. Painted minis and thought of you, Rob. Would love if you've covered the case I sent you soon. AG is a magical thing about timing. I actually read more into the case. I think it's phenomenal about using auto transcription / AI transcription and the faults in that transcription. I myself can attest to a lot of the way that these large transcription companies screw things up, and also the cost of transcription in general. So I think it's a very fascinating case, and I will try to get that covered. But again, it's a matter of timing. As soon as this trial is done, I'll obviously have more material and more time to go over that. Thank you. I still have it. Trust me, it's not gone. Light Queen, thank you for gifting memberships. Mary Lou Crafts, Playroom needs scope for the imagination, aka clutter. I'm actually, don't laugh and don't judge. I am actually, Mischief Manager and I are trying to find an assistant. An assistant to, well, assist with a household and someone who has two full-time jobs. Me and another person who has two full-time jobs. Mischief being mom and full-time job. So trying to find help to help organize and do other things. And we are working on it. There's been too many commitments, too many promises, too many things that have fallen by the wayside because there has not been time to do it. I mean, for example, I come home after a full day of work today, have enough time to eat dinner, get kiddos. I mean, sometimes not even get them in bed before I'm here talking to you guys on a live stream that goes for several hours breaking down cases. And then tomorrow it's back up and doing the stuff that we have to do to get the house in order for the week. Then every day is like rinse and repeat. So I'm doing my best and I fall short a lot. And I think now it's reached the point where I've recognized those shortfalls to such an extent that I've recognized that I need help. So I got to find that help. And it's not the kids that are the challenge. It's the other stuff about the kids being here. And just humans living in a house. We had to throw together like a potluck dinner tonight. Like just whatever was in the fridge was on the table. It just worked. It worked. Idle Hysteria. I like, if my life wasn't funny, it would just be true. And that is unacceptable, by Carrie Fisher. I like that too. Casey Cat, early happy birthday to me. I turned 69 in March on Monday, June 9th. Happy birthday, Casey. Happy Casey Cat. Happy birthday to you. Wonderful. I love the birthdays. Someone, Bloody Random. Rescue Randy needs rescuing. He did okay. I think he's fine. Shay B coming in with 50 gifted memberships. Thank you very much, Shay B. That's insanely nice of you. Thank you. Vez, Dr. Vez from Quebec. Holy crap, 33 months growing old with you guys. Don't say growing old. We're just, well, no, it's the phrase. We can get older. We're just not going to grow up. We're going to do that. Emily Hart, Brennan was trying to say nothing else. Hit the body and the foot is run over. We're going to get to Brennan's Cross because there's a lot of there. June Sidloskus. Did you see Donna Adelson? Adelson was transferred to another jail because of lack of tables. Or the first test went out as she wasn't released from jail. I did not see that news. I haven't been covering that case, so I'm not the one to speak to about it. I don't know that case nearly as well. Sharky. Growing old is mandatory. Growing up is a choice. And I choose not to do the latter. I choose not to do the latter. Allie Anderson, thank you. I work in medical simulation. Very familiar with Rescue Randy, Nursing Annie, Sim Man, and the rest of the crew. Well, maybe when we get to that, you can talk to me and talk to us about the very large significance that we were trying to place on some of these characters and whether they were appropriate to use in this setting when I didn't understand why the hiccup was what the hiccup was. Okay, shall we get rolling? I think we should. 34 minutes in, that's not too bad. Let's do this. You guys wanted to see the jury, so we will call the jury. And oddly enough, we get an appearance in calling the jury to hear from Emily. Dr. Vez, yep, getting old, but never growing up. My bad. Oh, no, I understood it. Happy early birthday. Rob, the cover image is fire. Thumbnail guy does well. All right, to ARCCA we go, and let's go ahead and bring this jury from the Maya trial. Let's see if we can find it. There we go.
The court has said our favorite thing. Bring the jury. Bring the jury. Bring the jury.
There's the jury box. Here's the jury box. All right. let's rock and roll, folks, because we got a lot to get through. We got a whole lot to get through. Oh, did I made her redo that? Didn't I make her redo that? I think I made her redo that. Oh, yeah, I did. I made her redo that. Hang on, jury questions. It was this one.
Bring this jury. We have questions.
There, that was the Maya case. That was different. So we had Murdoch for bring the jury, and then we had bring this jury, which was the Maya case. There we go. Either way. Let's go. Let's rock and roll. Share the audio tab. Yes. Lori Wallace is saying it, so I don't have to, but although I'm going to repeat it. Hey, y'all, smash the acknowledgement button. For those of you who have not seen the trial, hit the like button. We can acknowledge the stream all day. Hit it like you would a taillight in the Sally port. Oh, God. I didn't read the rest of that. Oh, no. Oh, no. Oh, my. Being told Nightbot might not be on. Let me get this fixed. Get that fixed. Nightbot ain't Fightbot, but Nightbot helps me manage focus, which I need sometimes. There we go. All right, that should work. All right. Let's rock and roll.
Good morning.
Good morning.
So, sir, we're going to try and keep the keep the air conditioning on this morning, so I'm going to ask you to speak really loudly into that microphone. And Mr. Jackson, you do so as well, please, okay?
So we're all going to use our outside voices. We're all going to use our outside voices. So for those of you wondering why it seems like the lawyers are yelling, Judge Canoni just told us, because the air conditioning is on. It's hot. This is an old courthouse, old courtroom. Here we go.
Of course, Your Honor. Dr. Wolfe, could you please state your entire name and spell your last name for the jurors, please?
Daniel Michael Wolfe, last name spelled W-O-L-F-E.
May I inquire, Your Honor?
Yes.
Dr. Wolfe, what do you do for a living, sir?
I am the director of accident reconstruction at a company known as ARCCA, A-R-C-C-A.
And I'm going to start right off the bat, getting really comfortable with that microphone. It's adjustable. Pull it right close to the area of your chin. It's really loud in here.
Okay.
Dr.
So there's a problem with that in that he pulls it straight up next to his breath hole. So there's a whole lot of just breathing that we get because the microphone is very close. So you listen to Alan Jackson's instruction. We're going to get a lot of breathing, folks.
Dr. Wolfe, you said you work for ARCCA, A-R-C-C-A. What is ARCCA?
ARCCA is a forensic engineering consulting firm. We have a variety of disciplines: accident reconstruction, which is the group I'm a part of, biomechanics, failure analysis, and crashworthiness.
And you said that your title again, one more time?
The director of the accident reconstruction team.
And what sort of contracts does ARCCA normally engage in routinely?
So in addition to our forensic consulting work, we have, going back in time, we've dealt with doing contracts with the Department of Defense, where we designed energy-absorbing seats for MRAP vehicles, mine-resistant armored protective vehicles, where these vehicles were going over explosive devices, and the energy from those explosions was going through the vehicle into the occupant. So ARCCA designed energy-absorbing seats to help mitigate the injuries in that type of in those types of incidents. We also do work for the National Hockey League. I myself am part of that work. It has to do with scanning and analyzing player pads, but we certainly do impact testing and help set guidelines for player safety.
With regard to those MRAP vehicles, was that contract for the Department of Defense for the United States government?
Yes, sir.
For the military?
Correct.
Is ARCCA both?
Y'all, okay. The Dr. Dimples and Crash Daddy, as long as we keep the comments PG, we're good. Because I'm making this comment because I made the comment about him breathing into the microphone, and the number of people in the chat that just said we can live with the breathing or some version of that. Y'all, I understand, but we're going to behave a little bit. He's a married man. He's happily married. So we're going to be PG, with Dr. Dimples, Crash Daddy, Dr. Wolfe. We're going to be PG, okay? At least in the chat, because I don't want YouTube coming down and just destroying this entire video.
Nationally and internationally recognized as a leader in accident reconstruction.
Sustained.
Does ARCCA have a reputation, or let me ask it this way. Does ARCCA entertain or engage both domestic and international contracts and clientele?
Yes.
As the director of accident reconstruction, do you specialize in anything other than just accident reconstruction? Anything having to do with human factors?
Yes. So my other specialties in addition to accident reconstruction are lighting and human factors.
What is, give us a 25-word overview of human factors. What is that?
So to give you a good example of that is, and again, this is a case that I commonly see, but let's say you're driving down the road at night. It's an unlit roadway. You're relying on your vehicle headlights to see the roadway ahead, right? And you've got a pedestrian that is entering the roadway. And you want to have an understanding based upon the lighting conditions, how much sky illumination there is, their clothing, right? When would a driver recognize that individual on the roadway? So that's where it starts from the vision aspect of human factors. Then we get into driver response, right? So the driver is presented with a hazard. So how do drivers typically respond to it? What are their actions and how long does that take to avoid and initiate a reaction?
That's human factors. Can you do the same thing and give us an explanation for accident reconstruction just in the broadest sense? What is that discipline?
I think a very simple definition of accident reconstruction is the application of physics and engineering science to collision events.
Yes. Yes.
What role do you take as the director of accident reconstruction for ARCCA as contracts come in or engagements come in?
Well, my scope and cases can vary greatly. As I just mentioned, I could have a case where I'm assessing the conspicuity of a pedestrian and a driver's response time. It could be a 50-car pileup on a highway, and I'm trying to figure out a sequence of events. It could be a rear-end collision where a seat back has failed in the vehicle and the occupant has sustained injuries, and we want to have an understanding of the crush, the damage, the forces. So, again, it can vary case to case.
Do you engage in reconstruction or attempt to engage in reconstruction of all sorts of passenger vehicles and commercial vehicles?
Yes.
What about motorcycles?
Yes.
Bicycles?
Yes.
Involving pedestrians and sometimes involving no pedestrians?
Yes, I see all types of collisions.
How many cases, if you have a number in mind, have you been a part of in terms of engaging in accident reconstruction broadly?
That's something that I don't track, but I've been with the company now for over 8 years. So at this point, if I had to estimate, it's well over 1,000 at this point.
What education, training, and background do you have that allows you to perform the duties that you've described for these jurors in terms of accident reconstruction and human factors analyses?
In terms of, are you looking at additional training?
No, let's start with your education. I want
Absolutely,
education, training, and background, but we can do them in order.
Okay, yeah, so we'll go back to 2012. I received a Bachelor of Science in Engineering from James Madison University.
Was that a Bachelor of General Studies? General Sciences? Not saying that anyone needs to have those degrees, but we're starting with the educational part. Interesting. Compare and contrast. And yes, chat, I completely understand. I wasn't giving a true admonishment. The jokes will write themselves. This is engineering. So, like I said, as long as the jokes stay within the realm of jokes, we're good.
Along with a minor in mathematics. Some of my courses included physics, statics, dynamics, thermodynamics, fluid mechanics, your engineering sciences. Subsequent to that, I then went on to pursue my PhD in electrical and computer engineering with a concentration in electromagnetics and photonics. So my coursework while doing my PhD included optoelectronics, semiconductor physics, basically how to guide light on semiconductor devices.
So
Did you write a
cool.
dissertation to get your PhD?
Yes.
What was the subject matter broadly of the dissertation that you drafted?
So my dissertation focused on a technology called smart glass. So you may have seen this technology where if you've seen a pane of glass that is transparent, somebody flips a switch and it goes opaque. That's a type of smart glass technology. So my PhD involved developing a new type of novel, what we coined optofluidic smart glass. So we are using geometric structures that we've optically designed to create a very reflective surface or medium, if you will. And then through the introduction of various fluids, we can then modulate the amount of visible light and electromagnetic energy that is passing through or being reflected. So not just visible light, but also energy that you can't see. As part of that process, I ended up prototyping these structures with a 3D printer that was capable of printing 3D printable polymers.
All right, I'm gonna be thirsty too. Just come on. The smart glass is so freaking cool. And he does the 3D printer stuff. I'm so annoyed. This guy is so cool. I want to have so many beers with him. I'm sitting there with my 3D printer in the back that's got 8 different spools and 29 million spools of film around me. I've got experiments that are actively ongoing. The nerd in me is so happy. So happy.
As we kind of got towards the end of my work, we looked at how we could scale this up on a larger scale. We ultimately ended up researching and doing tests with a material known as polymethyl methacrylate, which is PMMA or acrylic.
What relevance does PMMA play in terms of this case?
So with respect to this case, the outer lens and the clear plastic diffusers of the taillights on the Lexus are comprised entirely of polymethyl methacrylate, or that PMMA material.
The same material that was the subject of your dissertation?
Correct.
What additional training and experience do you have as it relates to accident reconstruction beyond your BS and your PhD?
So certainly the 8 years of work that I've had at ARCCA has certainly trained and taught me a lot over the last 8 years. Like I said, I've seen hundreds of collisions, all different types of accidents.
How many jurors had the same reaction that I did, where he's going through and he's saying, I did my dissertation on this, basically the use of acrylics. And this is my focus and my focal area of study. And it's like, well, what are we talking about today? A taillight. Well, what's a taillight made of? Acrylic. Just like, you're like, oh, okay, sure. I'm going to listen to this guy the whole time.
Accidents. But in addition to that, I've continued to take courses through Northwestern University in crash reconstruction, human factors and lighting, heavy vehicle forensics, heavy vehicle EDR downloads, Bosch data retrieval and black box downloads, photogrammetry, so a number of continuing education.
Are you accredited as a traffic accident reconstructionist?
Yes.
By whom?
An organization known as ACTAR.
Is that a nationally recognized organization?
Yes, sir.
What does that stand for, ACTAR?
The Accreditation Commission for Traffic Accident Reconstructionists.
Are you trained in photogrammetry?
Yes.
What is photogrammetry generally?
So photogrammetry is the science of extracting and measuring information in a photograph. So you don't actually have to physically inspect something to be able to get information about its measurements or where things are spatially. You can do that from a photograph alone.
Is that an accepted methodology in the field of accident reconstruction, to use photographs and or videos without actually having been at the scene during the course of the crash?
Absolutely. It's very common.
You mentioned Bosch. What is the Bosch crash data retrieval analysis? What is that generally?
So generally, most modern vehicles
Sandy, you mean your husband, the reconstructionist? Yeah, I
on the roadway now have what's called an airbag control module, or more commonly known as a black box, which can contain crash-specific data in a collision.
Are you a member of any professional societies?
Yes.
Can you describe those for us, please?
So I'm a member of the Society of Automotive Engineers, the National Association for Professional Accident Reconstruction Specialists, the Illuminating Engineering Society, and the Optical Society of America.
Is it fair to say that you've authored a number of peer-reviewed papers in the field of physics and or accident reconstruction?
Yes.
Can you describe that for us?
So my most recent publication in the field of accident reconstruction deals with vehicle control history records. Publications prior to that were focused primarily on my dissertation PhD work.
I think you testified that you have dealt with probably over 1,000 different types of cases Are you able to estimate of those 1,000 different types of cases dealing with accident reconstruction, how many of those or what percentage of those have involved pedestrians?
I don't know if I can give a percentage. I would certainly say it's the majority of my casework. As I mentioned earlier, given one of my specialties being in human factors and lighting, there's a direct correlation between time of day and pedestrian collisions. We certainly see a rise as sky illumination drops and the illumination levels go down. We're having to rely on artificial light sources. So given that occurrence happens in nighttime hours and low illumination, like I said, I certainly see many pedestrian accidents.
What types of pedestrian impacts have you been involved with in terms of your analysis or evaluations?
All different types, everything from pedestrians being...
Oh, hey there, Larry. I see him.
Run over, running into the side of vehicles, being hit by the front of a vehicle backing up in a parking lot into a pedestrian. So I've seen it from all sides of a vehicle.
What is kinematics? Can you describe that or explain that phrase or term?
I think a simple definition would just be the motion of an object or a body.
Have you done any testing as it relates to kinematics and the interaction between pedestrians and motor vehicles?
Yes.
How many times have you engaged in such an analysis?
Numerous times. We frequently and routinely do testing at ARCCA.
You mentioned ARCCA has several different disciplines within it. What are some of those different disciplines in addition to accident reconstruction?
So, as I mentioned, we have biomechanics and crashworthiness, and there's a few others. And I will note that it's very common in our casework that we will work together as a team. So to give you an example of that, I mentioned earlier about, that rear end collision, right? So let's just say we have a rear end crash and there's crush and there's damage to the rear of the vehicle and the seat back failed, which caused the driver to ramp up in the seat and ultimately hit their head on something and sustain an injury. So I myself, as a reconstructionist, will analyze the forces, the speeds, and the severity of the crash. The biomechanist will evaluate the mechanism for the injury based upon those crash forces. And the crashworthiness expert may analyze, okay, is there a better or stronger seat that may have held up in this crash?
Is it normal for you, as the director of accident reconstruction at ARCCA, to work with others in the other disciplines that are housed under the umbrella of ARCCA?
Absolutely, yes.
Is that a normal process for you?
Very common, yes.
As a matter of fact, it probably would be uncommon if you didn't do that, correct?
Depending on the kind of case, but yes, certainly wouldn't be uncommon.
Tell me about the testing that you've undertaken to determine forces that are at play in a given accident or an impact.
Okay. So to give you a simple example of it is, let's just say we have a sideswipe type collision where two vehicles sideswipe each other and a front bumper gets torn off or deflected essentially, and there's some deformation to it. Right? We can do testing at ARCCA to determine how much force does it take to bend that material so that we get the deformation that we have. That would be a good example.
Is there a specific type of testing, or is there varied types of testing that you've done and undertaken to determine the forces that would be, for instance, in your example, in that side, the forces at play in that sideswipe collision?
Yeah, absolutely. It would have been, again, as part of the test, we would be measuring the forces, we'd be measuring the displacement, we'd be able to calculate acceleration and things of that nature from that test data.
All right, I've seen the question enough, and before we get into the slew of objections, here's the thing. I understood. I was actually a little bit intrigued, and let me tell you what I'm talking about here. I saw some questions asking, where was it? Scroll. I wanted to start. I should have started. It's going by. The thing is, the chat's moving a little bit quick. A lot of people talking about, the court TV with the stupid camera wandering all over the place. Here we go. KLB. Any opinion on why Ajax is doing the direct versus Alessi? Jackson might just be the person he's more comfortable with, person he's communicated with in the past, person he has a rapport with. Jackson also was in the Air Force, and he actually worked on jet engines as a mechanic. So he has a fundamental understanding of forces and science of this degree. Alessi has kind of come in some cases, but I think it's just familiarity with the topic, and this is kind of an important witness. The other thing that people were making a comment about was the number of objections that were made. And I raise this now because we haven't gotten into the objections yet, but there was a whole lot of questions that Alan Jackson asked that were leading and slightly argumentative that could have brought on an objection that I think would have been sustained. For example, when he asked the question, in fact, wouldn't have been uncommon if you didn't do these things. That is leading and argumentative. That should have been objected to. Could have been objected to. It just didn't. It wasn't in that moment. So when Hank Brennan does object, it's important to focus when he does and what he's concerned about coming out in the response and why he's objecting when he does. Brennan has a habit of objecting way too much, I think. He can actually draw attention to things that I don't think he wants to draw attention to. He also gives the opportunity for the lawyer to rephrase the question or break it down a lot more and get the repeated answer over and over and over again. So I think some of them came back to bite him in the ass. But I wanted to bring this up here because there were probably about 12 different places where Hank Brennan could have objected and that objection would have been sustained in the lead up to this particular moment.
Tests that you undertake, are they generally accepted methodologies in the field of accident reconstruction?
Yes.
What are quasi-static tests?
So a quasi-static test would be like the example I just gave you, where we have basically the bumper would be stationary, right? And now we're pulling on it to determine how much force it takes to bend it. So that'd be an example of a quasi-static test.
So that test specifically is determining or attempting to determine the amount of force necessary to deform a bumper, for instance, in the way that it's seen after an impact.
Yes.
Or any other body panel, correct?
Like that was
Correct.
leading.
And on the human side, also there are forces at play, I'm assuming, in terms of injuries that are sustained by pedestrians in the accident reconstructions that you've done involving pedestrians.
Yes.
Do you have experience in evaluating whether damage to a vehicle is consistent with a proposed scenario or set of facts?
Yes.
Describe those circumstances for us. What are the circumstances in which you're trying to determine whether or not the damage fits a proposed scenario?
So a case that commonly comes across my desk is we have two very different versions of how an accident unfolded according to party A and party B, right? And we have a set of evidence in terms of the damage to the vehicles, maybe some roadway evidence, right? So we can look at that objective evidence, utilize physics, maybe some calculations, determine whose version is most consistent based upon the damage and the roadway evidence.
Is that an accepted methodology in the field of accident reconstruction?
Yes.
In other cases in which you've undertaken such an engagement to determine whether or not the physics or the physical evidence matches a particular scenario or is inconsistent with that scenario, have you been able to ultimately reach conclusions and opinions to a reasonable degree of scientific certainty in those cases?
Yes.
Is that normally what you're seeking, to ultimately come to an opinion or a conclusion about those scenarios or circumstances?
Yes.
Are your opinions and conclusions based on your education, your training, the background and experience that you've explained to the jurors?
Yes.
Is it also in furtherance of the scientific methodologies that you employ in order to come to those opinions and conclusions?
Yes.
And are those generally accepted in the scientific and accident reconstruction community as a proper methodology to come to opinions and conclusions of that nature?
Yes, sir.
Have you been qualified in other courts to testify in the area of accident reconstruction?
Yes.
Let's talk about how you began your work in this particular case. When you were initially retained in connection with this case, were you hired by the defense?
No.
Did you know who we were?
Sustained.
Your Honor,
I don't
may we
know that
approach-
one.
Yeah, you can ask it differently, Mr. Jackson.
Sure.
But how?
Were you hired by anybody affiliated with the defense?
No.
At that time, did you know any of the names of the defense?
No.
At the time that you were hired to or engaged in this case, did you even know the name Karen Reed?
Sustained.
Did you know any of the names or of any of the parties?
Why is that objection?
Sustained. I'll see it.
Sure.
I don't, this was the part I didn't understand. It's those questions. I think he was dodging around it enough that I don't know why those were objectionable. Of all the objections that were made, this was the one that I thought Alan Jackson was tiptoeing quite well. I mean, and you can hear how awkward the questions are. Like, you can very much hear how awkward the questions sound. Like, if I'm a juror sitting there in the jury box and I don't have any knowledge of who this person is or where they're coming from, I'm hearing the question phrased the way it is, and I'm going, why is he phrasing it this way? Why is he saying, did you even know the name of the person hiring you? I don't know if it's a foundation. I don't know what the base of the objection is on these ones. So they come back from sidebar.
Would you like me to just go in order from the materials reviewed?
That would be fine.
The Norfolk SPDU homicide death report, the Commonwealth of Massachusetts Department of State Police crime scene report, OCME dispatch removal report, photographs of the incident location, videos of the incident location, photographs of the 2021 Lexus LX 570, photographs of recovered evidence, crash data retrieval report from the 2021 Lexus LX 570, report of autopsy photographs, and there was a few other items there, but those were generated internally.
There were about 14 things that were listed in terms of categories of information that you were provided, or ARCCA was provided, is that right?
A little less than that, because some of those, like I said, were internally generated, but yes.
Why were you provided that data? What's the reason why it's important for you to get certain data as you begin your analysis?
Well, we wanted to have an understanding of, or ultimately the end.
See, what's funny is that question was objectionable, but there's no objection made there. Like, that question was speculative. Why were you provided the data by the entity that hired you, or when you were hired? But he's not objecting there.
Entity that retained us wanted to have an understanding of what, I guess, the evidence that we would need to reconstruct this.
Did you get enough information to engage in a fulsome analysis, an accident reconstruction, in terms of the initial request by the entity that hired you?
Yes, in terms of our scope, yes, we had sufficient information.
Were you able to review photographs of not only the Lexus involved, but John O'Keefe's body?
Yes.
Did you use those photographs in furtherance of your analysis?
Yes.
Did you use the reports detailing scenarios or possible scenarios in furtherance of your analysis?
From what I recall, I don't believe any of the reports indicated any type of theory or understanding of how the accident occurred.
Were you asked to determine whether or not certain scenarios could be possible?
I don't recall that.
How vague of a question is that? It was one, it's leading as hell. So this must have been, and I'm thinking in my head, this must have been as a result of the sidebar, where the judge is going to give him the ability to lead on certain respects, to avoid a certain topic, namely the FBI's involvement, how the FBI retained ARCCA. So in order for Alan Jackson to get around that and comply with the court's ruling about that, when he's got to be given a little bit of latitude to lead, because he can then kind of keep the jury away from, or keep the witness from accidentally answering a question the wrong way. So maybe that's why you're not hearing a lot of the objections, but there's a whole lot here that's a lot of leading. It's a lot of leading. But that's the only way I can think as to why the objections came when they did, and why the latitude was given here, where I think Alan Jackson does a whole lot of leading around here. How can it be leading and vague at the same time? You know what? That's a fair point. That's a fair point, music to my soul. That's a very good question. How can it be leading and vague at the same time? I don't know if that one was leading or just vague. Either way, it would be objectionable.
Giving us any scenarios to evaluate. They essentially left it in our hands. Here's the evidence. What do you think happened?
That was an open question, correct?
Correct.
All right.
That was,
did you engage
he
in
asked,
analysis?
Correct. That's leading.
That basically allowed you to think of any scenario?
I think that's fair, yes.
In your initial analysis, did you note damage to the vehicle?
Yes.
Describe the damage. Let's start with the vehicle. Describe the damage that you noted in furtherance of your analysis.
The primary damage was to the right rear taillight on the quarter panel section. The majority of the outer red lens was broken and shattered, as well as some of the underlying components and diffusers that are underneath that outer layer, as well as some damage to the back portion of the taillight.
Can I stop you right there? Describe when you say the outer lens material and some interior material as well was damaged. Describe that in detail for us.
So
This part I thought was
outer
im-
lens
this part I thought was
is
important.
red, and it's about 5 millimeters in thickness, and it basically encompasses the majority of that quarter panel taillight. And then there's a small segment that is clear that is for the turn
my
signal
calipers,
indicator,
I
which is yellow.
Hang on.
Underneath that 5 millimeter thick red lens, there are additional diffusers that run along the bottom. There's two rows of those, I believe, and then they also go up vertically on the side, and those are clear. And I think the thicknesses of those are about 3 millimeters.
Is 5 millimeters of PMMC, have I got that right? PMMA?
You'd call it acrylic. That's the more common name.
Easier for me. Is 5 millimeters of that acrylic, that outer lens material, is that considered thick or thin in terms of?
Well, let's see. Do I have dial calipers handy? Yes. Don't ask questions. 5 millimeters. Bro, that's thick. Damn. What does the chat want to see? Here we go. We can do this. Do I have dial calipers? Of course I have dial calipers. Why wouldn't I have dial calipers? 5 millimeters. Whoop. It's going to show in reverse because it's the camera. It's 5 millimeters. So there's my hand. That's thick. He says 1/8 inch. That's 1/4 inch. No, that's more than 1/4 inch because 11 mil is about 3/4 inch. So what is that? About 3/8? .197? Yeah. Yeah. That's 5.56 is 0.22. That's thick. Yeah, 0.22. That's thick for acrylic, by the way. Like, that is more dense than I thought it would be. No, don't do that. Do that.
Of just sort of what we'd see on a taillight.
I would describe that as a pretty thick piece of plastic. It's certainly by no means. You can't, if you had a segment of it and you try to bend it, it's not going to bend.
Okay. In addition to that outer taillight material, that acrylic, in terms of the information that you received, did the interior acrylic also have damage to it?
Yes, those clear diffusers that, again, there's 2 rows of those, and they also went up vertically. Those were shattered and broken as well.
Was that important to you in your ultimate analysis?
Yes.
Did you note any superficial scratches or dents anywhere on the tailgate area or the liftgate area?
Yes, there was a dent and some paint chips, if you will, above the liftgate taillight assembly. So again, that next to that quarter panel taillight, there's another assembly that is on the liftgate, and there was a small dent and some paint chips at that area. There was also on the wraparound section of the bumper cover, as it's going from the rear to the right side, there were some superficial scrapes in that area.
Did you note any other damage or deformation to the Lexus? Deformation in the the liftgate, the bumper, anything like that?
No.
Is it common in a vehicle-pedestrian collision that there is some sort of bumper deformation that's associated with a vehicle-pedestrian incident?
That can certainly occur if a pedestrian is in an normal upright position. You can certainly get displacement of the bumper.
Did you see any displacement or panel deformation on the Lexus?
No.
That's funny. I just caught that. I just caught a misleading question that Hank asked during cross-examination. Hank Brennan asked him a question during cross-examination saying, you testified and directed it was common to see deformation of the bumper. in direct testimony, but that's not what he testified to. Alan Jackson asked the question, is it common for you to see it? And Dr. Wolfe said in response, you can see that, yes. It wasn't really indicating that it was common. It was kind of acknowledging that, yeah, it can happen. I mean, for Brennan to pull that off, interesting. I wonder if any of the jurors remember that. Probably not. I caught it just now.
Is it more common that there's panel displacement or deformation if the collision is above, say, 10 or 15 miles an hour?
Yes.
Okay, so he does kind of answer it.
During your review of all the investigative materials, did you note any items of evidence that were recovered or claimed to have been recovered on the bumper itself?
I recall there were 2 or 3 apparent glass fragments.
What's the significance of that? Let me ask it differently. Is there any glass in the taillight assembly?
Can you repeat that question for me, Mr. Jackson?
The damn sirens in this courtroom. All right, let's go fast forward a little bit. Because he starts, Hank Brennan starts to object a little bit. Let me see here. Hank Brennan starts objecting to, where does he, starts to ask questions. Alan Jackson starts to ask questions about the opinions of other people, the opinions that were provided to you in the report, opinions of the third party. Starting to get in. I mean, that's kind of a question on speculation outside the scope. I can see how some of those objections might be sustained. But then we get to what I wanted to start talking about was the idea of the broken drinking glass. The drinking glass comes back. And I wanted to talk about that for a little bit because we get to talk about the cannon. So when he goes to his binder, I think. There we go. No, I was right here. 40, 50.
Your initial testing, the testing that you testified to about last year. When did you start that initial testing?
From what I recall, it would have been late 2023 into early 2024.
I want to talk about the drinking glass first. Did you become aware that there was a drinking glass that was found at the scene?
Yes.
And what was the testing that you sought to determine as it relates to the drinking glass and the taillight?
So looking at the evidence, as I mentioned earlier, when we're looking at that quarter panel taillight, we have an isolated region of damage. And looking at the additional evidence in terms of a broken drinking glass at the scene, we wanted to do testing to determine if a small object or projectile such as the drinking glass could induce damage that was consistent with that we saw on the subject Lexus.
Were you able to reach an opinion and or conclusion as it relates to whether or not there is a possibility that the drinking glass or a drinking glass could cause the type of damage that you saw on the Lexus?
Yes.
Given everything else in your investigation, are you concluding that the glass was responsible for the taillight damage?
No.
However, you did seek to determine whether it was possible, correct?
That's leading as hell. That's why that objection was sustained. But here's the thing. What you're seeing right now, this is the scientific method. Hi, welcome to the party. We've missed you the whole time. So ARCCA was given a theory, right? So they were given the opportunity and a request to say, hey, this is what they are saying occurred. So what did they do? They started to try and rule out every other possibility. So they were like, what other possibilities in the world of possibilities could possibly exist? Like, right. So we're being presented with this possible hypothetical, right? This is the hypothetical we've been given. This is our task. We're going to take that to heart. So in doing so, let's go ahead and, oh my God, I'm sorry. I just saw a chat by Creed and I'll get it to a second. But they're given a hypothesis. And what do they start doing? They start trying to poke holes in it. They kind of say, I'm going to go ahead and see if I can be caused by any other mechanism. What other mechanisms are available to cause that damage? Let's go ahead and test this shit out. right? So there's mechanisms that could be used to cause that type of damage on the vehicle. Let's rule out every other possibility other than a drinking glass or other than the body of John O'Keefe. It made sense. It just made sense. It's how it's supposed to be. And this was the comment. Creed M. I hate you. I mean, it's really funny. It's very well timed. Rob pulls out calipers, looks down at 5 millimeters. Damn, that's thick. You want to see? It's an all-time clip moment. The worst possible timing of any timing they could ever have been timed. Oh my God. Remember how I have said in the past about how certain things happen and you go back to reading a transcript of what you said in an argument in court and you want to bash your head against the wall time after time? That right there is a moment that in YouTube I will probably go back to and want to bash my head against the wall time after time because of saying that in that moment, because I was in nerd zone and didn't contemplate the practical ramifications of what I just said out loud while holding dial calipers and looking down. There's a recovery from this, right? Like that, we can bounce back. There's a bounce back from this world that I just entered. Oh my Lord. This is a problem. This is a problem. Well, here's what we're going to do. We're just going to move on like it never happened. That's what I'm doing. I'm sticking with it.
Sustained.
I'll ask it a different way, Your Honor. What testing did you undertake in furtherance of that specific, answering that specific question? Could the glass damage the taillight?
Right. So we designed a pressurized cannon that was capable of firing the drinking glass into the taillight at various speeds. We aimed for speeds of 30 and 40 miles an hour. Our achieved speeds were at 31 and 37 miles per hour. And we found that in the 37 mile an hour impact, and again, this is to emulate or simulate an individual throwing a drinking glass. The purpose of the cannon, if you will, was to be able to hone in on a speed precisely and obviously aim for that target. So it would just serve as a means of getting that projectile to the taillight in a means that we could measure it. And what we observed in the 37 mile an hour test is that we got damage that was generally consistent with that of the subject taillight, and that there was a large portion of the outer lens that was shattered and fractured, as well as the underlying clear plastic diffusers and chrome piece.
Tell me a little bit about the methodology that you undertook, the scientific methodology in building that pneumatic cannon and aiming that glass directly at the taillight.
Absolutely. So
Alan Jackson never asked the question that everyone wants to know. How big was the cannon? What did you shoot with it other than a taillight? Because I know for a fact you did not just throw drinking glasses like that. You built the damn cannon.
as I mentioned, it was a customized cannon, if you will. It had a barrel that was capable of fitting a rocks or an old-fashioned drinking glass in it. And that's a glass that has a thinner sidewall, if you will. I think the glass was about 3 inches in height or so, maybe 3.5 inches, with the bottom portion being solid glass or just a thick piece of glass. So we were able to design a kind of a holder for it, if you will. Almost, you could really think of it as stuffing an actual cannon with a cannonball. So we literally would put the drinking glass in the cannon. There was a pressurized vessel behind that we would open up a valve rapidly, and when it was set to a certain pressure, that would determine the exit velocity that it would leave the barrel at. And we were able to aim that device into the taillight at those specified speeds to be able to determine what would the damage pattern be when we fired that glass.
Were you able, in this scientific experiment, to control for aim and trajectory?
Yes.
Were you able to control for velocity or exit speed of the glass?
Yes.
Were you able to control for damage patterns as it pertained to both the glass as well as the taillight at which it was aimed?
I don't know that we have had control over that. Ultimately, physics takes over after that interaction.
Jackson, we shot it with a damn cannon. like you're asking me if I could control the damage that occurred. Sir, I built a cannon. I made sure the cannon could shoot the rocks glass at 31 to 37 miles an hour. I shot a rocks glass at an acrylic cover on a fucking taillight. You're telling me if I could control the pattern that happened when I hit it? No, it's a pneumatic cannon shooting a glass across a room at a taillight.
Occurs. I can't influence how that material is going to perform or how the glass will break, per se.
It's a poor question on my part. Were you able to, or did you undertake to memorialize the damage pattern that you saw on the taillight and the glass as the glass was projected into the taillight?
Yes.
All right. Did you do that through photographs,
Yes.
high-speed video,
Yes.
and all of that was memorialized in your report?
Correct.
Your Honor, may I approach?
Yes.
This is the most disappointing moment of the entire direct examination.
I'm handing you two photographs, or two 8.5 by 11 documents that contain two photographs each. Can you take a look at those two documents and tell me if you recognize those?
Yes.
Does one represent, you mentioned that one of the tests that you performed was at 37 miles an hour, correct?
Correct.
Did you mention the speed at which, or the velocity at which the other test was done?
If I didn't, it was 31 miles per hour.
All right, so 31 and 37. Do you see those two documents in front of you?
Yes.
Does one of them represent the 31 mile an hour test and the photographs associated with that?
And an extracted frame from the high speed, yes.
Okay, and does the other one represent the other test, the 37 mile an hour test?
Yes.
If we could take those one at a time. May I approach one more time? Okay.
I don't understand. I mean, well, because showing the video wouldn't be replicative of anything. It would make us very happy to see the video of a glass being shot out of a cannon at a taillight. We would love it. We would absolutely love it. But generally speaking, because they concluded that the glass didn't do it, they don't really need to show the glass being hurled at the taillight, and it would be appeasing to all of us. I really want to see the glass being shot at a taillight, but I don't get to see the glass being shot at a taillight. It's completely unfair. It's absolute bullshit that we don't get to see it. From our standpoint, I mean, the jury probably is, there's how many jurors in that jury box going, can we see the video? Hey, can we see the video? Judge, can we ask a question? Where's the video and why aren't we seeing it? Based on the age of the jurors, you know that there's at least one or two jurors in that jury box that's going, I want to see the video. Why don't I want to see the video? So mad. That was the upsetting part. That made me very mad. Ms. Meggs, I don't know what happened to the cannon. It should still be somewhere.
Be marked as next in order, one at a time. 31 mile an hour test. Handling to the corner with the court's permission.
So there's no objection?
The innuendo in y'all's comments is hilarious.
I'm sorry.
Number 13.
Yes, Alan Jackson was jealous of, everyone's jealous of Dr. Wolfe's job.
7 mile an hour test.
For the 214.
Court's permission, I'd like to exhibit 213. I'm sorry, present exhibit 213.
Okay.
Is this the photograph that was just marked as exhibit 213 that's in front of you?
Yes.
Can you explain to the jurors what they're looking at?
So on the left part, you are looking at a frame from the high-speed video just after the contact with the taillight. On the right, you're looking at the post-damage to the taillight after the glass had been fired into it.
So fucking cool. Sorry for the profanity this early in the stream. Tell me that's not pretty fucking cool. Like, we have a still image of the moment of impact when it hits the polycarbonate. Now, what's interesting about this is look at how the acrylic reacts, how it caves before it cracks. I think that part's kind of relevant when you think about how that acrylic would shatter. And then also look at the very clean breaks. Look at those nice clean lines of how it breaks along a fault line. You know, because there's a curve to the tail light, and it would break in a curved pattern because that's where the stresses would be felt.
And if we could look at the next exhibit with the course permission.
Okay.
And what are we looking at here?
Same thing on the left. Again, this is the 37-mile-an-hour test. The glass striking just in the area where the bottom of the turn signal indicator is, so right where it meets the red portion of the lens and the clear portion of the lens. That's about where the impact point was. You could see that a large portion of the outer red assembly, lens cover is missing and fractured. The clear portion of the part of the outer lens to the turn signal indicator is also fractured, as well as the underlying clear diffusers in that assembly.
Would your testing in both of these scenarios, the 31-mile-an-hour test and the 37-mile-an-hour test, represent an accepted methodology for controlling for aim, velocity, impact site, and those issues, if you will, as it relates to testing of this sort?
Yes, we were able to control those variables.
And is that an accepted methodology in the area or the field of accident reconstruction?
Absolutely, yes.
When you...
Did he just... I love the explanation. Is launching... Break it down to its logical conclusion. Is building an air cannon and shooting a glass out of an air cannon at an acrylic cover of a light, tail light, an acceptable method in the field of accident reconstruction to make a determination on whether that actually happened? It's like, oh yeah, of course it's an acceptable method. Like, this gets done all the time. Can we normalize air cannons? Also, note to self, do not launch glass at other human with air cannon at 37 miles an hour. That is a lot of damage. That's a lot of damage. Wow. And this is a good point, Melanie. Now this is the part of the question. So thank you for the very generous super chat. But this is the part of experiment or inquiry that ARCCA is in, where they're trying to disprove that this could have been a tail light. Or not tail light, disprove that this could have been a glass. So we're not really at a stage of the tail light got broken by an arm yet. It does break a little bit differently when they do the impact test with the arms. But it is a very good question. If the diffuser lights are broken, how do we see the tail light lit at 5:07 a.m. and on the tow truck, wouldn't the whole light stop functioning? At least portions of it, because we've seen that in other videos, where once the diffuser, because it's an LED, once it loses electricity or once it loses its connection, it goes out. It's not like it can continue to be lit. So this was very interesting to me. Cat in Virginia, I thought Wolfe said this was his testimony in the first trial, that it was not struck by a taillight, or the damage was caused by a taillight. I don't recall that specifically. I don't. I'm going to try. Nick makes a good point here. Nick Starrow, thank you. The state's case relies on proving reasonable doubt of the defense case. I will get there, Nick. Don't get ahead of me. I'll get there. When Hank Brennan starts doing cross-examination, I in my head, I was viewing Hank as the defense attorney and Alan Jackson as the prosecutor, because it very much felt like this trial that Hank was trying to poke reasonable doubt into this conclusion. So Nick goes on, not proving their own intentionally being vague and using hypotheticals as evidence. Then look at the difference. Look at the defense disproving them. This is a remarkable reversal of a lot of things. Very, very, very confusing.
Finished your testing. Were you able to make a determination as to whether or not either one of these velocities, the 31 mile an hour velocity or the 37 mile an hour velocity, were consistent with the damage that you saw on the subject Lexus, which is the 2021 Lexus belonging to Miss Reed?
Yes, from the 37 mile per hour test, we are getting damage that's generally consistent, and that I mentioned we have portions of the outer lens missing, the underlying diffuser. There was also some fracturing on the backside of the assembly. So again, we observed damage that was generally consistent with that of the subject taillight.
And that was the 31 or the 37?
The 37
The 37. What about the 31?
didn't have enough energy to create that damage.
So were you able to conclude, in your opinion, whether or not the velocity of that glass hitting the taillight would have to be somewhere in the vicinity of 37 miles an hour, well above 30 miles an hour?
Well above, and it certainly could have been above 40 miles per hour per se. I mean, we may have actually blown out more of the outer lens had the speed increased.
Did you have any information in the data or documents that you reviewed associated with this case, for instance, that John O'Keefe had a pneumatic cannon with him out there?
No.
Okay. So obviously, well, let me ask a different way.
Well, Alan's asking a different question. SLV, Rob, did you never build a tennis ball cannon with beer cans or a pop can? No, I built potato cannons. Absolutely. And we did the back chamber with the igniter from a grill, filled it with hairspray or whatever we wanted to, and then boom, boom. Yeah, no, I absolutely did that. That's why do you think the pneumatic cannon made me so happy? This is exactly what I did.
Based on this series of tests, were you concluding that the damage on the taillight conclusively was the product of...
I can fast forward a bit.
At some point subsequent to that initial discussion in February of 2025, did we have another discussion about the potential of retaining you?
Yes.
Tell me about that. When was that?
From what I recall, it was sometime in March, and we were trying to figure out...
Sustained. Next question, please.
Did I ask you if you were available to be retained by the defense?
Sustained.
May we approach?
Okay.
Did I ask you if you were available? I think that's getting to the federal investigation question, because the intimation would be, you can't ask that question with a proper foundation, because the proper foundation would require the evidence being presented to the jury that they could not retain, that they were not able to retain. I don't know. This line of questions, these objections became kind of confusing to me. And yes, it brings the general inquiry up, and I'm just going to glance through this because he does get through this kind of inartfully.
You're saying is that we were...
Hang on. Because he does come back from this sidebar, and I don't know if he moves on.
2025, were you hired by the defense?
There you go.
Yes.
Okay. Were you asked to do anything or to review anything from the Commonwealth and any of their experts in relation to testing that was undertaken by them regarding the Lexus and Mr. O'Keefe?
Yes.
What were you asked to do?
My understanding is that we were asked to review and evaluate the report and analysis conducted by Dr. Welcher.
Did you receive Dr. Welcher's reports?
Yes.
Did you receive his raw data?
Yes.
Did you receive his 140 plus page PowerPoint?
Yes.
And did you undertake a review of that, all of that data, in order to evaluate that data?
Yes.
What methodology did you undertake at that juncture before you began any testing? Just your review process. What methodology did you undertake in terms of your review of his evaluations and his opinions and conclusions?
Well, I think when reviewing his report and his analysis, I look to his opinions, and then I look to what's the basis and the foundation to those opinions, right? How did he ultimately arrive at those final conclusions? So I'm looking for the methodologies that he followed, what testing did he do, what type of experiments, what type of data analysis, ultimately to provide that opinion.
Ultimately, did you prepare a PowerPoint presentation in furtherance of memorializing your review and opinions and conclusions of his evaluation and testing?
Yes.
Did you bring that with you today?
Yes.
Do you have that with you on your computer, or are we
Load it up.
going to run the PowerPoint?
It's on this computer up here with me.
With the court's permission, could Dr. Wolfe present his PowerPoint presentation?
Okay.
Your Honor, I have a thumb drive that I believe represents the PowerPoint. Do we have this marked?
Yes, is this coming into evidence?
I'm agreeing it's demonstrable name, like evidence.
All right, so we'll mark it for
We can
identification.
mark it for identification for the time being and discuss it later. Thank you.
It ultimately comes in as evidence.
EB for identification.
May I proceed, Your Honor?
Yes.
Dr. Wolfe, do you see what's displayed or presented up on the TV screen?
Yes.
All right. Do you have with you, by the way, just a matter of housekeeping, something called a spotlight?
Yes.
Something that can do whatever spotlight that.
Yep.
Okay.
Yes.
I may ask you to employ that, or I may take it from you at some point as we're discussing this. Do you recognize what's on the screen?
Yes.
What is this?
This is my PowerPoint with just the first page, the title.
If we can move to the next slide, please. Describe what we're looking at in this slide.
This is from
Lacerations.
Dr. Welcher's, in which he's indicating in this slide that arm.
In conducting
There you go. Give me 1 second.
where some on this slide in your PowerPoint.
Yes.
You indicated that this slide indicates that the location and orientation of the lacerations on John O'Keefe's right forearm and arms are consistent with the geometry and orientation of the right rear taillight, correct?
Correct.
Are the injuries to John O'Keefe's arm lacerations?
That would be an opinion from my colleague, Dr. Rentra.
Have you ever heard the phrase abrasion?
Yes.
It's funny. So, style-wise, I will sometimes compare Alan Jackson to Hank Brennan. Is it a fair comparison? Not really. But if you take the tone out of it, if you take the dialogue out of it, Alan Jackson, the expert witness, just told the lawyer in response to a question. The lawyer says, "Are you familiar with a laceration and identifying a laceration in a pattern?" Right? So he says, "Are you familiar with this?" Expert on the stand says, "That's not my area of expertise." What does Alan Jackson do? What does he do?
In your opinion, are the injuries to John O'Keefe's right arm better described as lacerations or abrasions?
Immediately
have an
comes
opinion
back
on
and asks it again. Immediately tries to go back and ask it again.
Slide number 2, please.
It just says, "I'm not a
Based on your
doctor.
review
I don't know
of
what to
Dr.
do."
Welcher's reports and his data, what testing did Dr. Welcher undertake or conduct?
So he did, initially, it appeared that he did a static test, if you will, just demonstrating holding his right arm out adjacent to the rear taillights on the right side of an exemplar Lexus to demonstrate his theory of how the arm contacted the taillight.
What is a static test?
So I'm sustaining that. Ask it differently, Mr. Jackson. And I'm going to strike that.
It's a stupid move to strike. He objected because there wasn't a foundation to get into the static test without him laying the foundation a little bit more. It was a requirement for additional foundation before saying, what is a static test? Jackson gets it in 2 more freaking questions.
What testing did you note that Dr. Welcher did with regard
There
to
you go.
this particular photograph?
I
What is a
noted that he
static
did
test?
static testing.
Well, in a static test, that neither the arm or
That's what I
the
mean.
vehicle
It's
is moving. It's just he's aligning his right arm adjacent to show how his arm aligns to the geometry and the dimensions of the Lexus.
Did Dr. Welcher appear to be wearing similar clothing as John O'Keefe was wearing?
Let me give you the objection, why the objection was stupid. Here's why the objection was stupid, because it took 1 more question or rephrasing the question in order to get it in. The objection was stupid because Alan Jackson jumped ahead of the necessary foundation. Does he get to ask the question of what the static test is if we don't already know that a static test was done? You can't ask for a definition before you know that you need the definition. Does that make sense? You have to lay the foundation to establish that we need to know the definition of a static test. That's why it's a stupid objection. Let him answer the question. I don't understand that part. it was a proper ruling on the objection because Jackson just jumps ahead and says, what's a static test, without any foundation that that's what Dr. Welcher did. That's the point. So there are certain rulings that Judge Cannoni did today that I thought were wrong, very wrong. There's certain rulings I was confused about. Then there were certain questions that I was like, okay, I get it, but why? Why make them go through the hurdle of the next question?
On January 29th, 2022.
Yes.
Was there any significance or purpose for that, in your opinion?
In this test, no.
Did you identify any limitations with regard to this
I love
sort
that.
of testing undertaken by
Was there a
Dr.
purpose
Welcher?
to him standing there and taking a picture of this? No.
Well, it's very basic in that the only thing that this demonstrates is that you can get your right arm to align with the taillight. Beyond that, it doesn't tell you
Thank
anything
you.
with respect to what happens to the arm when it makes contact with the taillight, right? What's the motion of the arm? What's the damage to the taillight? What's the acceleration of the arm? What's the forces of the arm? So it doesn't answer any of those other questions. The only question it answers is, does the arm align with the taillight?
And if I'm speaking candidly, if I'm a juror sitting in the jury box and looking at him hold that drinking glass the way he's holding it, it looks awkward as hell. It looks awkward. Who's sitting there holding their drinking glass like that? Holding it like slightly elevated at a perfect 90-degree angle with their shoulders upright and back when they've been drinking? I don't. The static test looks stupid because it explains to me how dumb some of this theory sounds.
You're aware that John O'Keefe was 6'1", correct?
Correct.
Is the only person, let me ask it a different way. Can only a 6'1" person align their arm with the taillight?
Thank you. This
No,
was
it's-
stupid.
The arm is adjustable, so certainly people of different heights could also meet that alignment as well.
Just by
And thank you, Dr. Wolfe, for delivering that answer with the exact amount of laughing and joking that I viewed it to. Like, Wolfe looks over at the jury, he's like, no, you can raise and lower your arm. That's why we have a fucking arm that raises and lowers and moves in different positions.
right?
Sustain.
How
As
would
leading.
you describe the ability of somebody 5'7" or 6'3" being able to align their arm with the taillight?
Just changing the orientation and the posture of your arm.
Was there any scientific significance, in your opinion, of this particular test?
Again, other than just demonstrating that it aligns with it, no, nothing beyond that.
Next slide, please. What are we looking at here?
So this is an extracted frame from one of his dynamic tests in which the vehicle is moving at about 2 miles per hour into his arm, making contact with his hand, his forearm, and his elbow.
What is a dynamic test as it relates to a static test?
Did you notice how Wolfe learned from the first time? Did you pick up on it? What does this slide depict? This depicts Dr. Welcher engaging in a dynamic test. Then Jackson gets to ask the question, what is that dynamic test? Just like that. Witnesses learn. They do good.
So that's when something's in motion, and in this instance, it's the Lexus moving at about 2 miles per hour into his arm.
Did Dr. Welcher explain what the purpose of this test was?
Thank you.
From what I recall, I think it was to demonstrate that when his arm makes contact with the taillight, he observed paint transfer in the general location that there were the abrasions or the lacerations on his arm.
Did he appear to paint the taillight?
He did, yes.
Do you see that Dr. Welcher appears to be wearing an orange t-shirt?
Yeah.
Sustain.
What is
There's no relevance to it. I get it. Like, one is leading. It's completely leading. Like, is he wearing an orange t-shirt? Yeah, he's wearing a fucking orange t-shirt. Jessica, the Transmetal Alchemist. Your Honor, I would like the court to take judicial notice of the fact that humans possess shoulders and elbows. In this courtroom, denied. Wolfe almost laughs when he says, what's he doing here?
he wearing?
It appears to be an orange t-shirt.
Is that similar to what was described as John O'Keefe having worn that night on January 29th, 2022?
Yes.
Is there any significance to wearing that T-shirt?
Not that I can think of, no.
Did you note any or identify any shortcomings with this particular test?
Well, okay.
Much
The
like
objection was done.
the static test, again, it leaves the door open to all those questions, right? About, again, doing this at 2 miles an hour doesn't tell you anything about, well, what happens at 10?
I stand corrected. He asked about the static test first. Then I think that Judge Kennedy just missed the purpose of the objection. I don't know. Jackson got there, so I don't really know what the objection was.
What happens at 15? What happens at 20, right? In terms of what are the collision forces? What's the damage? How does the arm move? What would the expected injuries be, right? This dynamic test, as well as the static test, doesn't answer any of those questions for us.
Thank you. Thank you.
Is this test from Dr. Welcher considered a force calculation?
I'm not aware of him making any type of force calculations or measuring accelerations or anything of that nature, no.
Did Dr. Welcher conduct any testing to determine whether the damage to Miss Reed's Lexus was consistent with the striking of an arm of a pedestrian?
I'm not aware of any impact testing that he did, no.
Did Dr. Welcher conduct any testing to determine the forces necessary to cause the damage to the taillight of Miss Reed's vehicle?
Not that I'm aware of, no.
Did Dr. Welcher conduct any testing to determine the forces necessary to cause the injuries to John O'Keefe's arm?
No, not that I'm aware of.
Did Dr. Welcher provide any opinions as it relates to the speed of the subject Lexus at the time of the alleged incident?
No, from reviewing his report and his PowerPoint and analysis, I could not find anywhere in it a specified speed or even a range of speeds.
Did Dr. Welcher provide any opinion as it relates to the forces experienced by the taillight in such an impact?
Not that I'm aware of, no.
Did Dr. Welcher provide any opinion at all as it relates to the post-impact trajectory or movement, if you will, of John O'Keefe's mass or his body subsequent to the alleged conduct?
No.
No, not that I'm aware of.
Next slide, please.
The nice thing is, hopefully, just by those questions and those responses, it gives the jury a pretty clear understanding of, hey, these are the things that we expect of you. Like, if you are going to come in here and offer an expert opinion that certain injuries were sustained by a vehicle going in reverse at a certain mile per hour and that it was caused by the taillight, then we would expect you to do certain things to substantiate that, other than, paint the back of a taillight and say, hey, at 1.5 miles an hour, when it hits me in my arm, I don't sustain injuries. And look, there's paint transfer. It highlights that for me. At least it did. I'm sitting here listening to this and going, well, hopefully the jury is getting the same impression that I am, because holy shit. The difference.
This is something that you probably have heard and certainly I've discussed already, but this is looking at the right rear corner of the subject Lexus, specifically in the area of the damaged right taillight.
Did you consider this?
And the question, so maybe the chat can help clear this up for me. My recollection was that there were certain photos of the damage that were shown after the Commonwealth acknowledged that they had removed certain pieces. But was this photo, this one right here, remind me, chat, please. Is this photo, the one here, the one that the Commonwealth produced and said that this was the state of the taillight when we received it from Karen Reed? Like, this is where it looked like, this is what it looked like in the Sally Port when we finally got it thawed out. I think this is what they said it is. And I'm looking at that damage. Okay, chat's saying yes. So this is the Sally Port photo. Line that up to the damage that the glass did, going 37 miles an hour. Wow, look at that. All right, Mama Betts. Mama Betts, I'm telling you something now because I don't want to lose context, because God knows if I lose context in making this comment. Mama Betts says, what? Oiling up, rubbing against it, and spreading as low doesn't cut it? No, not for an expert, Dr. Welcher. Shame. For shame. Oh, this is the CSI tech that came through the solo cups. Okay. Found the hair. Yeah. All right. So this is what I'm supposed to see, or this is what the damage is supposed to be. No other damage to it. Okay.
Photograph and coming to your opinions and conclusions.
Yes.
What, if anything, of significance did you note about this taillight other than the fact that it's damaged?
Well, I'm going to jump to the next slide, if you will. So this is now the taillight obviously has been removed from the vehicle. So obviously what's important here is looking at what is the damage that we have to this taillight. What components were damaged in this alleged interaction. So we're looking at the clear diffuser at the bottom is fractured and missing. Same with the ones on the vertical side. The majority of the outer red lens is also missing and fractured. And then on the back side, we also have some damage in terms of some fracturing to that black plastic. And there's also a chunk of plastic missing on the top portion of the taillight as well.
I want to ask you a couple of questions about that diffuser. If you could focus your attention on this area. Describe for the jurors what they're looking at in terms of the diffuser. What is the diffuser?
Right, let me see if this. So the diffuser.
How many of y'all love the spotlight? Because he pulled this thing out and I was like, where the fuck has this been the whole trial? Because this makes life a whole lot easier. It's like, here, draw your attention to this shining light on the photo.
There's right where my mouse is, there's a clear diffuser that runs along the bottom, and then there's another diffuser that runs along here, and then it also goes up vertically. Same here on the bottom one, that also goes up vertically. So this piece was missing and fractured on the bottom, along with the vertical portion. The chrome piece here you can see is also fractured and damaged. And then the kind of the second tier, if you will, that clear diffuser was also fractured and broken on the upper section as well.
Was that of significance to you in your review of the damage to the taillight?
Yes.
Why?
Well, because that tells me that we have to have enough force and energy to break, we talked about earlier that 5mm thick red outer lens. We have to have enough force to be able to get beyond that to now start penetrating into the interior components of the taillight to get to, again, those clear diffusers and certainly cause damage to get induced out the back end of the taillight as well.
He said every possible innuendo in that sentence, didn't he? He just... every single one. And we're not going to repeat it.
May I have just a moment?
Yeah.
We're not going to repeat it.
Dr. Wolfe, did you bring with you an undamaged taillight exemplar?
Yes. It's up here with me.
It's up there. Oh, I was just looking for it.
Yep.
Thanks for nothing. Describe what it is that you brought with you.
So I brought a two-part assembly. So what I did is I 3D printed a bracket so that I could mount the lift gate taillight assembly as well as the quarter panel taillight assembly.
And these are undamaged in sort of manufacturing specs, correct?
Correct, yes.
May I have just a moment, Your Honor?
Okay.
You brought an actual taillight and you 3D printed the bracket. Sir? Yes.
If you could remain standing for just a quick second. Do you recognize what that is?
Yes.
Is that what you just described?
Correct, yes.
Describe it one more time for the court and the jury. What is it that we're looking at right here?
So this is an exemplar set of...
Mr. Jackson, I can answer. I can answer for the class. It's a taillight. It's a taillight. I think he asked him to fully describe what he just made and built. And it's like, hey, this is the thing you built, right? Hey, do you want to describe what it is?
Of taillights from a 2021 Lexus LX 570. On my left side here, this is the lift gate taillight assembly, and it's attached to the quarter panel taillight assembly. And I will know it's not normally like that. Obviously, you can't have a connector, else you wouldn't be able to open the lift gate.
I had this question too.
Printed a bracket back.
this is a very relevant question. How many of these taillights did they buy for this case? I have no clue, but they broke a lot of them.
Back here so that these can remain as one unit.
Your Honor, with the court's permission, I'd like to have that marked as next in order.
Is that coming into evidence?
Yes, if possible.
Is that okay?
Okay.
Okay. So how?
May I approach?
Yeah.
Hank Brennan saying no objection. I think there might have been a valid basis for the objection there. I don't know. If I'm Hank Brennan, I'm objecting to that. I'm not letting that go back to the jury room. I'm not letting them play with that tail light. Because I think that a lot of people are going to reach. Has anyone else in the chat ever changed the tail light? You know, gotten into a collision and, you know, maybe needed to fix something on your own or tried to. If they are sitting there and they have the opportunity to mess around with that tail light, I don't know that that's what they want, because they're going to hold that up to the camera or to the picture. They're going to hold up the picture and they're going to look at it and they're going to say, huh, how did that damage occur?
This might be clunky.
Yeah. Yes. Wait, where was it? Where was it? I want this question. This is the question I want. I can't wait for the jury question. Yes. Yes. Kylie, phenomenal. If I'm the jury and you give me the opportunity to have that back, the first question I am asking the judge, can I try to break this thing? And like, you can't do your own independent research. Okay, judge, but we're in the jury room and no one's watching us. Like, what if we do a drop test? You can't do your own independent research. Hypothetically, if we dropped it and it broke, would you be mad with us? Like, would you be upset if we called the bailiff and we were like, hey, so the taillight you gave us, it's broken? I'm sorry, I have no idea how it happened. That would be 100% my question. Can I break the thing, please?
Thank you. If we just have the tag, perhaps put somewhere on the maybe the lift gate side.
And is Dr. Wolfe going to use it for his testimony now?
He is.
Okay,
Very
so
briefly.
give it back over there, please, Chrissy. Just give it to him. Thank you.
It's at 250.
Thank you.
Why does the court reporter look so angry all the time?
Ma'am.
Okay.
Thank you. Dr. Wolfe, you indicated that there was a 5mm area of acrylic covering the diffusers, correct?
Correct.
What I'm knocking on, is that the 5mm acrylic?
Yes, both on the quarter panel part that you just pointed to, as well as the lift gate part.
Mr.
Those are-
Jackson, why don't we give that back to the witness and let him do?
It's proper. Let's let the witness explain it. But Jackson wanted that in his hand because he wanted the jury to hear the sound of it. He wanted to actually knock it. Like, he actually wanted to do that.
Instead of you.
Sure. Is there... Can you see through that loose material into the diffuser that you've just been describing?
Yes, so as I mentioned earlier, in this area here, there's a diffuser that's running along the bottom.
So, Dr. Wolfe, I'm going to ask you to not have that so close to
Oh,
the court reporter.
my apologies.
You know what? That's a fair statement. It was right up next to her head. Judge Cannoni's like, can we avoid a workman's comp claim, please? Like, just keep the thing that could do the injury away from the person. Like, we already had a taillight in his case already.
The other side of the witness stand.
Yes, Your Honor. So along the bottom is the clear diffuser that runs along and then goes up vertically. And then on the second tier, there's also a clear diffuser that runs along here and then goes up vertically. And you might be able to see it through, it kind of looks like there's little dots on it. So that's what I'm referring to in terms of the diffuser that's underneath. And that, again, so you have that outer material that's 5mm roughly in thickness. And then those diffusers are about 3mm in thickness underneath this.
Could you make a determination, and you can go ahead and have a seat. Well, actually, you may not want to. Could you make a determination of the space, the gap between the outer plasticine area, the outer acrylic area, and the internal diffusers? If you could just estimate that gap.
If I had to estimate, I'd probably estimate around an inch, maybe inch and a half.
Okay. You indicated that something was of significance to you in this photograph about the diffusers on the subject taillight, correct?
Correct.
Describe, now that you're holding that, what was it that was of note to you, Dr. Wolfe?
So as I mentioned, we have damage not only to this outer thick portion, but it was enough force and energy to then penetrate deep enough to fracture the underlying diffusers that sit below this outer surface, and certainly enough force then to work its way back through inducement into the backside, and ultimately there was a top portion of the taillight that was also fractured up here.
Was all that significant to you?
Do y'all see how this testimony right here stands in pretty damn stark contrast to the, hey, I painted the taillight blue? Like, he actually is sitting there with an exemplar taillight and pointing out to the jury, where was the taillight damaged? This makes so much more sense. I was watching this and saying, thank you. Finally.
And your review of the subject taillight material.
Yes.
Okay, you can go ahead and put that away.
But I want to play with the
So
taillight.
that can't go back there because it's in evidence. So why don't you take it?
Yeah.
And
I was just
Hang on. Was that? Hang on. There's a little bit of a joke there that I'm going to make. You mean like the shoe that was the wrong shoe, that was out of the wrong bag, that was sitting back behind the witness stand, that was supposed to be the shoe that was already in evidence? The panic mode right there of, nope, we learned that already. Nope, that goes somewhere else. Not here. We're going to go give that way. That way. Over there. The wrong shoe. That can't go back there. That's in evidence now. Well, I mean, to be fair, I don't think that Dr. Wolfe is going to bring up another exemplar taillight. I don't know. I might be wrong. Maybe we'll get one in redirect. I don't know.
going to store it there until he's finished with his testimony, and then we can give it to the clerk magistrate.
Okay.
However you want to do it, Your Honor.
Right.
I have
Do
no
you wanna take
preference.
it? Is he using it still for his testimony?
Not right now.
All right. So
The concern. It's just, can we not put it back there where we had the whoopsie?
May I continue?
yes.
Can we go to the next slide? What are we looking at here?
This is a collection of photographs that depict various fragments from the right rear tail lamp assembly of the Lexus. And I will note that, and I'll try to spotlight it, there are a few fragments in this photograph that are glass fragments, which, as I discussed earlier, there's no glass in the taillight, so these did not originate from the assembly. But altogether, from what I recall, there's about 50 fragments, I believe, that were counted or so, maybe a little less than that from the right taillight.
If we could go to the next slide, please. What are we looking at here?
So these are photographs depicting the sweatshirt or hoodie that Mr. John O'Keefe was wearing on the night of the alleged incident.
And what was the role that this played in your analysis ultimately?
Well, so one of the things that I noted, and I can go to the next slide, is there were a series of small punctures or holes in the sleeve, on the right sleeve of the sweatshirt in varying sizes. I think some as small as just a few millimeters. Again, I think there was maybe 10 or 12, I think I recall, on the right sleeve of that sweatshirt.
If we could go back to the larger photo, the previous slide, do you see the right sleeve denoted on the photograph to the right?
Yes.
Your review of these photographs, what was the significance of the triangular sort of arrows or markers?
Point to the
I believe
holes in the
those were
sweatshirt.
to annotate or draw attention to those holes.
Okay, the defects in the right sleeve?
Correct.
Can you count those for us, please?
On the photograph on the right, I believe I see a total of 9.
And what about the photograph on the left, just the right sleeve area?
9 as well.
If we can go to the next slide. What are the arrows pointing to in these photographs?
So this is basically the previous shot, but what appears to be close-ups of some of those evidence markers.
You indicated some of the sizes. What were some of the smaller sizes of those defects or holes?
From what I recall, like I said, I think it was around 3 to 5 millimeters, maybe some of the smaller ones.
How big is 3 millimeters in inches?
It'd be probably around like an eighth of an inch or so.
Can we go to the next slide, please? What are you describing when you say the word fundamental, or you write the word fundamentals?
So I want to discuss some very basic concepts that I hope will kind of resonate.
He goes to Newton's laws. Yes, he actually goes to Newton's laws. He starts with fundamental principles and he works his way from fundamental principles going forward. Absolutely after my own heart. I absolutely love it. I don't want to go through all of it because we don't have the time to go through all of it, but he goes through the calculations, how the calculations get done, the fundamental equations, the delta V, the acceleration, the force, how and what those mean. All of those things he walks through. He gives an actual damn physics class to the jury. This is exactly what an expert is supposed to do. They're supposed to say, hey, I'm not just going to give you conclusions. I'm going to try and teach you. I'm going to try and explain to you why these things are important. And in order to do that, I need you to understand some pretty fundamental principles. Like, you have to understand basic concepts before you can actually comprehend that my conclusion means anything. You can't just sit there and stand up and say, I held my arm out and this was consistent with the strike, and based on my years in practice and all of the above. Like, the only math that Welcher put up on the screen was math that was done by Shannon Burgess, and it was math that had to do with the calculation and positioning of the vehicle. There was no understanding of, this was my biggest question. Oh, chat's going to get mad at me. Chat's going to get mad at me. All right. Okay, hang on. We'll go back and we're going to listen to some. We'll listen to his, you want his physics lesson? Fine. Here. We'll do the physics lesson. We'll do the physics lesson. We'll do the physics lesson. We will do the physics lesson after I get caught up on some of the chats. How about that? Okay, physics lesson chats first, real quick. Mostly harmless fuzzball, and just think aperture cost 5 to 5.5 times as much as ARCCA charged. Yeah, that's the other part we haven't gotten to. Best gun, losing detective, also says a lot of broken taillights at the bargain basement price of $50,000. Compared to $400,000, that's quite the substantial difference. Just wait, the best is yet to come from Mary Montagnani, my apologies. Just wait, the best is yet to come. It is, indeed. Judy M saying science does exist. I hope the jury believes it too. We're going to have to wait and see. I don't know. Greg, $10 says Welcher comes in on rebuttals, having still not done any real testing. This is part of my concern with what Alessi was trying to draw to the court's attention back when they were having the dispute over the order of presentation here. We'll get to that more during Hank's cross examination. Michael Oldham, imagine how much aperture charges for doing math. A lot more than they, $400,000, $400,000. You could have done equation. It's not the most hard thing in the world. Michigan Farm Boy, was Dr. Welcher properly inebriated to make his test accurate? He held that drinking glass rather straight angled. Indy Cindy, Hank is just downright rude in my honest opinion. I've seen a lot of attorneys that act like assholes that somehow get results out of juries that I will never understand. I don't understand how attorneys acting in that fashion connect to juries. I really don't. Julie, your mother's an engineer. Have you showed her these testimonies? I wonder what she thinks about all of this. She was a systems engineer. She wasn't really on the mechanical side. So I don't know that she would be the appropriate person to ask the question. My brother, however, my brother and brother-in-law and sister, I intend to kind of walk them through this and be like, how does this math? And they'll be like, it doesn't math. And I'm like, yeah, I thought so too. Randy is no dummy. $400,000 blue paint versus $50,000 blue hoodie. Brilliant. Brennan, how about sit down? It's interesting. Creed M with another fire comment. I apologize. I will use Dr. Welch's method to spread out my physics principle load. Chats scientifically in the future. Very sciencey. All the science. Bailey, watching the videos they showed how long it took the vehicle to come to a stop. That front yard is not that big. I could not agree more. I wanted to answer this one. Dragon Nerd, random question. I really want to cordless nail gun, but I can't. I can only afford one. Should I get a brad nailer or a finish nailer? It depends on what you want to do. It very much. I can do a lot with a brad nailer. I have both. So my first nailer was a finish nailer, and I ended up using that a lot less than the brad nailer. So the brad nailer would be my go-to choice because I can use that for more practical applications. Because usually I'm putting smaller pieces together, and the finish nailer, generally speaking, is a higher gauge nail or lower gauge nail. It's a lot thicker. It's a thicker nail, guys. Just leave it be where it is. Let's see. I have been waiting all week to hear your comments on Hank Brennan asking Dr. Russell if she had men problems and never grow up. I don't know if he didn't do any damage on Dr. Russell. That's why I'm not focused there, because I don't think that there's a lot of damage there. I don't think he ever really undermined the opinion that the injuries weren't consistent with a vehicle strike. Judy M, thanks for becoming a member. Mildred Katie, video of the cannon in action or the blueprints. The blueprints would be preferred. To be honest, I would love the blueprints. Katie Healing, asking the dog why she's so stupid. Paused. Wonder the same thing about the Commonwealth experts. It can happen. Mod Princess 916. When I was in 9th grade, a senior boy built a real life trebuchet. Oh, that's cool. They had a blast with it and did all the tests. And I do mean all. Sparkle for it. That's same. That's fun. Edward Kirkpatrick, they stopped Alan Jackson from asking hired insurance, which was the jury theory from last time. We'll get to this. Then Brennan gets up and tries to make it nefarious that it wasn't asked. And then Alan Jackson gets up and redirect and gets to ask a question he wasn't allowed to ask. It's pretty good. Greg, Dr. Wolfe was just about to show what happens when the assembly hits a human head. What's the big deal? We're going to get there. We will. Zess Alex, you always tell us to go do something. Tomorrow I'm helping host a walk or roll to raise money for CRPS, which I've had since I was 9 years old. Thank you for the inspiration. Zess Alex, I probably pronouncing that terribly, and I apologize for doing so, but congratulations on getting out there and doing something. And hopefully it makes you feel remarkably, and like you're contributing. And I feel for you in the struggle with CRPS. For those that are struggling with that, I cannot imagine what a chronic pain syndrome like that is. So I am very proud of you for getting out and doing something, especially something like that has such a great benefit. Heather, doesn't this hurt their case? Saying it needs a lot of force to break the light means that Karen couldn't have damaged it backing into John's car. They are positing that what might have been the original fracture that people are testifying to. Like the people are saying that, look, there was a crack, right? But it wasn't that. It was cracked based on the contact with the vehicle. But it did not have nearly enough force to get what you see in the photo. Happy Sunshine. Rob, do you think that Judge Girardi would have made the decision as the same decisions as Judge Cannoni? For example, in motions, objections, size, and side comments. Side comments and size, I can tell you pretty emphatically, Judge Girardi doesn't do that. I'm not going to try and interpose what I think her opinion might be on several of these motions. I will say that she does give thorough and ample room to both sides to argue their respective positions. I'm not a big fan of how Judge Cannoni rules on a lot of this stuff. Sandy's reminding everyone, don't forget to hit the like button. Please hit the like button, guys. 3,166 of you here. Please do so. Wait, what? I'm so curious as to why the FBI got involved in investigating this in the first place. We all are. Every one of us are. The Aurora H. White, Hank tries to copy Jackson and Alessi without having the gotcha receipts that they do. At this point, I hope the jury sees the difference. I don't know, because there's a lot of questions that Hank Brennan asks that are fundamentally flawed in their premise. And I don't know that the witness does a really good job of fighting it the same way. I guess we'll just have to see. We'll have to wait and find out. Josh H. Brennan forgets who has the burden of proof. Yes, he does. In all his cross-examinations, I'm wondering if the tail light bushes a dog to grass rash caused the hoodie holes. We'll get to that. Bus stop person number 27. Thank you for the super chat. JZ. If I had Bev behind me, Lolly and Hank in front of me every day while having to talk into a vacuum, I'd look much worse. All things considered, court reporter looks like a ray of sunshine. Fair. That's a fair comment. NJ Nancy, you've been a sub since before you had a channel name. Thank you. Very kind of you. Let's see. CSI can't. The mic is smarter because he is breathing on it. It's pretty bad. Nancy, I'm bringing this up now. We'll get to it later. Nancy, Drewby. Rob, what do you think when Brennan brought up Wolfe's wife? It wasn't cool, and I don't think it scores any freaking points. I think it pissed people off, to be honest. Henhouse Bath Company, off topic for a minute, had my 18-month follow-up with the oncologist. I'm at 18 months cancer-free. Fuck cancer. Fuck cancer in the horse you rode in on. For those of you who don't know, I lost my dad to cancer, so there is a very, very large banner that I hold to heart, and it's fuck cancer in the horse you rode in on, or he, whomever. Henhouse Bath Company, congratulations. 18 months cancer-free is quite a remarkable feat. And hopefully there's 18, 24, 36, 48, all the numbers beyond that you continue to live cancer-free. Wonderful. That is wonderful, wonderful news. Okay, shall we get back to the testing?
Underlying physics and what I'm talking about.
Rather, the physics explanation. I'm going to do it 1.25, folks. So we're going to a speed lesson in physics.
Can you go ahead and describe the role of an accident reconstructionist and the fundamentals that an accident reconstructionist undertakes when performing
You too,
the
Jake
kind of
644,
testing
congrats.
that you performed?
So as I mentioned earlier, when I was describing what a simple definition of accident reconstruction is, it's the application of physics and engineering to collision events. So this is, I want to go through some very basic elements of that so that you have an understanding of the physics.
Can we go to the next slide, please? What are we looking at here?
So this might be something you all remember back from high school physics, but even though it's been around since the late 1600s, it's
One, given the age of the jurors, I'm not sure what they taught in high school physics. Two, that is presuming a lot that I remember anything from high school physics. Three, why don't you give a refresher course?
we still use these laws today. So what we're looking at here is what I've done is just describe Newton's laws very simply. So, and again, you might be familiar with these. So for instance, if we're talking about Newton's first law, an object at rest tends to stay at rest and at a constant speed unless it's acted on by an outside force, right? So if my arm is just here, right, it's just going to stay there until I give it a push or a pull, right? When I do that, that's going to induce an acceleration, right? So that's when we get into Newton's law, where if I apply a force to a mass, I'm going to cause it to change its speed. It's going to accelerate. And then Newton's third law, basically the law of reaction, indicates that when I push on my arm, there's also an equal and opposite force going back to my hand that I'm pushing with.
What role did these three very fundamental laws of physics play in your reconstruction or your ultimate opinions and conclusions following your accident reconstruction in this case?
So when we're talking about the concept of acceleration, what you will see in the dynamic test that we did and conducted, we measured the acceleration of an arm when it's impacted by a taillight. If we know the mass of the arm and we've measured the acceleration, we can use Newton's second law, which is force is equal to mass times the acceleration, to calculate what that force is applied on the arm, which ultimately you will hear from my colleague, Dr. Rentschler, to talk about that.
Is that broadly considered a force analysis?
Yes.
What role did force analysis, your force analysis, play in the accident reconstruction that you did or you undertook in this case?
Well, there's certainly going to be a correlation between the impact speed and the damage that we see. The higher the impact speed, the greater the force. So from my perspective, I was interested in the speed and the force to look at what's the observed damage to the test taillights that we did.
Do you think that's fundamental to an accident reconstruction?
Yes.
Did Dr. Welcher engage in any force analysis with regard to John O'Keefe's arm and the taillight?
Not that I'm aware of, no.
Let's move to the next slide, please. What are we looking at here?
So don't be too afraid. This is some really simple equations that I want to show you. So that first one, delta V. So what do I mean by that? That simply just means you can think of delta, change in. So change in velocity. So if you look at that equation, the change in velocity, really simple. If I've got an object that's, let's say it's initially, for what V naught is, initially at 0 miles per hour, I hit it, and it's now moving 10 miles per hour. That means it underwent a change in speed of 10 miles an hour and is moving at that velocity. Acceleration is essentially how quickly did that velocity change occur, right? Did it go from 10 miles an hour in a split second, or did it go to 10 miles an hour over a few seconds? So depending on the timing of that, how quickly that change in velocity occurred will determine what the acceleration is. And as I've already mentioned on the previous slide with Newton's second law, we can then take that information about acceleration and apply it to, if we have a known mass, to calculate what the force on that object is.
How did these math equations, delta V, acceleration, force, how did these play into, what role did they play in terms of the accident reconstruction here, in this case?
Well, they're extremely fundamental. And I think as we go through the PowerPoint, you will have an appreciation and understanding of what these concepts are. You'll see that I have plotted graphs with acceleration that shows the rate in that change in speed over time. You will see graphs of delta V, so the change in speed of the arm as it's being impacted by the taillight. And then ultimately we can calculate the force of that impact to be able to assess whether or not there's a mechanism for the injuries. And as I mentioned, that'll be my colleague, Dr. Rentschler, that will discuss that.
Can I ask you about delta V specifically? I'd like to focus on that for a second. Is that okay?
Yes.
When you say that that equation suggests or dictates that an object that is struck by another object with mass moves up to the same speed of the object that struck it, describe that in a little bit more detail in colloquial terms, if you will. Sixth grade terms.
I'm sorry, can you rephrase the question?
Probably not, because I don't understand this going to you. If an object, does delta V describe the circumstance in which you have an object that may be at rest and it's struck by another object moving? Is that calculating the speed at which the object that is struck moves to the same speed as the object that struck it? Okay.
So that's sustained.
Honey, Chad is wondering if there's a Leo intermission. Chad is wondering if Leo wants to make an intermission, or will that get him too riled up? Wants to make an appearance on camera, if that'll rile him up too much. You can send him down. Easy. Come here. Hop up. Come on. Nah, come here. Hop up. Oh, come here. Yes. Oh. Harold, can you say hi? Say hi to, no, don't, to my ears. Those are my ears. Yes. Okay. We're talking about physics. And we're learning about physics and how objects in motion stay in motion just like you. Oh, nope, not that ball. You can't have that ball. No, he can't. Go to mommy. Go upstairs. Go on, go upstairs. Go. Yeah. That is the chaos gremlin. So, Leo can demonstrate acceleration. He absolutely can. Yeah, he's a big boy. He's a big old baby. He treats for the good boy. He gets plenty of them. Absolutely. He very much does. Big boy. He's getting a treat right now. You can hear Mischief giving him a treat. There. That was for the chat based on the request of so many that needed a Leo intervention for a moment. Y'all hadn't seen him enough. So, figured that I would grant a certain request, motion for Leo intervention, having a rough day. Okay, now that request has been granted, we're going to go back to the physics lesson. Okay?
Just ask him a simple question, let him answer.
Easier said than done. Sure. Can you describe in more conversational terms what delta V is describing in terms of mathematics?
Right. So let's just give an example specific to this case. If the majority of the arm is struck by a 6,000-pound vehicle moving, let's say at 20 miles an hour, that arm will experience a change in speed. It'll go from 0 up to about 20 miles per hour due to that impact. So that would be the change in speed. If my arm is at rest, stationary, is impacted by a 6,000-pound vehicle, it's going to change its speed up to roughly what that impact speed is.
And what about acceleration? What are you describing, or what is math or physics describing in that equation in terms of the time it takes for that arm to now move from 0 to 20?
Right. So that's
Distributed load wins for the time being for this hour block. Can you ask Leo to bite your arm at 24 miles an hour so we can see what the injury looks like? No, but you get points for the humor.
That's how quickly that change in speed is occurring. So to give you maybe an example you're more familiar with, let's say you're driving down the road, you come up, you see a red light at the intersection, right? You're going to get on the brakes lightly, and your vehicle is going to change in speed, right? It's going to slowly decelerate. Let's say you're driving and a deer jumps out in front of you, you got to slam on the brakes, right? You're going to change your speed much quicker. So that's an example of two different rates of acceleration. One where you're mildly braking, right? You're going to coast down slowly, versus a sudden, emergency in front of you like a deer. You're going to slam on the brakes, and your speed change is going to be it's going to happen much quicker with that acceleration rate.
Are there
Leo, chill out. Go lay down. I'm hollering up the stairs at the dog. This was the concern I had. All right, we're going to ignore him. He's upset. He's upset because he can't come downstairs. Oh, no. This is going to be bad. Oh. Leo has so many opinions. So many opinions. Oh, okay. We're going to ignore him. We're going to try to ignore him.
Circumstances in which the acceleration can be from 0 to, say, 20 miles an hour in milliseconds?
Yes, when we're talking about impact durations, especially of this nature, yes, they're not going to be, we're not talking about the impact occurring over a second, 2 seconds. That's extremely long. Even a duration of a couple hundred milliseconds in the context of this is considered long.
And then, of course, the force calculation is associated with the delta V and the acceleration calculations. Is that right?
Correct, yes.
In what way? What are we looking at in terms of that a little bit more complex calculation?
Absolutely. So if you look at the bottom equation there, where I have force is equal to mass, and then that top component is the change in speed, right? That delta V, V1 minus V naught, divided by the change in time, T1 minus T naught. So if you substitute in that equation, right, that's delta V over delta T, which is acceleration. So there's a relationship between all of these equations.
And do all of these equations, or did all of these equations assist you in coming to determinations and opinions and conclusions concerning this case?
Yes.
Are these normally accepted methodologies in determining delta V, acceleration, force, that all the force dynamics or impact dynamics in an accident reconstruction?
Absolutely. They are the core of physics.
The core of physics. Okay, they're the core of physics. A little bit longer, folks, on direct. Then we get the cross. We got a lot more to catch up on. Okay. Do some of the testing. Let's get to, okay, there we go. All right, so we're right about here.
In Dr. Welcher's evaluation, all of his data,
Yes.
did you find any
No.
other than
I'm
the static
sorry.
impact test?
That was the only test, correct.
I'm sorry to all the puppers who overheard Leo barking. I apologize. Shay B, your Great Dane Ducky is barking, and it's a big bark. Yeah, I'm sorry. I apologize. Leo does not apologize. I apologize. Leo does not. We will see if he calms down, maybe, but he's so amped. He doesn't come down here very often. So when he does, he gets way too excited, and that results in a problem.
Did you see any force dynamics testing?
Sorry.
That's leading, so you can
Sure.
get to it without that.
He was leading.
What about any other testing? Anything else that we've talked about? Do you see anything else done in Dr. Welcher's?
As it pertains to an analysis to the taillight and the damage and the forces, no.
Let's move on to the next slide. Did you actually undertake testing in furtherance of the scientific method?
Yes.
Let's move on to the next slide and you can describe what we're talking about. What are we looking at here?
So you're looking at a test matrix of the various tests that we conducted at ARCCA. I could go through them one by one if you want.
Let me ask you foundationally, was your testing directed toward determining whether or not the scenario proposed in Dr. Welcher's report was consistent or inconsistent with what you would find ultimately?
The objection sustained.
Was your testing specifically designed to determine whether the damage to Ms. Reed's vehicle,
Was
the
leading
Lexus,
argument.
was consistent with the scenario that was proposed by Dr. Welcher?
That's sustained too. Ask it differently, Mr. Jackson.
What
You have to-
was your testing? What were you engaged
Can't
in
lead him to the
in
answer.
terms of your testing? What were you trying to find out?
Well, I think it was
Those were all leading. Every one of them were leading.
to, again, we talked about earlier about that hypothesis, right? My understanding, Dr. Welcher
A non-leading way of getting to that question. What were you trying to do by doing this? Why? Given what Dr. Welcher had sent or what you had seen from Dr. Welcher, why did you do this? Open-ended, not leading. Don't give him the conclusion in the question. He does it a lot. It's challenging with experts because you want them to focus and you want them to give the right answer. And by the right answer, I mean the actual particular answer. So it can be a challenge, but it was leading.
Welcher indicated that the arm contacted the
Yeah,
taillight.
she does.
But
It's
there
disproportionate.
was no
It's kind of
analysis or testing
frustrating.
to determine what's the expected outcome of that. What's the damage to the taillight?
So you answered the first question. I'm striking that second part. Ask another question.
Was there anything else?
Non-responsive.
I think simply put, it's to find out what happens when you impact an arm with a Lexus taillight at various speeds. What happens?
What was your understanding of Dr. Welcher's hypothesis?
That's sustained.
Did you have an understanding of Dr. Welcher's hypothesis?
That's sustained too.
Speculative.
Ultimately, what were you trying to find out through your testing?
I know. So distributed load mixed comment, she has sustained all 40 plus of the objections Brennan made today. How many times have you had a judge sustain every single objection against you in a trial? Rare. It's rare. It is rare. But on the reverse side, I have had opposing counsel in a case where I've objected and the judge has sustained every single one of my objections and wasn't biased in that case. It was just sometimes the questions or the way that you're forced to ask the questions lead to certain objections. I don't think she should have sustained all of them. I think there were a lot that were probably improperly sustained, but it happens. Do I think this judge treats the defense different than the prosecution? I think that's been demonstrated. I do. So you just, as a lawyer, you just have to work around it. You have to work around it. Let me put it this way. There is nothing you can do. There's nothing you can do. The judge is sustaining every objection against you. Nothing you can do. All right. So when you're playing a game and it seems like the ref is calling every foul for the other side, but none for yours, do you just stop playing? No. You have to keep on going. So you have to keep on playing. Brennan, however, is becoming very obstinate in these objections, and the jury is going to start to wonder. This is also one of the problems is if Brennan is objecting overly and just keeps on objecting, there's certain jurors that are just going to be like, why are you, I want to hear the fucking answer. That's what some jurors will think. They'll be like, stop objecting. I want to hear the damn answer. So you can alienate jurors. That's why they teach you in trial advocacy or damn, if you're being taught up right, save your objections. Don't use them for every single objectionable question. It's frustrating. And you have to count on the jury noticing that. Aurelian, that's extremely kind of you. Very, very generous of you. Thank you, Rob. I've been on leave for 2.5 years now due to depression, anxiety, agoraphobia, and PTSD from extensive childhood trauma. I am so sorry for that. I don't usually like bringing attention to myself, but Dobermans are my favorite breed. I did not know that. So Leo the Doberman says hi. Absolutely. He's been saying hi repeatedly throughout the chat. So cheers. Glad you're here. Glad you're here and watching and hanging out with all of us. I'm seeing reports. Yeah, these aren't the only people reporting. The people are saying that the jury is looking frustrated with Hank Brennan. Aurelian, stop sending the really expensive super chat. Save the money. Go order a massive thing of ice cream and hang out with us longer. And as I attempt to navigate my challenge and deal with yet another treatment failing to provide even the slightest bit of relief, this Leo pause was quite helpful and healing. Thank you. You are absolutely most welcome. Absolutely. Now, don't spend the money on me. Go order some ice cream and have it delivered. And when it gets here, and keep hanging out with us, and we will do that. LJ Peach saying Bev doesn't like out-of-state attorneys. Bev, I don't know. I don't know. Like I said, Brandon, just because you can win every objection doesn't mean you should make them. Just saying.
As I mentioned, I think it was determined when you impact a taillight at 10 miles an hour, 15 miles an hour, 25 miles an hour, what happens to the taillight? What's the expected damage? What happens to a sweatshirt when it makes contact with that? What happens to the fragments? How does the arm move? What's the acceleration of the arm? What's the change in speed of the arm? And certainly, as I mentioned, my colleague, Dr. Rentschler, will discuss what are the expected injuries in that type of impact.
Did you see any of those questions answered in Dr. Welch's report?
Ask it differently.
Yeah,
what did you see in terms of Dr. Welch's report?
It's argumentative.
Those types of questions.
That's sustained.
Why that was sustained, I don't know.
Ultimately, did you undertake a methodology to perform the testing to answer the questions that you just explained needed to be answered for this jury?
Yes.
Describe that, please.
So we started out, we kind of worked at this incrementally, right? We didn't start right off the bat with utilizing an exemplar Lexus, going right into an ATD.
God, I love this explanation. Please, I love this explanation. This feels right. Feels right. Every nerd is just like, yes, this feels right to me. How did you start? Did you buy a Lexus and stand up next to it? No, I wanted to understand the first premise. Can I do this? Blah, 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 blah.
Or test dummy, right? We wanted to start in the laboratory to have an understanding what happens at a range of speeds, in this instance, in our first two tests, between 10 and 17 miles per hour, right? What happens, what kind of damage do we observe, right? At 10 miles an hour, do we even break the light? At 17, what kind of damage do we get? What kind of accelerations do we get? And then we moved up to full-scale vehicle impact testing.
Yes.
Is that methodology that you just described generally accepted in the field of accident reconstruction, in the broader field of engineering?
Absolutely. Everything from utilizing an instrumented test dummy to using an exemplar vehicle to all the data acquisition systems that we had in the laboratory, as well as the vehicle. All of that is generally accepted techniques in the field of accident reconstruction to evaluate what we did in this case.
And are those techniques also supported by peer-reviewed articles in scientific literature related to accident reconstruction?
Yes.
Did you rely on this methodology that you just described to render opinions and conclusions as it relates to this case?
Yes.
Have you relied on that same methodology in rendering opinions and conclusions in other courts?
Yes.
Let's go to the next slide, please. What are we looking at here?
So we've gone over this before, but this is looking at the exemplar vehicle that we utilize for the latter part of our testing. You're looking at again, just annotating where the liftgate taillight is, as well as the quarter panel taillight.
When you say exemplar vehicle, what is this SUV that we're looking at?
So it's the same year, make, and model of the subject vehicle. So it's a 20.
Sir, it's not black and you're not standing next to it in jeans and orange t-shirt and a sweatshirt. How do we know this is an exemplar? I mean, I don't see you there next to it in the same clothes as John O'Keefe, 6'1", or approximately that, is holding a drinking glass next to the. How do I know this is a proper exemplar? Hopefully the condescension was noted in my tone.
2021 Lexus LX 570. So it's the same weight, same geometry, same as the subject vehicle.
Is this a picture off the internet, or do you actually have access to this truck?
We have access to that vehicle, yes.
Yeah, you do.
And ultimately, what testing did you undertake specifically as it relates to this particular vehicle?
We did full-scale vehicle testing with the vehicle driving into an ATD arm, as well as an ATD arm attached to a dummy, and then a full-on impact to a test dummy.
You mean you actually drove the thing at the speed that it was alleged to be driving and you hit something with it at that speed? You mean instead of driving in reverse at 1.9 miles an hour and making impact with an arm that was held awkwardly at some position by a standing human that rolled against the vehicle very slowly, intentionally in one direction to transfer paint to an arm, you actually drove the vehicle at the speed it was alleged to be going and hit something that was like a human body to try and see what it would happen? Well, sir, that sounds remarkably scientific. That sounds like an exemplar experiment. I would love to see the results of that. Huh. There, in my mind, am I crazy here? Like, is the jury sitting here and going, wait, this is what we could have had the whole time? I don't. Does anyone know how much ARCCA charged? $50,000 was the estimate. $50,000. What the fuck?
Did you assess the damage to the right tail light after these various tests?
Yes, after all of the tests.
Did you assess the acceleration and quantify the forces that were involved?
Yes.
Did you assess the material and textile damage to the clothed ATD?
Yes.
Ultimately, did you conduct lab tests in an effort to answer some of these questions as well?
Yes.
And you've already mentioned this, but you utilized in your testing the exemplar vehicle to the fullest extent that you felt necessary?
Absolutely.
Were
yes.
you hampered or hindered in any way in terms of damaging the vehicle or utilizing the vehicle in any way that you wished?
No.
Let's go to the next slide, please.
Did we tell you how to do it? Did we give you any parameters within which you should have done it? Is there a reason why you didn't do it at 1.9 miles an hour and you did it at this speed? Here's the thing. If Welcher gets back up, when Welcher gets back up and testifies in rebuttal to this one, the number one question I have in my mind as a juror is going, why didn't you do this the first time? Because if Welcher gets up having done these tests that he's going to be doing, I imagine he's doing them now. And I have a speculative answer. I have an answer for that. I have an answer for why I think Welcher didn't do the tests. Because once you do them, what do you have to do? You have to turn them over to the other side. So Welcher, if he does those tests, has to turn over all of the data from the test to the other side. Every single bit of it, all of it. The failed test, the successful test, all of it. So if he hamstrings himself to doing a fucking paint transfer at 1.9 miles an hour and then watches another expert do all the difficult testing, then he can come back and poke holes in it with the data that scares him or damages him already in evidence. I hate this. I hate the way this is brought out. If I'm the jury, I'm resentful as hell of the Commonwealth. Because what they gave me was paint by numbers and cosplay. What I'm getting here is testing at speed. That's the point, at speed.
What are tests A and B? What are those laboratory tests?
So these were the initial two tests that we did to get an idea of starting to test this hypothesis. As I mentioned, we weren't sure at 10 miles an hour what would happen to the taillight. We wanted to see what would happen at 17 miles an hour with the arm. So again, it was to evaluate from a starting point what happens in this interaction based upon how Dr. Welcher had his arm oriented in his PowerPoint and analysis.
Next slide, please. What is this?
So you're looking at a photograph of our lab setup. You can see on the left side of that is our Hybrid 3 anthropomorphic test device. To the right is a linear impactor, and this is something we already have in-house that we built years ago for our testing that we do for the National Hockey League when we're looking at, what's the accelerations on an impact to a goalie wearing a helmet, right? We use this same device for that type of testing to measure head acceleration. So we applied this same linear impactor to be able to project, if you will, or accelerate the taillight at a known speed into the ATD arm.
What are some of the instrumentation that you use in addition to the mechanical impactor? What's some of the instrumentation you use to track the data?
Certainly. So you can see.
This also puts Hank Brennan to fucking shame. I'm gonna rant for a second. Do I do it now or do I wait a little bit? I think I do it now because Jackson just said it. He made the comment about the data. Okay. The witness that we've heard most In commenting about the data, Hank Brennan, in his opening statement, listen to the science and the data. Listen to the science and the data. What science and data did they show me other than a fucking chart that had some numbers on it without any explanation as to what those numbers were, without really giving me any understanding of the physics behind it, and then saying we don't have enough data to reach a conclusion as to every possible variable. We can't say what happened to his body after the impact because we don't have a launching point. And by not having a launching point, I can't give you an understanding. Hank Brennan, in his opening statement, said, listen to the science and data. And what he delivered was fucking paint by numbers and cosplay. And it is so infuriating to know that that was what was presented and to know that this was the option we had all along. You know what science and data looks like? An accelerometer attached to a fucking arm that you're getting hit with a tail light going at a speed that is near the speed the Commonwealth is theorizing the vehicle was going at. That is science and data. Where was this? That would have been a scientific and data-based conclusion. This is not what the Commonwealth presented. They gave me, I hit him, 2.0. And then they backed into it with what they viewed as data and science, which were really just conclusions masked by, I don't know, garbage science. Maybe you'll get me there on the vehicle positioning and that stuff, but this was the most important thing. The most important thing isn't proving that Karen's vehicle went 24 miles an hour. The most important thing isn't proving that Karen's vehicle did a 3-point turn. The most important thing isn't proving that Karen Reed had anything to drink. The most important thing is proving that John O'Keefe's body was struck by Karen Reed's vehicle. That there was an impact with that vehicle. Not just that it was traveling backwards. I don't care that it was traveling backwards. I don't care that that's what the data says. Tell me how the vehicle traveling backwards impacts a human body in this manner and results in the injury pattern that I see on the arm with no other injuries to the lower extremities or his rib cage or his shoulder or anything else. That was the Commonwealth's obligation. That was their burden. And I don't understand when I see other people on different chats or in the Twitter sphere or wherever the hell you want to talk about it, or on other live streams, and I haven't watched them, but I see it mostly on Twitter when people are dunking or trying to dunk and saying that this proves it beyond a reasonable doubt that she hit him. What the fuck are you looking at? What are you looking at? What are you seeing? You think they proved that Karen Reed said, I hit him? Sure. I don't give a shit. I'll take that. Cool. Wonderful. Have they proven that the injuries that John O'Keefe sustained are consistent with him being struck by a vehicle going 24 miles an hour in reverse? And that there were no other corresponding injuries that resulted from that strike? No. And seeing this science and data, because that's what this is just highlighting that even further. I don't have to understand how John O'Keefe came to pass that evening. I don't. And I know people want me to believe any number of things or want me to say any number of conclusions. My brain is not geared to, nor will it reach that conclusion. It just won't do it. What I am measuring is the burdens between the two parties that exist in this trial. And did the Commonwealth prove beyond a reasonable doubt that Karen Reed's vehicle was traveling at that speed? No, I don't think they did. Made impact with a human at that speed? No, I don't think they did. That John O'Keefe was specifically impacted by a taillight or a vehicle? I'll leave it dead. This is frustrating. Just a little bit. And by a little bit, I mean a lot. I'm very frustrated.
I'll get my, see right here. So at the top here, there's a blue camera here. There's another blue camera here. So these are our high-speed cameras. And you'll see there's a bunch of lights around those high speeds. That's just because the frame rate's so high. And again, it's only sampling a very, very short amount of time. So you have to have a lot of light when you do these high-speed tests. So we have the high-speed cameras running. We have an accelerometer mounted to the ATD arm here on the other side. So that's some of the instrumentation. There's also a couple other cameras that we're documenting this overall.
Can we move to the next slide, please? What are we looking at in these photographs?
So this is looking at, and not to be confused, this wasn't the arm position when the impact occurred. This is just showing you the setup. So on the left is just kind of an overall shot. And then on the right is, right here is a uniaxial accelerometer. So that's going to measure.
Wow. It's a device that takes data and measures data on impact. Whoa, that's cool. I didn't know those existed. We did. We all did. Everyone did.
We talked about that term earlier, right? The acceleration. So that's going to measure how quickly is this arm changing its speed, right? What's the acceleration of the arm as it's impacted?
Does that accelerometer put into motion some of the mathematical formulations that you talked about earlier?
Yes.
Let's move to the next slide, please. Tell me about these photographs.
So the importance of this is more specifically looking at the
I just saw. Good for you, Jackson. I love this. The awesomely soft ultimate hoodie. Oh, it's good. That's good. I didn't catch that the first time. I love the zoom in on the label. By the way, the fabric is super soft, and if you skid it across the ground, it'd probably be torn to shit.
right photograph here might be a little bit hard to see, but we wanted to get the same exact sweatshirt or hoodie for the testing to evaluate if the taillight breaks, is there a mechanism for the fragments to penetrate and cause holes in the sweatshirt as were observed in Mr. John O'Keefe's sweatshirt?
Next slide. Were you successful in finding the exact
awesomely soft ultimate hoodie?
Yes, and I will note,
good.
as I mentioned, I know it probably is hard to see, but the material blend on the sleeves are the exact same. They are 60% cotton and 40% polyester.
Was it important in your mind to maintain consistency with the data that you had received concerning John O'Keefe's clothing?
Certainly, I think we wanted to try to control as many variables as we could.
Let's move to the next slide, please. Test A. Describe Test A for us, please.
So you're going to see a series of photographs and then videos, but Test A was mounting a preconditioned taillight on that linear impactor to accelerate it into the Hybrid 3 arm to, again, evaluate the damage to the taillight and the acceleration to the arm.
Let's move to the next slide, please. What are we looking at in these photographs?
So you're looking on the left, a photograph just before the impact test was conducted. On the right, you're looking at a thermal image that is depicting the temperature profile of the taillight.
Describe that thermal image.
Certainly. Your Honor, may I refer to my notes?
Yes.
That's funny. You didn't need to look at his notes until just now. That's cool.
So what I did is I analyzed the profile of the temperature down in this area. And when we look at that segment, that lower portion here, where contact was made, the average temperature in that area was about 34 degrees with a minimum of about 33 degrees.
How did you get that exemplar taillight down to around freezing?
So all of the taillights that we tested were preconditioned overnight in a freezer.
Why was that important?
Well, it's my understanding that at the time
Brittle.
that this allegedly occurred, the ambient temperature was 31 degrees Fahrenheit. So as I mentioned earlier, certainly there's a correlation between how plastics perform in cold weather. So we wanted to take that variable into account in our testing to precondition them down to temperatures that were consistent with at the time of the alleged incident.
Next slide, please.
I would ask the question of where this was in Dr. Welch's report or his analysis, but no, because he never actually took a tail light and put it at anything other than 2 miles an hour. He just somehow came to, was there ever any math for his conclusion of 8 miles an hour? Did we ever get any math or data that concluded as to why the tail light would fracture or break at 8 miles an hour? Or was it just kind of given to us like, hey, 8 miles an hour, it's going to break? because I really needed to understand that, especially given this understanding here. Like, yeah, acrylic, when you get it really freaking cold, is very brittle. So I'd like to replicate the brittle and get it cold enough to the surrounding environment. And this also brings to mind Hank Brennan's stupid ass questions earlier about the, did you put it in the freezer? Did you put it in the freezer? Now I'm starting to understand why he was asking those questions. Hank Brennan was obsessed with ARCCA. Obsessed.
What are we looking at in this slide, on this photograph?
So this is a video. Do you want me to go ahead and play the video?
Tell us what we're about to see, and then I'll ask the court's permission.
So you were looking at a camera that is mounted above the entire setup. If you look at the top portion of this video, you will see the taillight. Part of it's covered by the high-speed camera. But what will happen is the linear impactor will fire, and the taillight will be accelerated up to 10 miles per hour, striking the closed ATD arm.
With the court's permission,
Okay.
let's go ahead and play the video. Next slide, please. What is this?
So this is also a video, but with the high-speed camera. So it's the high-speed camera
Oh,
that's
yeah.
looking top down at the
Give
arm.
me the
So
high-speed
you will
camera.
see when the video plays, you will see the taillight enter from the left and contact the arm. And I will note that this is essentially slow mode, so it's not happening in real time. So you'll see the taillight slowly moving, but it's actually in reality moving at 10 miles per hour.
Understood. Go ahead and play that.
Give me the camera.
Can I ask a question now that that's played?
Huh.
How did you mount the taillight to the accelerator, the linear accelerator?
Right. So we had to get a little bit creative there because you may have observed this when we had the physical assembly out earlier. The back of that, it's not some nice clean surface that we can just bolt on. So what we had to do is 3D print a bracket that we could bolt onto the linear impactor, and we used a polyurethane expanding foam to be able to marry those two together so that we could then bolt it onto the linear impactor to use it for this test.
Did you see any debris from that foam?
Sir, my brain just smiled. Like, just about as my brain just fully smiled. How did you brace the entire, basically, how did you solidify or shore up the entire taillight mechanism so it was akin to being attached to a 6,000-pound vehicle? Well, we printed a bracket. 1, bonus points. Love it. 3D printed, phenomenal. The only questions in my head is what material did you use when you printed it, and what 3D printer was, and what settings did you use, because I'm going to steal it to try my own tests later. 2, the expanding foam. And Hank Brennan tries to make a comment about this one, but I think that might fall flat. Why'd you use the expanding foam? Well, because we had to make sure it was secured to the damn thing in such a fashion that it would have been, like, similar to what it would have been if it was actually physically attached to the vehicle. What does the expanding foam do? The expanding foam fills in all of the voids so that when that bracket, everything that bracket's not making contact with, the expanding foam is filling in the gaps and reshoring all of those pieces. So it really is one mass, one singular mass that you've accelerated up to the speed you need it to be when you're hitting the arm so that you get accurate measurement. God, I love this. Oh, it's phenomenal. I'm so happy. Emily Ippolito. Rob, you know they have one out of your budget. Come on now. We, not in this household. In this household, when it comes to the 3D printers, the tools in the shop, God, if Mischief is in this chat right now, I am in so much fucking trouble. We don't use the B word. We don't use the budget word. Not when it comes to that kind of stuff. You know what? This is the appropriate use of it. Sharky. In other words, it distributes the load. Yep, that is the appropriate use of that phrase. Right there. That is the appropriate use of that phrase. Jess J, householder office. Yes. That's a call out to the fact that I bought a 3D printer in secret and had it shipped to my office, a second 3D printer. Yeah, so I am nerding out. I'm enjoying this.
Foam mounting mechanism.
Yes, there's a few flakes you can see of that polyurethane foam off the backside kind of going into being dispersed there.
Okay. With regard to this particular 10-mile-an-hour test, what did you note in terms of the damage to the taillight?
It was very minimal.
And what did you note in terms of any damage at all to the hoodie?
There was none.
None.
Can we go to the next slide, please? What are we looking at in this slide?
So this is looking at a side view. So same test, just looking at it from the side. And similarly, you'll see the tail light come from the left and impact the arm.
If we can play this, please. What did you note in terms of deflection of the arm, the test arm?
Well, the arm essentially, and we'll see this in the data later, it reaches a common velocity with the tail light based upon.
Give me Dr. Rechler. Give me Dr. Rechler right now. This is a 10-mile-an-hour impact. This ain't lacerations, folks. This is fractures. The fuck? This is...
The portion of the arm that was contacted, again, consistent with how Dr. Welcher has it oriented, it will become accelerated up to 10 miles an hour, roughly.
Over approximately what period of time is that arm accelerated up to 10 miles an hour along with the taillight?
We'll see it on the data plots. I think it's about 10 milliseconds or so.
How long,
10
do you know
milliseconds.
how long an eye blink on average takes?
Off the top of my head, no, I don't. Probably pretty quick.
Somewhere around 250 milliseconds. Does that sound right?
Sustained.
There you go, Hank. I was waiting until you were going to wake up. That was a good objection, too. Problem is, Jackson got it out. I was waiting for it. Hank, that wasn't fast enough. That was... Did you fall asleep, sir? You knew he was going to do it. You know what's funny about that? You can line it up. Line it up right there. Do you know how fast the human eye blink is? No, I don't. I am up in my chair. I am waiting for that objection because I know damn well Alan Jackson's going to say about this. Is that an eye blink? Oh God. Hank fell asleep. Whoops. Whoops.
Let's move to the next slide, please. What are we looking at in this series of photographs?
So these are extracted frames from the high-speed
The
video that we just saw on
10-mile-an-hour
the previous
impact.
slide, basically showing just at contact, just after contact, and then post-contact, so you can see the kinematics of the arm and how the arm is moving.
Okay, let's move to the next slide, please. What is this photograph?
So this is photographs taken of the taillight after the 10-mile-an-hour test. I will note that there was a couple small fragments of the clear portion of the assembly, the outer lens that was missing from that turn signal area towards the left here. There's a couple fragments missing, and then there was
Apocalypse DOA, great point. Not sure on the fracture, but definitely bruising. Apocalypse DOA, I'll just go back and say that was a 10-mile-an-hour test. 10. And Hank goes and makes the opposite argument than I thought he was going to make. Hank makes an opposite argument. I did not think Hank was going to make an argument that I thought was dumber, but he does.
there was some small fracturing here in that area.
How would you describe the damage to the taillight at the 10-mile-an-hour test?
If I may go to the next slide, I think it might.
Sure.
No,
So this was the totality of that damage at 10 miles per hour. So I would describe it as minimal and superficial.
Okay.
yeah,
Next slide,
the,
please.
the clear acrylic, the thinner acrylic broke.
What is this?
So this is the photograph that I just shown you compared to that of the subject taillight so that you can have a side-by-side.
God, the PowerPoint is in evidence, folks. If I'm the jury, I'm saying, give me the PowerPoints of both experts. I want the PowerPoints. I'm going to take them back in the room. I'm going to compare them.
Side comparison of the test taillight compared to that of the subject.
Were you able to reach any opinions and
right back.
conclusions about whether the damage to the subject taillight is consistent with striking an arm at 10 miles an hour?
It's inconsistent, in my opinion.
Next slide, please. This is still test A, is that correct?
Correct.
Were you able to reach any opinions or conclusions as to whether or not the damage to Mr. O'Keefe's clothing is consistent with being struck by the taillight at 10 miles per hour?
What I observed from the test is that there was no mechanism to create any of the holes that we observed on the subject sweatshirt.
Do you hold that opinion to a reasonable degree of scientific certainty,
Yes.
as well as the former opinion that you just gave us?
Yes.
Next slide, please. What are we looking at in this graph?
So this is a graph that shows on the next graph, you're going to see a 24 millisecond window. So what I want to show you on this graph is what does that look like over a full second, so you can have an appreciation of just how quickly this is occurring. As you mentioned earlier, I think your comment about a blink of an eye, this is even shorter than that. We're looking at, as you'll see on the next graph, again, it spans over just a few milliseconds. So that yellow tick that you see in the middle there, what I've done is I've plotted that over a full second. So 1 second is equal to 1,000 milliseconds. So if we go 500 milliseconds to the right, 500 milliseconds to the left, this whole graph represents 1 second in time. This impact duration is occurring very quickly.
1 second, is that reflected from the beginning of the graph to the end of the graph? That's representative of 1 second, is that right?
Correct. So starting at this y-axis all the way to here is 1 second in time, with our impact duration happening over just a few milliseconds.
And this was at 10 miles an hour?
Yes.
Next slide, please. What are we looking at in this graph?
So we're looking at the acceleration or the change in speed over time, that parameter that we discussed earlier. So what you can see is that as the arm is impacted, we have the accelerometer mounted on the inside portion of the forearm, if you will. You see that it starts to accelerate, right? Because it's changing its speed, and then it starts to level off after the impact has subsided, basically, and it's reached a common velocity.
What do we see in terms of the G-forces that the arm is subject to?
So the peak is occurring right around here at about, looks like just over 6 milliseconds. And the peak acceleration is just over 130 Gs.
And what does that mean? What is a G?
So a G is acceleration due to gravity. So if we're being held down by 1 G, so you could think of it as basically a multiplication factor, that it's 131 times the acceleration due to gravity.
And the next slide, please. What are we looking at in this slide?
So this is, again, that concept that we talked about earlier, delta V. This is the change in speed. So if we do some math to the previous data that we collected, it's a technique called integration, where we can actually add up all of that acceleration to determine what speed did the arm get up to. And when we do that calculation to this data, what we see is that initially at the impact, right, the arm's at rest, right, Newton's law, first law. And then we impart a force on it in terms of the tail light impacting it. It's going to cause the arm to accelerate and change its speed. So as I noted earlier, it's essentially going to reach a common velocity with the impact force based upon how Dr. Welcher has the arm oriented. And we can see that it's a tick over 10 miles per hour at just over 10 milliseconds. So that means that the arm in a 10 millisecond period is going from 0 up to about 10 miles per hour, which was the speed of the impact.
And 131 times the force of gravity is exerted on the arm at the same time?
Sustain us to that point.
Where does gravity play into this? What is the 131?
He explained it already, Alan.
Where's that force exerted?
So that is the acceleration that the arm experienced as a result of that impact. So that's how quickly it was changing in speed.
Understood.
All right, so let's get to the second test. It's after the break. So take a break.
Remember, we're talking about that short duration of time, that 10 milliseconds. So once it breaks, it's already reached a common velocity to the tail light.
Okay. Can we go ahead and go to the next slide, please? What do you note about this impact?
17 miles an hour.
So one of the things you'll see is kind of that dust cloud that you see. Again, that's all the particulates from the expanding foam that we use. So that's kind of what you see in the background there, kind of going over kind of the arm and the tail light there.
Do you note more damage or less damage to the tail light at 17 miles an hour versus the 10 mile an hour test?
There's more
Alan.
damage, yes.
Let's go to the next slide, please. What are we looking at here?
So you're looking at a top-down view from the high-speed camera. You'll see the tail light enter from the left, impacting the arm at about 17 miles per hour.
Okay, go ahead and play it. Can you describe the decoupling that's shown here?
Absolutely. So as you can see, where the two are basically married together, right? It's kind of actually coming back together now. So that bond that we had, right? This is the most effective way that we could mount it to the impactor. It just became detached due to the force of that impactor stopping at the end.
My next question was, did you get pissed off at the fact that you made the design the way you did? And did you start redesigning how you would attach it next time? That would be my question. Because I with a brain that thinks anywhere like in this process, or with this type of thought process, I would have looked at this and been like, damn it. All right. How did I design that? Why did that come across? Why did that fall apart?
End of the stroke.
Understood. Next slide, please.
17 miles an hour. And
So in this slide, you're looking at another high-speed video. This is just a side view. Again, you're going to see the taillight enter the frame from the left, impacting the arm at 17 miles per hour.
Is this in slow motion as well?
This is in slow motion, correct, not real time.
Okay. What do you note in terms?
Okay, so the prior one might have been bruising. This one, I think, might be different.
In terms of the deflection on the arm?
The arm, as we saw in the previous one, is accelerated up, so it's moving now at roughly a common velocity with what the impact speed was.
And what did you note about the damage to the taillight?
It was more significant than the 10-mile-an-hour test, which, again, there was very minimal damage to that, where several fragments of that red outer lens fractured as well as the clear lens.
Okay, next slide. And what is this depicting?
This is extracted frames from the previous video just showing right at contact, during contact, and post-contact.
Next slide, please. What is this a photograph of?
This photograph is depicting the damage to the taillight at the conclusion of the test, where, again, it's missing fragments of the outer red lens. I will note that the interior diffusers and plastic components are intact in this test.
When you say intact, what do you mean?
They're not damaged or broken.
At all?
Correct, at all.
Next slide, please.
The diffusers are intact. So, rocket glass breaks diffusers. Arm, 17 miles an hour, no broken diffusers. Actual vehicle, broken diffusers.
What is that a picture of?
Another photograph showing the taillight post-test. Again, no damage to the underlying diffusers in terms of being cracked, shattered, or broken.
And what did you note in terms of the damage to the outer acrylic, the red piece?
It broke into a few fragments, and I think on the next slide I depict those in a photograph.
Let's take a look at that. What is that?
So this is a photograph depicting the collection of the fragments post-test. I will note there's one clear piece,
Yeah, there's
one
a
red
couple
piece,
pieces that are.
another clear piece, and there is one more red piece in this bag. So the outer lens broke into approximately 4 pieces in this.
Yeah, that part would have me, if I'm Dr. Wolfe, I'm kicking myself, because that gets me back to the bracket and mounting it to that post. And if he had secured it where, I don't know. Because a lot of these pieces on the back end, those are the back end pieces, like that are actually part of the tail light apparatus. But it's like 4 or 5 pieces. It's 17 miles an hour.
17 mile
against
per
an
hour
arm.
test. And I'll point out one other thing just because you can see it in the photograph. This is that 3D printed bracket that we used to bolt it onto the linear impactor with the foam on the other side that mounted it to the taillight.
Thank you for that. Next slide, please. What is
Why'd
this
you
picture
print it
of?
red?
Pictures of?
This is a side-by-side comparison showing a depiction of the 17 mile an hour test impact to the test taillight, comparing it to that of the subject taillight.
Were you able to reach any conclusions or opinions as to whether or not the damage to the subject taillight on the right is consistent with striking an arm at 17 miles per hour?
It's inconsistent from a damage perspective.
What's the basis of that opinion?
The test that I've just...
I can see the photo, Alan. What's the base of that opinion? I can see the photo. Like I can see the photo. I don't need this part right here. This is why this expert was so much more effective, because the jury, if I'm the jury, I'm sitting here going, I don't need to know his basis of his opinion. I just saw it. Like I just witnessed it. He just walked me through how he did it. You don't have to tell me what the base of the opinion was. I just watched him do it. And he did it in a way that I could understand and comprehend. Like he broke it down to me like I was 5. Like I was 10.
just showed you all.
Was that testing that we've just talked about conducted in accordance with the scientific literature and generally accepted methodologies that you've earlier described?
Yes.
Is the damage to the right rear taillight consistent with striking John O'Keefe's arm at 17 miles per hour?
No.
Do you hold that opinion to a reasonable degree of scientific certainty?
Yes.
Slide 45, please. What is this?
You're looking at photographs post-test.
Sir, that's a fractured arm. Like that's a fractured elbow. Also, not to mention the tendon tears that would exist right here. Like just all those tears. That's a lot of internal. That's a lot of injury. That's a lot of injury.
Of the sweatshirt that the ATD was wearing at the time of the impact.
Is this the 17-mile-an-hour impact?
Correct, yes.
Did you note any defects in the fabric of the right arm?
There were no punctures, holes, or fraying of the material during this impact test.
Based on this testing that you conducted in this case, is the damage that you saw of the shirt that John O'Keefe was wearing consistent or inconsistent with the shirt that's on the ATD?
It was inconsistent compared to the sweatshirt that Mr. John O'Keefe was wearing.
Based on that, do you have an opinion or a conclusion as to what?
Thank you. I don't know if they focus on this enough,
but the damage on
the damage on the sweatshirt, the holes in the sweatshirt, a vehicle going 17 miles an hour, if you are impacting a sweatshirt, and let's say hypothetically, let me give the Commonwealth their best theory. The best theory they have is that the vehicle taillight was broken, and that the broken vehicle taillight had some jagged edges or points. Okay, so the broken taillight had jagged edges or points, and that when the vehicle hit John O'Keefe's arm at 17 miles an hour, those jagged edges and points made impact through the sweatshirt, caused the punctate holes in the sweatshirt, and then went in and made lacerations in the arm. Here's the problem with that. Well, there's several problems with that. One, if you take the Commonwealth's theory of the glancing blow, if one of those shards catches that sweatshirt, you're getting a tear that is just ripping that sweatshirt to shreds. Okay, so now let's take the hypothetical of there were no exposed shards and there's just the dimples. The dimples caused that. No. Just unequivocally, no. You saw the arm get up to acceleration. It was within the blink of an eye, like that, like blink of an eye. The arm is accelerated to the speed of the vehicle. At that point in time, what is there to puncture? It can't puncture. The puncture would have had to happen at the immediate impact. And you can't get a puncture wound from those little dimples on the end of the taillight. His explanation here, this is where I think that Alan Jackson needs to clean it up and redirect, is explaining how the punctate wounds, the lacerations on the Commonwealth's theory would be, I want to say they would abrade more. They would be more scuffs or scrapes or scratches, but not even then. They would be more bruises. I don't think that you would get the puncture wounds in any of these hypotheticals, not based on what we just saw. So that's where I am with it. I think that part needs to be cleaned up on redirect.
O'Keefe's clothing was consistent with being struck by the right rear taillight at 17 miles per hour.
It is inconsistent.
Next slide, please. What is this graph depicting?
So going back to these terms that we've talked about, this is the acceleration trace of the 17-mile-an-hour impact test. And you can see that we reach a peak of acceleration at around 5 milliseconds, and that's at about almost 270 Gs.
You said 270 Gs?
Correct.
Or 217? 270.
270.
Thank you.
70.
I'm sorry for replaying so much of his testimony. I really am. I wanted to kind of hit the highlights here, but I actually was, this is why I said this is going to be later or longer, because I can't chop this up. This is all good. This isn't little bits here and there where I'm sitting there going, why are you explaining this to me? I'm watching this and really enjoying the presentation. That's why I'm replaying a lot of it. Tammy Lynn, I feel as though the case is as good as over. However, we are not the jury. I agree 100%. Hard to tell who they will, however they will go. I agree as well. I don't understand. I mean, we also are not guaranteed that the jurors that are smirking or laughing are going to go back and deliberate. We don't know. I don't know. Hank Brennan does a damn good job of conflating the burden of proof. He very much does a good job of doing that. He has me half convinced at the beginning of his cross that the defense has the burden of proof. I shouldn't feel that way. He shouldn't be allowed to do that, but he does, and he's effective at it. Lisa Paxton, thanks for being a member. Polly Piazza, getting my master's in mechanical engineering will apply to ARCCA. That'd be cool. Molly, I hope to see your name in well, I hope you never have to testify as an expert witness, because I don't really wish that on a lot of people, but I imagine the science is really damn cool. Katie Erickson saying, I'm a little late. Congrats on the 200K. Been here since the Depp trial with your famous video. Love your lives and trials of the century. Thank you, Katie Erickson. Very kind words, and thank you for the congratulations. We've hovered right at the 200K. I honestly get to talk to you guys once a week. So I love where I am. Love the channel. Love being able to explain these cases. And the capacity that I have available to me is kind of that one time per week, just based on life and circumstances. Shark. I really wish you would tell me how to pronounce your name, because I keep screwing it up. The pilot episode of Mythbusters 2 is lit, yo. It's about to get more lit. Ian BPPK. The difference in testimony is like the kid whose parents did the science experiment versus the kid who actually thought out an interesting question. I love this. This is just singing to my brain, because I was always the one where if you told me something existed that way, if you told me that certain things operated in that fashion, I was like, bet. Like, let's go try to make that happen. Let's do that. Oddly enough, to some very unfortunate consequences, such as broken bones. Yeah, I broke a lot of bones. The guy who did the casts in the ER in California when we were growing up knew me, would come in and be like, what was it this time? Leg, ankle, wrist, shoulder. I needed to know how things worked. And that resulted in some very painful consequences, but I learned. I'm getting correct. It's just Shark. All right, Shark, you got it. But yeah, this is how I learned. This is how my brain works. Not Sarah Lee. It's also a throwback for Justice for the Line. It was also a throwback for Justice for the Line when I got to know you. Oh, we got to hang out. That's awesome. I always look forward to FNFs with everyone. Thank you for taking the time out for us. Thank you, Sarah. Thank you. Yeah, sitting in the line was a lot of fun. It wasn't a lot of fun. It was a necessary chore. Trying to sleep on pavement, getting into the Johnny Depp trial. It was fun. Looking back at it, it was fun. I wouldn't do it again. I probably would. Matthew Self. Karen Reed would have had to strike a dog first and then accelerate that dog into John's outstretched arm while the dog was mouth wide open. The dog would have had to chomp while Karen Reed went forward and backward again. I could probably develop a mechanism that was not a dog jaw that could inflict this injury pattern, but I would probably have to develop that mechanism in a very specific fashion with certain things that are pointy objects sticking out, like just. The taillight thing is shot to shit for me. I don't buy it anymore. I just don't. I can't. Not on these two experts back to back. Lisa Paxton bar exam signed up for next month. Shit's real now. Cool. Good for you. There you go. Many thanks to you, Ian, EDB, and Peter from Lawyer You Know for teaching me how to critically think in trial. Thank you. Thank you. Lisa, that is awesome news. Congratulations. Good luck. Good luck. Nose in the books. Learn. Just memorize all you can. Melissa Ensign, thank you. Equality, I feel for your mom, Rob. We shared the obligation of taking the children to the hospital when they were hospitalized, and there was more than a few. We were rambunctious children. All three of us, very rambunctious children. Big Dog 5758, 3 hours behind, catching up on 2.5x. Oop, I'm sorry, I talk fast. Thanks for the recap, but the police lady defense witness would have been fun to cover as well. only have a little bit of time. The engineer in me just wants to see this. That's just me being selfish. The engineer brain needs to see the science. That's just where I am. Miss Shorty, I live for Friday Night Frenzy these days. Thank you, Rob, for your time and insights and humor. Free Karen Reed. Thank you. It's very kind of you. I did save the rest of the super chats. I have them saved. Not Sarah Lee. I saw this one from earlier. Wanted to pull it up. Thank you. Very generous. Layers Live going to court today was fascinating. Peter Murphy spoke on police support for Karen Reed, though they won't come forward. And Scott McGinnis said Cannoni used to be very liberal, pro-defendant, but has to cover for DA Morrissey now. People are going to have opinions one way or the other. I'm focused a lot on what is allowed to happen in trial, the evidence being presented. I think I can give you guys a lot more input there on what I think the arguments are, what the favorable arguments are being laid out as, whether the rulings are proper. That's where I think it is. Inquiring mind, Rob, there's your closing argument. John O'Keefe was never hit by a car. Facts and the data right now are not in favor of the Commonwealth. I don't know what really happened as well as nobody else, because there was a shitty job done on the investigation. That's where I am. The other Jules, I hope defense brings this up in summation. The defense, who has no obligation to prove anything, brought you the science, data, and testing. Yeah. If Welcher, so Baby Gator says, if Welcher charged $400,000 to play with paint, how much will he charge if he does actual testing? I don't know. I don't know if he'll probably go out and buy a 3D printer. Oh my God. Could you imagine? Can you? If Dr. Welcher begins his rebuttal argument or his rebuttal testimony with, we went and bought a 3D printer, I don't know what I'm going to do. What's a good bet? What's a good bet? Shave my head? There's no way that could happen, right? We don't live in a world where that could happen, where Dr. Welcher goes and cosplays ARCCA, right? This is just a bad dream that I'm living. Why am I seeing this actually play out? Where he goes and cosplays ARCCA and like literally tries to replicate their tests to the point where he goes and buys a 3D printer to print a bracket to hold the fucking taillight. Oh my God. If it comes out that Welcher bought a 3D printer, I don't know. If it comes out that Welcher bought a 3D printer, I will donate 250 memberships. 250 memberships. I'll donate. And I will do a shop stream the very next day that Welcher testifies, from Welcher testifying. I don't care the condition of the shop or how tired I am. I will make it happen. If that testimony comes out where he bought a 3D printer to do the testing that ARCCA did, that is my promise. Mods, hold me to that. Please don't happen. Please don't let this actually be the most horrible thing I've ever seen in courtroom. Don't let it do that. Just don't let it be that. Gray Space, finally some real physics in this trial. Thank you, Gray Space. I caught you talking to Ian the other night. Yeah, I like seeing it too. You know, actual science and data, the science and data that we were promised over and over and over again, that is now in front of us. Science, data, the proper use of acceleration in an argument. Oh no, wait, we don't have to think about that. That's going to get completely butchered, because Hank Brennan and Cross is gonna bring us back to a fundamental misunderstandings of how physics works. Oh, and math. He's gonna completely conflate mathematical equations. Oh my God, completely conflate mathematical equations. And I fucking hate math. And he's gonna butcher it. Classic overthinker, paint by numbers and cosplay, spat my H2O everywhere. Yeah, that's what it was. Melissa K. They didn't pay Welcher for testing. They paid him to say what they wanted. $400,000 to make a joke out of yourself in education. I don't know. Where Karen Reed's injury, she would at least have whiplash. I don't know about that. 200-pound vehicle. It might be. It might be.
Did that have any significance on your analysis?
Yes.
What was that?
Well, we can use that to
did
estimate.
talk to Grace Space too. I
obviously, we
joined
can
the
integrate
chat.
that to get the
Thank
speed.
you for
We can
reminding
also
me.
estimate.
Thank you for reminding me. That was late. Ian was crashing. Ian was crashing hard. Grace Space, we hung out. Yes. God, that was so late. And Ian was doing a dive. He was so tired. He had a headache. He had a migraine. And I saw it happening, and I had court the next day, and I jumped in and helped to finish up the questions. So, Grace Space, we've had a lovely time talking. And we need to do it again, to be honest. You know what? Please tell me you're going to be on when Dr. Rentschler testifies. Because the math and the science and the data, and I need the math, science, and data.
Estimate the force applied to the taillight with that information.
Can we go to the next slide, please? What is the delta V as it relates to the 17-mile-an-hour lab test?
So you can see, again, the arm initially at rest is accelerated up, increasing in speed, and then reaches just about 16 miles per hour, so reaching nearly a common velocity with the taillight at about 8 milliseconds in time.
Next slide, please. Did you conduct additional tests other than the 2 lab tests that we've talked about?
Yes, sir.
Describe just in general, and then we'll talk in more specifics. What were the tests that you undertook after the lab tests?
So we conducted 2 tests with a suspended ATD arm that was impacted by an exemplar 2021 Lexus LX570. We then conducted a test where the arm was then attached to a test dummy, and then our final test was a full-on impact to a test dummy.
Can we go to slide 48, please? What are we looking at in this slide?
Oh, I miss the days of complaining about Elaine. I miss the days of complaining about Elaine and her microphone.
This is the exemplar 2021 Lexus LX570 that was utilized during this test program.
Was this the same vehicle that was utilized in all the tests, C, D, E, and F?
Correct, yes.
We could go to slide 49, the next slide. What's depicted in this photograph?
It's a
Well,
good
so
idea,
there's
Kate
a number
Kristen.
of things here, so I'll try to point them all out. So obviously, we talked about just now the Lexus here, the exemplar vehicle. We have a forklift that was hoisted up that ultimately was suspending the arm. I think I have an additional photograph that shows it close up. But the arm was suspended from the forklift at the correct height to interact with the taillight. We have our high-speed cameras set up under this umbrella. There's another one over here. Another thing you'll note is we brought out the chest freezer when we were installing these in the Lexus to, again, keep them at that steady state temperature for as long as possible.
If we could go to the next slide, please. What are we looking at in this photograph?
So this is the
Tell you what I don't see. I don't see an orange t-shirt, jeans, and a person wearing a hat that happens to be 6'1". I see testing apparatus.
approximate position that we plan to have contact occur in these tests. So as you can see, the forearm is in contact with the liftgate and the quarter panel taillight along with the elbow.
Why did you choose this configuration for the arm, the forearm, the hand, the elbow?
It was based upon my review of Dr. Welcher's work, and that he did through his static and dynamic test or paint test that this is how the arm was roughly oriented when the alleged contact occurred.
What were you trying to replicate in positioning the arm this direction, this way, as it relates to the SUV?
Well, I think as I stated earlier, it was to understand, okay, let's get beyond just simple geometry, aligning things. What happens to the arm, right? What are the accelerations? What's the damage, right? What we want to answer some of those other questions that Dr. Welcher didn't answer.
Does this
So I'm going to strike the last part of that answer.
Does this configuration align with your understanding of Dr. Welcher's alignment of the arm as it relates to the vehicle?
Okay. Existing.
May we approach, Your Honor?
Yes.
Trying to get him to say he replicated his experiment and that it's bullshit. That's what he's trying to get him to say. Now, let's see. Let's go to beyond the sidebar, which is 307. Let's go to here.
Slide, please. What are we looking at in these two photographs?
So on the left is a photograph of the installed preconditioned taillights just after the install, and on the right is a thermal image of that.
That's pretty damn cool. That's pretty damn cool. They preconditioned the taillights. They got them down to temp. They got the damn taillights down to temp. Do you know the appreciation that I have for this level of detail? It's like we're going to hit an arm at the same speed the Commonwealth said it was going. And there was someone in that group that said, well, it was cold that night, right? And they're probably going to say that, well, a colder taillight would have broken more easily. So why don't we actually replicate the conditions that night? And someone's like, cool, let's throw the taillight in the freezer and get it down to temperature. This is the nerd just heaven.
And if I may just point out with the temperature. So one of the things you may see here is that due to the reflective chrome here, this is just an artifact of that being really reflective. So when we look at the average temperature profile of the taillight for this test, the average was approximately 17 degrees Fahrenheit for the taillight.
Was it important in this testing to account for the temperature variance of the taillight assembly?
Yes, absolutely. And I will note we certainly strive to maintain that. One of the things you actually may see in this photograph on the left are these pellets on the ground, and that is due to the fact during the installation process, one of my colleagues was positioned adjacent to the taillight fixtures, applying a compress of dry ice to help mitigate any heat transfer during the install process.
Let's move on to the next slide. What are we looking at in this overhead view?
This is it's a drone video, so you're going to see the Lexus accelerate from left to right, impacting the hybrid suspended arm in the area where you could see the umbrella.
Can you use your spotlight and orient us? Where are the vehicles and the testing locations?
Yes. So the Lexus is starting here. You will see it accelerate in reverse with the hybrid arm suspended in this area here.
Okay. Is this a video or just a still shot?
This is a drone video.
Let's go ahead and play that. Dr. Wolfe, is that in real time or slowed down, sped up?
This is in real time.
Okay. Next video,
How scary was it driving that in reverse that fast?
please. What is this?
This is a camera that was mounted on top of the forklift that was suspending the arm.
Is this a still shot or is it a video?
It's a video.
What is the orientation of that arm as it relates to the vehicle that we'll see?
So it will make contact with the taillight, although I will note in this test, ultimately the contact ended up being more of a clip or a side swipe in this test.
Go ahead. Did you see the impact area?
It's quick.
Right. What did you mean when you said more of a side swipe or a clip?
So I think the next couple of videos will help demonstrate that.
Let's move on to the next one. What are we looking at in this video? Or, I'm sorry, in this photograph.
So this is going to be
But why are you not wearing an orange t-shirt? Sorry, I'm going to keep making that
a
comment.
high speed or a slow-mo video. You're going to see the Lexus come in from the right and then move across the screen to the left. And you'll see contact occur between the taillight and the arm.
Okay.
Now, this is where, I mean, in cross, Hank's going to conflate this, so I'm going to bring this up now. The purpose for measuring via this mechanism is not to demonstrate so much the impact on the taillight. It is more the fact that they're getting the accelerometer readings on the arm from a full vehicle doing this, meaning actual test, actual vehicle going in reverse. What does it do with the accelerometer and all the different mechanisms here? Hank conflates that later, I think.
Can you explain for the jurors using this video what you meant by more of a side swipe or a clip?
Right. So this is where the hand and the wrist are kind of in the area of the quarter panel taillight, and then a portion of the forearm in contact with, I'm sorry, what I previously said, the wrist and the hand in contact with the liftgate portion of the taillight, and then on the forearm is more in contact with the quarter panel taillight.
Okay, can we move to the next slide? And what is this angle?
This is, yeah, same test, just a different angle with the high-speed cameras in slow motion.
And this is at 15 miles per hour, correct?
15 miles an hour, correct.
Can you explain for the jurors, given the fact that this is suspended, does that have any impact on
Why is
the
it there?
ultimate analysis or reconstruction, rather than being attached to an ATD?
Effectively, mass is mass. So whether we have an arm that is suspended or attached, again, it's the arm is on a joint, right? So the arm can accelerate freely of the rest of the body, right? So if anything, even if it is attached to the body, there may actually be some additional force associated with that, just because there could be more mass attached to it.
Understood. Okay, let's go ahead and play this video.
Good catch, guys.
Can we go to the next slide, please? What are we looking at in these three photographs?
So you're looking at, on the left, starting from left to right, just at contact, and then just after contact, and then post-contact. So as I mentioned, you can see that in this first one at contact, again, we don't have, the hand isn't, and the arm aren't positioned as far out on the previous tests, and the hand is in the area and the wrist of the lift gate taillight, with part of the forearm in contact with the quarter panel taillight. And as you saw in the video, essentially the arm just kind of moves out of the way of the vehicle as it comes by.
Understood. Next slide, please. What are we looking at here?
This is a photograph of the test vehicle subsequent to the test, depicting the, I'll say, lack of damage to the taillights.
Describe what you did see in terms of damage or lack of damage on the taillight.
There was no damage or fracturing to the taillights.
Describe the orientation of the arm in this particular test that you said was more of a side swipe. What was the orientation of the arm to the taillight in terms of how much of the arm touched the taillight? It's probably a clunky question, but I think you understand it.
Okay, let's fast forward to the 29 mile an hour, 318. Vehicle test, 29 miles an hour.
Hybrid arm.
We move to the next slide. What are we looking at in this series of photographs?
So on the left is my colleague, again, compressing the taillight, while we are on the right is of this into the suspended hybrid arm over here at the location of the forklift.
Okay, if we can watch this video, please.
Look how far the distance is to get up to 29 miles an hour. Look at that. Look at the distance. Look at that distance. Ugh. Look at him gun it too. Oh, it's 1.25. Okay, that's fair.
Do your next slides show? There you go, the suspended arm. What are we looking
That's
at?
1.25.
So this is a
that's not
video
fair,
camera
Rob.
that was positioned on top of the forklift,
Bad,
looking
Rob.
down at the arm. So you'll see the vehicle move from bottom to top as this video plays.
By the way, Dr. Wolfe, what are the purple and white lines that we see have predominated? I'm sorry, I was talking over that.
That is
Purple and-
fast.
Your ne- Do your next slides show? There you go, the suspended arm. What are we looking at here?
So this is a video camera that was positioned on top of the forklift, looking down at the arm. So you'll see the vehicle move from bottom to top as this video plays.
By the way, Dr. Wolfe, what are the purple and white lines that we see have predominated? I'm sorry, I was talking over that.
Sorry,
That's okay. What are the purple and white lines that we see?
So those are guidelines. It's small of a target, so just served as a guideline to reference as we're accelerating rearward into this.
Is this in real time?
This is in real time, yes.
What's the speed that the vehicle is entering the frame at?
29 miles per hour.
Thank you. What happened to the arm in terms of
Wow.
its suspension?
It actually gets ripped off.
I believe to get to the other testing, the force of
Okay, come on.
The Lexus SD
So
at
now
29
Brennan
miles per hour.
conflates
Just a different
this. Let me get
perspective than the previous video.
to.
okay,
Let's go to Randy. All right, Randy.
this graph.
Sorry, Randy. Here you come.
So this is looking at the change in speed of the arm as a result of the contact. So starting here at about 2 milliseconds, the arm accelerates up to, by 8 milliseconds, we're at about 35 miles per hour. And this, you may be wondering, why are we getting more speed than what the input was? And that's because you get
smaller
the
mass.
collision
Utilize 20,
Okay,
please.
Randy.
attached 24.
4-mile-an-hour impact test. What is that?
So this is a 24-mile-an-hour impact test to the ATD arm attached to a test dummy.
Next slide, please. Why did you utilize 24 miles an hour for this test?
So it's my understanding that this is the upper end. There is a triggering event of, I believe it's 1162.2, and I think at the end of that data, the speed is approximately 24 miles per hour. So we did a test at the end point, if you will, in that data set.
What is this photograph showing in terms of the orientation of the arm and the hybrid test dummy, or ATD?
So the orientation is to depict, again, the orientation that Dr. Welcher indicated in his static and dynamic test to show what happens when again, that ATD arm that we had is attached to a test dummy and is struck at 24 miles per hour.
Next slide, please. And what is this?
So this is a thermal image of the taillights just after the install with the average temperature at about just over 33 degrees Fahrenheit.
Next slide. And what are we looking at?
So you're looking at a top-down drone video with the Lexus here on the left that will accelerate in reverse up to 24 miles an hour, striking the ATD arm.
Let's watch that, please. Next slide. What are we looking at in this slide?
So this is a top-down video from atop of the forklift, or where the arm is suspended attached to the dummy. So you're going to see the vehicle enter from the bottom into going to the top of the screen.
Next slide. What is this view?
It's just another perspective. This is a slow motion video where you'll see the Lexus in reverse. I think this one actually has kind of a long build up before it starts here.
Slow motion.
And what is this?
With the
Dr. Wolfe, I failed to ask this, it may be obvious. After each of the tests, C, D, E, F, were you replacing the taillight with new exemplar taillights that had
Of course you
been
did.
temperature accounted for?
Yes, every test had a test.
Of course you did. There's Commonwealth's best scenario. That's their best scenario right there. Why do I say that's their best scenario? Look, so when Dr. what's his name? Welcher did the testing. Remember when he held his arm next to it to get the grease paint transfers? His body, his center mass was right behind the vehicle, meaning that to get that grease transfer and have the striations they had on the arm the way that he had kind of shown it, he had to be right up next to that vehicle. So hypothetically speaking, if you can get beyond the actual lacerations or the abrasions, whatever you want to call them, the only way that the vehicle could have impacted John O'Keefe without leaving lower extremity injuries is if it hit only his arm. only his arm. It's really awkward, right? So how's it only going to hit his arm? This is the only scenario that it could play out where his lower body, lower extremities are not bruised, broken, damaged by hitting the bumper, the fender, or anything else. Oh, look at that. Wild Ian tries to appear. Look at you with service. I'm laying out the fact that this is the only scenario the Commonwealth could possibly hope for.
Hello.
There is a delay. I think there's a delay. But this is the best scenario the Commonwealth could have or hope for, is the arm being extended, but no lower extremities, no nothing. But then they lose the argument on the damage and impact. I mean, at this point in time too, if the vehicle hits the arm going at that speed and fractures, I mean, I think it fractures the elbow. I don't see that as being consistent. So what are you up to, buddy?
I am coming to you from an undisclosed location.
It's undisclosed, nondescript.
It's a fifth wheel. So
Look at that.
yeah, I am at the land. So
Yeah.
we just got here, but I do still have a sharp thing.
Maybe put that down for the moment.
No, you're gonna play more Brennan, so I need the sharp thing.
We haven't gotten to Brennan yet.
Yeah.
So we're walking through just the basic testing because I've been actually loving the science and data that we got from the defense, not from the prosecution. This is phenomenal. So
The wonderful thing about the fifth wheel is that it gives me access to things like a fridge in which I can store Clamato or a Caesar.
terrible. You're a terrible human.
I am. So,
All right. You ready to keep going? Because we're going to get to Cross soon. I want your opinion on Cross.
oh, I have so many opinions.
I knew you would. God, I knew you would. Oh,
Some of
'cause
them
it
are
was
even like ones
horrible.
that I
It
can.
was horrible.
Some of them are even ones that I can repeat on a stream.
I know. So this is like I said, this hypothetical is the best situation the Commonwealth could possibly hope for, right? This is the closest matching. If I were to say the injuries that were sustained to the lower torso and the body and the arm outstretched is the only way I can envision this possibly happening. And then that happens, and I look at the arm go undertake that force, and I'm like, no. Just no.
Yeah, well, I mean, the Commonwealth theory has some issues. Let's go with that as a gentle way to phrase it.
Yeah, just a few.
Next slide. In this configuration, was the ATD outfitted with the hoodie that you've earlier described?
Yes.
At the time you outfitted the ATD with the hoodie in this configuration before this test E, did you confirm that the sleeve, the right sleeve, was damaged or undamaged?
After this test?
No, before.
Before it was undamaged before the test.
Okay. What are we looking at in this slide?
So this is still frames from the high speed. So starting out on the left here, just at contact. So the forearm making contact with the liftgate taillight, and then the upper part of the forearm and the elbow making contact, a direct hit into the quarter panel taillight. And the middle here is just after contact, and on the right is post contact.
Thank you. Next slide, please. What are we looking at in this video or in this picture?
So
A lot of damage spread across both taillights, but also not as much damage as is depicted on Karen Reed's one taillight.
this is a overall photograph depicting the taillights subsequent to this test at 24 miles per hour. I will note that there's no damage to the liftgate taillight, and then there is damage to the quarter panel taillight.
I see a
Is there
little
any damage
Oh,
to
no.
the internal diffusers on this taillight?
So if I go to the next photograph, if I may.
Please.
Please.
You may not.
So you can see here, there is this kind of thicker, it's actually not a crack. So I'm looking at the clear diffuser here with the dots that you see. This line that you see, kind of opaque. I don't know if you've got a laser pointer to.
Run a man?
Yes.
Just so there's no confusion, thank you. So the line right here that's part of the assembly. So that's just a part of how the plastic is molded. There's a very small crack right here in the underlying diffuser, but all of the remaining part of the diffuser in terms of this portion here and here are all intact, and same with this portion of it.
What about the chrome piece that's running between the diffusers?
I don't believe that was damaged during this test, no.
And what about the clear acrylic toward the top left of that taillight housing?
It was partially fractured, but not the entire outer portion of it.
Next slide, please. What is this depicting?
So this is a photograph depicting the quarter panel taillight subsequent to the 24-mile-an-hour impact test with the ATD arm compared to that of the subject taillight.
Based on this test, were you able to reach any opinions and conclusions as to whether the damage to the subject taillight is consistent with striking John O'Keefe's arm at 24 miles an hour?
Sustained in that form.
Were you able to reach any opinions or conclusions as to whether the damage to the subject taillight is consistent with striking an arm at 24 miles per hour?
Based upon the test results, it's inconsistent with striking an arm.
On what do you base that opinion?
I base it upon the test results.
Again, I love this question because I don't have to see it. You don't have to tell me what you base the opinion on because I just saw you do the test.
Yeah.
Like I'm not dumb. Like that. This to me was so much more effective. Now we have to say a prayer for Randy. Because Randy is about to undergo some hurt. Because this is a demonstrative of what happens to the human body if the impact was square on. What would we expect to see?
Projected and slide on the ground.
Okay.
That was so brutal. So brutal.
Can you play that one more time, please? Next slide, please. What are we looking at in this series of photographs?
So this is a extract from our VBox software and data acquisition system. So on the top, you'll see the video. On the bottom is the data. So this is another feed that we had of video. This was triggered. So we do have data from this perspective. So what
Welcher is going to be triggered by all of this data. Like this is... You mean you attach accelerometers to the thing when you try to get the speed matching the thing? Like this is what I would expect to see.
I was stunned. Like the thing is that as much as Brennan's going to try to take a shot at this on Cross, the thing I kept thinking about is he's like, so does the arm weigh exactly the same amount? Isn't it possible there's a slightly closer arm weight that you could have found? And I mean, so here's the fun thing. The whole like force thing is, you know, every action has an equal and opposite reaction. The force is the same on the vehicle as it is on the arm, which means that you're basically looking at, okay, are we worried about the like, you know, what was it, 3 pound difference on the arm weight when you factor in the 6,000 pound vehicle?
Yeah, exactly. Exactly.
You know, So
Because he was
yeah.
conflating the two tests. One test was to measure the impact on the plastic, on the acrylic. The other test was to measure the impact on the arm and the forces transferred to the arm. And he conflated the two. It was dumb. It was dumb. We're going to get there. And we'll explain why
What
it's
you'll
dumb.
see is my colleague will move away from the assembly with the dry ice, and then the vehicle will accelerate in reverse.
That was my question. The blue, that's dry ice gloves.
You can't, you don't want to touch dry ice with your bare hands. So
Okay.
it's, he's wearing gloves.
Sure.
He's capturing the thermal images now.
Yes, Apocalypse Theory. You can learn a lot from a dummy. And good photos. Lindsay says hi. Just
Next slide, please.
yes, let's
And
see.
what are we looking at in this?
So these are extracted frames from that video you just saw from the data acquisition system. So on the left here is just before contact between the test dummy and the Lexus. On the right is just at contact.
Next slide, please. And what are we seeing in these series of photos?
So this is obviously during the
Devastation.
collision sequence. The body now has loaded into the lift gate and the back window. What you're seeing here is the back window shattering. And this is just a few split second later in time where, again, the body is continuing to move with the vehicle as it's contacted.
Next slide. And what is this?
This depicts the post-impact damage to the rear of the Lexus. As I noted, the rear window is completely shattered. There's deformation and crush to the liftgate section of the vehicle. The bumper step was popped out, and then there was some minor fracturing in the bumper cover at the lower level.
Did you note anything regarding the internal components of the exemplar taillight?
Yeah,
even
it
if
was
this
fucked
direct
up.
impact?
So the taillight, as you could see, it blew out the outer lens cover. I believe the part of the clear diffusers were actually still.
All right, so we get the point. We don't need to hear Dr. Wrenchler say blowing out anything else for a little while. He did that to the chat.
Go back, so we're good.
He did. And there was a full innuendo. He was like, we blow it out the back end of the gasket. And I was like, stop speaking. Stop it. So, Hank Brennan. At this point in time, we can agree that this is the most devastating witness the defense has put on, like, period, end of story, right?
Yep.
Okay. Like every other witness prior to this, Lucky, Barrows, all of them, good witnesses, solid witnesses. This right here is the most devastating witness because this witness says vehicle did not do this. So Hank Brennan needs to destroy the witness. Where does he start? How does he start?
Badly.
The Department of Defense, was that during your time or before you got there?
He starts by back at the you took
That
credit
would've
for
been
shit you
prior to
didn't
my
do.
employment, yes.
So when you were telling them about working with the Department of Defense, that really had nothing to do with you. That was ARCCA before you began working there.
ARCCA as a whole, yes, the work that we do, yes.
Not you.
As I said, I wasn't involved specifically in that project, no.
And you mentioned that you did some stuff, or the company does some things for the NHL.
Yes.
You didn't tell us much more about what you do. There's other things that ARCCA does as far as clients, right?
Certainly.
Did you share with us that you work for lawyers and law firms?
Yes, we do.
And you do litigation, insurance companies?
Yes.
Okay. Is there any reason why you highlighted?
Hank Brennan opened a door that Alan Jackson gets to close on redirect that he wasn't otherwise able to close. Hank was like, you work for other people, right? Insurance companies. So Alan gets to come back and say, you weren't hired by an insurance company, right? leaving only like one real conclusion, an agency. But the jury now knows it's the FBI. At least one person on the jury is walking back there, and the first thing they say in deliberation is, so we totally believe that ARCCA was hired by the FBI, right?
The Department of Defense that you don't do, and the NHL, but didn't share the rest of the stuff with us?
Oh, wait, I wanted to catch that. Hang on. Hank, right here. This is great. This is great. It's the dumbest question.
Insurance companies?
Yes.
Okay. Is there any reason why you highlighted the Department of Defense that you don't do, and the NHL, but didn't share the rest of the stuff with us?
Hank, let me answer the question in not a witness version, because what I highlighted was fucking cool, and I wanted the jury to hear that it was fucking cool. Like, you don't need, am I going to go through the entire company history of every case they've ever handled? And what? Yeah. I'm going to highlight the NHL and the Department of Defense because those experiments were cool. You want me to say the FBI hires me too, and I do cool shit for them?
Oh, I mean, I would have laughed so hard if it had come out. But the thing is that the defense is picking experts who aren't trying to snipe at the other side.
I know.
But I mean, if this guy was Dr. What's his name, who was for the Commonwealth, he totally would have been trying to wedge in, I was hired by the FBI. So
I know.
Yeah.
That's just some of the prominent clients that we have.
I see. You provided us a CV, didn't you?
Yes.
And that's like a resume, tells us a little bit about your education experience. You get to highlight some of the things, your accomplishments.
Yes.
You shared with us you've been the director of accident reconstruction at this company, ARCCA, since 2017.
No, not since I started.
You started with ARCCA in 2017.
Correct, yes.
When did you become the director of accident reconstruction?
I think that would have been in January of 2024, so about a year and a half.
About a year and a half ago?
Yes.
And you received your certification from ACDAR.
Yes.
Did you pass the test on both parts first time?
This is the dumbest fucking question or regular question he could have asked, especially when he put a witness up on the stand who has been pursuing his degree in general science or whatever the hell it is for 17 years. You're going to ask the man if he passed the test on his first try? Really?
1 second, I just heard noises.
Oh, go inspect the noises. Let's go inspect the noises. He's out at his property, which he has trail cameras of bears. God. Oh, at least I know he's armed. No.
I don't recall, but I think it was I had to retake, I think, the practical section in the afternoon.
Well, you would recall something like that, wouldn't you? Did you pass both parts on the first try?
Like I said, I think it was the second part I had to retake.
Well, this is a pretty important test, isn't it?
Not really.
It's your certification.
It is, but much of the
Sir, you are referring to me as Dr. Wolfe? Dr. Wolfe, like the PhD. You're now having me parse words over a certification. Do we really want to do this? Like, do we really want to have that discussion? Because I also explained to you my dissertation, which I can do again. Are these landing any points at all? Why are you starting here?
concepts that are covered in it are very elementary.
Well, not so elementary. You had a hard time with part of it, didn't you?
Well, with respect to the portion that I had to retake, it's a
That was objectionable. I'm surprised Jackson didn't jump up.
practical exam where you have to reconstruct an accident, where you have to determine approach angles, departure angles, and it can be very sensitive to those inputs. And unfortunately, if you mess up one of your first angles and you carry out that calculation, then the whole problem is graded wrong, even if you did all of the math correct.
So we understand there's a multiple choice question part that's the easier part, correct?
I don't know if it's easier, but there is a
Bro, anyone who's ever taken the bar exam, There's a multiple choice part and there's an essay part. And if you're telling me the multiple choice part is easier than the essay part, I'm going to say for what percentage of the population? Because there's certain people that cannot pass the multiple choice part that can pass the essay part and vice versa. So stupid fucking question. J. Michael RN, board exams are crazy hard. Missed mine by 3 points. All the love to Dr. Wolfe. Yeah. I know people that failed the bar exam the first time and second time who are damn good lawyers. These certification exams don't mean shit. They really don't. I don't understand this question. Like, is this scoring points?
It's a multiple choice part.
There's a more practical part where you actually have to go out in the field and do assessments, kind of like things that you did today.
You don't go out into the field, no.
And, when did you first take that second part that you did that?
I don't recall.
You don't remember when you took the test?
No, I don't.
Suffice to say you took it again.
Correct.
And ultimately you passed both sections of that test?
Yes.
In your CV, you list your schooling and you list your degrees, don't you?
Yes.
Did you lie about any of those degrees or your schooling in prior versions of your CV? Hank, move on. This, I am sure the jury is like, really? Really?
You mentioned some of the things that you focused on in your academic experience, don't you?
Yes.
And you have publications.
Correct.
Recently, you did a publication regarding vehicle control history on Toyotas.
Correct.
Vehicle control history is data that is stored in a vehicle,
Yes.
and Toyota owns Lexus, correct?
Correct.
So you have familiarity with vehicle control history. In fact, you have a publication on it.
Yes.
In your entire resume, you only mention pedestrian collisions or that you're involved in pedestrian type events 3 times. Is there anything specific?
Tell you how stupid this question is. In my entire resume, I only mentioned that I handle, I don't know, God, what is a good example? I mean, think of the number of cases that I handle on a daily basis or a weekly basis or a monthly basis. And the specific subset of those cases. On my entire resume, if I'm answering or providing 3 exemplar cases that deal with a specific issue, are you thinking that's a few cases or a lot of cases? If I'm giving you a highlight reel in my CV. 3 cases involving pedestrians it's a lot. That's a bunch. Grayspace asks, this test is just graded badly. No partial credit? I don't know. I don't know how the test is graded. We don't know by the question because it doesn't give us the context.
Specific in your resume or your publications that show a published accomplishment, for example, in pedestrian collisions? Do you have any publications that have been peer-reviewed or published in that area?
No, I don't have any publications in pedestrians.
You write or you note areas of specialty and you list a bunch: accident reconstruction, human factors, EDR, commercial vehicle, HVEDR, pedestrian bicycle accidents, nighttime visibility, and a number of others, correct?
Correct.
Is there anywhere in your resume that notes particular classes that you've attended and completed regarding pedestrian collisions?
No, I haven't taken any classes in that.
You haven't taken any classes on pedestrian collisions?
No.
Have you ever taught regarding pedestrian collisions?
No.
Have you ever been a speaker in a presentation about pedestrian collisions?
Yes.
Okay. Is that listed in your resume?
I don't list lectures or presentations, no.
You were asked questions about your involvement in this case.
There you go.
Yes?
Yes.
And you had shared with us that you, at the beginning, were working for a separate party or a third party, you said?
Yes, another agency.
Another agency. And at some point, you came in.
If I am the defense, I am working my ass off over the weekend very much to pull a transcript of every question Hank Brennan asked in this regard, because I think that Hank Brennan asked these questions in a fashion that I am arguing like hell opened the door for me to give a further explanation. The condescension in his tone. It's like it's an open invitation for the jury to speculate that they are some nefarious agency somewhere in the world. Even the way he asked it. I think Lolly stayed way the fuck away from this. But Hank is playing a game of fuck around and find out, and it feels horrible. Like, I want a sidebar and I want a motion. I'm going to put it in writing, and my word. Like, he's skating that line. Trying to mislead the jury about insurance company. Oh, this other agency, this magical agency that came in and gave you this information. Hank, you know damn well what this agency is, and you're playing a game with it. Lolly stayed away from that. Hank is tiptoeing a line that I think is pretty unfair, and at the very least, I want on the record that I wanted that to be known.
To court and testified last year.
Yes.
And during the time before you came in to testify, you weren't wholly independent of the defense, were you?
Well, certainly before all of our testing, at the point at which we did all of our testing, report, and analysis, as I mentioned on direct, I didn't know the Commonwealth or the defense in this case.
It's dodging the question. He dodged the question. He did a good dodge, but he dodged the question. The question was, you weren't wholly independent of the defense. That was a shitty question. It wasn't phrased right. Could have been phrased better. Hank does this repeatedly, but Wolfe dodged the question. Don't kid yourself. He dodged it.
My question, more precisely, before you testified.
And that is a less condescending way of coming back and saying you dodged the question. That is an appropriate response when a witness dodges your question. You're supposed to say, my question was this. Wolfe.
So,
yeah.
you wanted my take on the cross-examination.
Yes.
He lands a
Big
few
screen.
minor points, but he is a total jackass in the process.
Yeah.
And what do you call it? The other thing is that I suspect that the jury just finds him to be absolutely obnoxious. But I also, at this point, need to bow out. I've got Mrs. Runkle right there, so she and I are going to spend some time. And but yeah,
Please do that.
This is me logging in from an undisclosed location. And
I'm gonna speak very loudly into the microphone. Hi, Mrs. Runkle. We miss you. I miss you. Good.
He is waving.
Good.
And Zora and Potter are running around like idiot. Well, Potter is now on the couch. He's a little nervous about being out of the city. So hopefully he's gonna get over that. But yeah. Anyway,
Good. Run. Go do
yeah.
your thing. Hang out. Have good time.
And we gotta hang out sometime soon.
I agree. I agree.
Any chance of you making it to Vancouver in July?
I will be just south of there in July.
Ah, that is unfortunate because
I
being just
know.
south of there means that it's probably not able to dip up. But July 12th, if you're is my.
Oh, is that the
Vancouver-
meetup date? Is that the meetup
Yeah.
date? You guys in the chat, Ian is doing a meetup. I want to. Ian is doing a meetup on July 12th in Vancouver. July 12th, right?
Yeah.
Okay. I'm sure he's going to post that on social media. I will continue to further that and post that. If you are local to Ian anytime around that time, make the effort, get there, hang out with him. It's worth the drive.
So, but yeah, we'll have to figure things out soon. But for right now, I will let you go and good night.
Be good. Have fun.
Cheers. Bye.
Bye.
And somebody says we'll ever come to Vancouver Island at some point, but I'm not sure when. So
see you, buddy.
Yeah.
All right. That's fun. I'm glad he's having fun. I'm glad he's getting out and having a good time. He works really hard. And this land is a really cool thing that I was really glad he got to do. Really glad he got to do. And I know he was super hesitant about it. And seeing it come through and seeing how excited he is about it, it's pretty freaking cool. So I like when I see him post his trail camera photos on Twitter and elsewhere, you just get the excitement. You get the sense of the excitement. Like he loves it. So I'm really happy for them. I'm glad they're there. Good. Enjoy the evening. Wonderful.
Before you came into court and gave your testimony, you weren't totally independent from the defense, were you?
No, I mean, I had to communicate with them to be able to determine when to appear for testimony.
So you were communicating with them, yes?
Yes.
And in fact, some of the time that you spent, ARCCA actually billed the defense for, and they paid that bill, didn't they?
Eventually, after the trial, yes.
During that time, you know what a sequestration order is, don't you?
Why didn't he get the bill in? If I'm Hank Brennan, why are you not getting the bill in? Why are you not getting the money for the appearance? Like, ask the question. If you've got the red meat, go after it.
Yes.
Do you think that you're under a sequestration order today?
Yes.
Did you talk to anybody about any of the prior testimony in this case before today?
No.
How'd you get here today?
How did I get here today? I took a car ride over from the hotel.
Who drove you?
It was a driver. I don't know his name.
Who set up the car?
It would have been someone on the defense team.
Was it like a window, like a limo?
It was an SUV.
Was there anybody from the defense with you on the ride over?
There were 3 young ladies in the back seat. I think they might have been interns and Mr. Woke.
And who?
Mr. Wolke, I think is it pronounced? Am I saying it wrong?
Have you discussed anything about this case before your testimony today as far as the trial?
Before today?
Yes.
Yes.
Have you discussed anybody's testimony in this case?
Nobody's testimony, no.
That was different last year, though, because before you testified last year, you did have discussions about testimony, didn't you?
Not with the Commonwealth or the defense, no.
But I'm asking, though, you did have discussions about testimony before you testified last year, right?
Correct, yes.
And you know what a sequestration order is, don't you?
Yes.
He wasn't subject to the sequestration
After
order
you testified last year, the court ordered you to provide all of your text messages, all your communications with the defense, didn't they?
Yes, earlier this year.
And when you were ordered to provide all of the actual verbatim communications with the defense, did you provide those communications?
Yes, all of the records that I had at the time I provided.
Well, not the records. You know what I'm getting at. Did you provide the communications?
I provided everything I had in my possession, sir.
A text message isn't just a time and date. It's actually substance when you text somebody, isn't there?
Correct.
And when you texted, how many texts do you think you had with the defense?
From what I recall, I think it was around 50 texts that I sent.
It wasn't 100, it was 50?
Well, I think it was around 100 total in terms of back and forth, but it was, I think, 50 that I sent.
And during those texts, communications, conversations, correct?
About logistics, yes.
Did you
This is the downside for Hank Brennan's part. People talk about how Hank Brennan got a bite at the apple. He got his voir dire, right? This is the downside of Hank getting his voir dire. The downside of Hank getting his voir dire is Dr. Wolfe knows it's coming. Dr. Wolfe knows how Hank is going to try and use it. And Dr. Wolfe anticipates the question being asked and is smart enough to basically respond without appearing defensive or like he's obfuscating the issue. Comes and says, I gave you all the records in my possession. And it's most important when it comes to the next part of questioning here.
provide the content of those text messages when you were ordered to by the court?
Well, those text messages spanned from, I guess it would have been April or so of 2024 through May to June of 2024. Ultimately, I think I received the court's order in May of this year, April of this year. So it was a year after the fact, and I had already deleted the text at that point.
How many of those text messages did you delete?
I just swiped the conversation, so it would have been the whole conversation.
Not how you did it.
There you go. When I say the voir dire is going to come back and bite you in the ass, that's what I mean. In the voir dire, Hank was allowed to make it sound like he deleted 50 separate messages, right? And Wolfe, being kind of caught off guard, is playing defense on that. This answer makes sense. Makes sense to me. Like, it very much makes sense to me. I have questions. I have chats in here. So we'll get to this in a second, but very routinely, I go back through my old text messages with old clients and I delete them for very good reasons. I don't ever want them coming up because that's client privileged material. Like, I don't want it there. But if you're simply swiping a communication or swiping a line of text messages, like on your phone, when you're looking at it, it's a text message chain with, Bill Nye the Science Guy. And now the entire chain is gone. We do it all the time. It's now in the minds of the jurors. And it's not like he deleted all these messages. He just swiped the conversation. Depending on the age of the jurors, that doesn't sound like anything.
How many of those 100 or so text messages did you delete, sir?
It would have been the whole text chain. I didn't individually delete them. It just, when you swipe, it just deletes the text chain.
After you deleted them, did you go into the recently deleted and then delete them so they were unavailable?
There's no recently deleted. When I delete a text chain, I don't have a recently deleted. Right? Like on my phone, I don't have a recently deleted. Do I have a recently deleted? Like if I delete a text chain right now, let me see. Yeah, when I say I'm busy, like the anxiety I have looking at the number of unread text message communications, where's a spam one? Because there's tons of those. Oh, there's a good one. Delete. Bye-bye. Delete. Do I have a recently deleted? I don't think so. Recently, I don't think I've got recently deleted text messages. Where? There's archived and there's deleted. No, I'm not under. Wait, if I go to edit and I say, oh, I'm going to learn something today. Hang on. Edit. Ooh. I didn't know that. Look at that. Well, holy crap. How long has that feature been available? That's interesting. And when does it auto purge? If I go to edit, I can say show recently deleted text messages. Huh. I didn't know that. Interesting. Very cool. I'm learning something. Now, I'm going to use that with use that. It's pretty good. So,
I don't recall doing that.
You were asked to search your records.
Yeah. If you ask, here's the thing. If you ask me to search my records and be like, hey, so Rob, search all of your text messages. I'd be like, I did. I don't see anything. And they say, did you search your records? I searched all my records. Someone's going to have to get to me and explain to me the process of, did you search your records? Did you also search your recently deleted? Then I'll say, how do I do that? And then they would explain to me that I can do that. And if you explain to me that I can do that, I'm going to do that. And I can tell you I have searched those records too. But without explaining that's the process, you're just assuming that I know how to do it. I don't. And I'm not. Am I expected to know how to do that? Is that the expectation? No, but I am absolutely and unequivocally going to use that in my damn cases. Oh, baby. Huh. Rob learned a new skill. Oh, that's going to be dangerous. That's going to be fun.
Text messages, did you do a thorough search to see if you still had them or whether you had destroyed them all?
I checked my phone, and I also checked with my phone carrier.
So do you know if they were still under the recently deleted part of your phone, or did you go and take that extra step and totally destroy them?
From what I recall, I did not find any of the text messages, no.
Is there any reason why you deleted all of your text communications with the defense?
Well, it's something that I routinely do. I work with attorneys and clients all the time, whether it's appearing for trial or inspections, and I don't have a habit of keeping a text chain that talks about logistics and things. It's just I routinely delete them after that communication is over with, and certainly after the prior proceeding, once it had concluded, there was no reason for me to preserve those.
Okay. And so, at some point, you switched from text messages to another form of communication, didn't you?
Yes, earlier this year.
Tell us a little bit about this new form of communication, not text messages.
So Mr. Jackson had indicated that he and his defense team utilized an application known as Signal for their communications amongst their defense team. Ultimately asked if I would also use that application to communicate, which I agreed
I also use Signal. Side note.
to.
Is Signal an encrypted app?
It's a secure encrypted app, yes.
Are iPhone iMessages encrypted? They're encrypted, yes. Are RCS messages encrypted? They're encrypted, yes. Encrypted. Is Snapchat encrypted? They're all encrypted. Everything's fucking encrypted. Everything's encrypted.
It doesn't leave any records, right?
I don't believe so, no.
Well,
False. It does. It depends on the settings that you have. I don't know. One of the... I use Signal. I use Signal a lot. You know why I like using Signal for certain things? One, because Signal has a desktop app or a web app where I can actually go from computer to computer where I'm more efficient at typing shit, and I can type it on my keyboard and I can have communications. I have Signal open right now. It's sitting right there. They don't auto delete. They're just there. I'm seeing the chats. They're right there. I have several communications with Signal. Am I engaged in some nefarious conduct because there's Signal on my computer? No. It's a messaging platform. And to be candid, I understand why. Are my phone calls recorded? Every phone call communication? Is it all recorded? Is every conversation I have, is it expected that I record those conversations? No. But Boogeyman must be Boogeyman. I don't like stupid arguments.
you're using it. Do you have any records from your Signal use?
I'm going to allow that.
Do you have any records from your Signal use?
I do not, no.
So you know full well that Signal is an encrypted app, leaves no record.
There may be a setting that you can...
Hank, know the answer to your question before you ask it, dumbass. Sorry.
change. I just know that the way that it was set up, there was no record.
Well, who set yours up to have no record?
I don't know. I think it was default.
Have you ever checked your Signal app to see if you have any record of your communications pursuant to that court order?
Well, I don't have the application anymore, but at the time I did check the application.
Out of all these clients that you've had, how many times or how many clients would you use Signal with?
This was the first time.
Have you used it since with other clients?
Not yet, no.
Before you
It's
testified
just dumb.
last time, at the last proceeding, or should I say when you testified at the last proceeding, kind of like today, you attempted to portray yourself as totally independent, didn't you?
Argumentative.
Sustaining that.
When you testified at the prior proceeding, did you attempt to portray yourself as totally independent?
Argumentative.
Yes.
The truth is,
I would have argued
before
against
you
that.
testified, you were communicating with the defense and attempting the best you could to assist their cause, weren't you?
I wouldn't characterize it that way.
So before you testified, you wrote out questions that you thought could help, that you should be asked when you testified, correct?
So something I routinely do before testifying is prepare an outline of topics and questions that would best help be able to get out my opinions in the analysis I undertook. Ultimately,
Oh, Dr. Wolfe, you prepped the fuck out of that answer. Come on, sir. Come on. You knew that question was coming. And you were like, here's my monologue in response. Don't lie to me. Come on. I love your analysis, but look, like, come on, sir. We know this.
Correct?
So something I routinely do.
It's a great trick. So something I routinely do. No. Kind of falling in the trap a little bit here. You're jumping ahead of the question, and I applaud you for the effort. But way to go.
Before testifying is prepare an outline of topics and questions that would best help be able to get out my opinions and the analysis I undertook, ultimately so that you all have an understanding of what I did.
So I'm asking you a question. You gave the explanation, but you're skipping over the answer to my question. So
Sustained.
I'll ask you again.
It's argumentative.
Before you testified, did you write out?
Brennan, let me tell you what happens if I am in a courtroom and I run through a judge's objection like that. When I run through a judge's objection, if the judge sustains an objection and I immediately just keep talking, if I just keep talking, I get chewed out. I get stopped mid-question and chewed out. And this is the most minor of the offenses he does in this cross.
Out a list of questions that you wanted to be asked.
It was prepped under voir dire too. It was prepped. Y'all are being shitty to me. It was prepped. It was a prepped answer. You guys know it was a prepped answer. Don't fight me on this. It was a prepped answer. So I routinely do this in all these cases. It was non-responsive. Like I said, I'm going to call it both ways.
Yes.
And when you listed out the questions, you also listed out the answers, didn't you?
A general response. It wouldn't be verbatim to that.
Let me tell you why. Because what's good for the goose is good for the gander. So what if it was a canned response? So what? What's good for the goose is good for the gander. If I am asking an individual on the other side of the aisle to answer my question and my question only and answer the question I'm asking you, and I have the right to ask them to answer that question and that question only, I can't be mad at them when they go outside the scope of my question and then be happy when my witness does it in response. That's not how judges should view it. Basically, it's consistency. It's basically just saying be consistent in your rulings. And not just that, but sorry, I got sidetracked by the chat. The question is asked. Answer the question. You can say yes, but, and you can go on with the explanation and say I wasn't done giving my answer, or vice versa. Now, there's different witnesses that do better at it than others, right? So Welcher was obnoxious in the responses. He would fight the premise of the question. This was just a very smooth response. This was delivered well. That's why I said it was prepped. It was delivered well because it doesn't seem evasive unless I'm the lawyer asking the question and you didn't answer my question, because I want you to answer my question. And then I want to get a specific question after that fact. Go back and watch any one of Alan Jackson's cross-examinations and come to an issue just like this. Just like this. And Jackson, at the end of a monologue, will come back and say, but you didn't answer my question. This is how that works. I don't know how to give you guys a different read than that. You want to talk about law? We can talk about law. You want to talk about the application of evidence and evidentiary rules? We can talk about that. That's what this is. It was non-responsive. Now, how you respond to that as the lawyer is in your control. Jackson handles it better than Brennan does. Brennan becomes condescending. Brennan becomes an asshole. Jackson pushes. Jackson fights. Brennan goes sarcastic and stupid. That's the difference.
Did you list out the answers to each and every one of the questions that you had prepared?
Yes.
So for every question, there's an answer that you provided so that you could follow a script, so to speak, yes?
I wouldn't characterize it as a script.
One of the questions asks, so not being able to inspect vehicles is something that's not uncommon in your line of work? And your answer, absolutely not. Remember writing that out?
Yes.
And you put a footnote, a comment. And you said, not sure if you want to put this somewhere in direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case. You write that?
Yes.
When you're talking about they, I have a feeling they are going to argue I didn't personally inspect the vehicle. Who's they?
That'd be the Commonwealth.
And so when you were writing out these questions as is your routine with the answers, is this the mark of independence to you?
Well, I think, again, whether the Commonwealth asked me that question or the defense asked me that question, my response would be the same. It wouldn't change depending on who called me to testify. There are a number of cases, by the time I get involved, the evidence is gone from the roadway, the vehicle is gone. So it's certainly not necessary to inspect a vehicle. And I wanted the jury to have an understanding that because I didn't physically inspect the vehicle, it didn't affect my analysis in the case.
So you think that showed independence?
Yes.
Then you also had another question. Would it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? Remember that?
Yes.
And you said, yes, unfortunately, there is a direct correlation between time of day and pedestrian fatalities. Is that true?
Correct. Yes.
Do they happen more often in the day or at night?
More often at night. Yes.
Statistically speaking, by the way, this case involves nighttime, doesn't it?
Correct.
Statistically speaking, most of pedestrian fatalities occur during the evening and night hours. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Did you write that?
Yes.
In fact, you testified, you shared that with the jury, didn't you?
Correct. I've testified to that twice last year as well as this year.
And in the notes that you wrote, when you shared it last year and this year, was it an important point to the jury?
I think so, because it helped gave them an understanding, I think, of my background and lighting and human factors. And as I mentioned earlier today, there's a direct correlation between time of day and pedestrian impacts, right? So my specialty in lighting and human factors results in me seeing many, many different types of pedestrian impacts.
So if it's important, why did you include a note? If you don't want me to say this, that's fine. Why did you include a note to the defense that if they didn't want you to say something that you thought was important, you would...
I hate that Brendan does this a lot, and it pisses me off. He asks a question and he keeps asking a question. Like, he asks a question, then why? And then he keeps on asking the question. Ask the question and let them answer.
leave it out.
Well, I think because I didn't want to confuse the jury about a statistic that just because we have inclement weather and dark lighting conditions, it doesn't automatically equal a pedestrian impact, right? We have to look at the evidence and the damage to the vehicle and the injuries to determine whether or not a collision occurred, not the visibility.
So you weren't trying to mislead the jury, you were trying to help them because they wouldn't understand something that you were...
Maybe I would have prepped an answer to this one. No, I was trying to prevent the lawyers from misleading the jury with a statistic and implying the statistic had more relevance than it did given the factual scenario that was given to me. That is the best answer. No, I wasn't trying to mislead the jury. I was trying to prevent the lawyers from either side from misleading the jury using a statistic that didn't apply in the way that they wanted it to apply. Because statistics can be used in any number of fashion, any number of ways to corroborate a fact, to corroborate a theory, or they can be used to mislead the jury. So I wanted to get ahead of that and prevent the lawyer, any lawyer, from trying to use a statistic to undermine my own analysis. Ooh, well, that's remarkable.
trying to explain? Is that the way you're phrasing this?
I think at the end of the day it was to help them understand my background, how it relates to seeing a lot of pedestrian impacts.
Something is important, and it helps the jury get to the truth. Why would you offer to leave it out?
Well, I didn't leave it out.
No, but you offered to. You would have if requested. Why did you invite?
The answer to this one is, if I didn't think the lawyer was going to be misleading, or if the lawyer wasn't misleading and citing that statistic, then you wouldn't need to ask the question of me. If the lawyer wasn't misleading and trying to use the statistic to make a false premise to the jury known, then you wouldn't have to ask me that question. It's a pretty simple answer. It's just, I don't like the question. It's not a fair question. It's not phrased in a fashion that can be fairly answered.
Excuse me. Why did you invite somebody else to interject in your independence and guide you to lead something out? Why
Right
did
there.
you provide that invitation?
Yes.
Again, it's because I didn't want them to get hung up on a statistic that just because we have more pedestrian impacts at night and in bad weather, that this alleged incident happened at night under bad weather, to give it more weight, to weight the evidence more because of that statistic.
You done?
Yes.
There are certain times as a lawyer when you can use a remark like that. I'm going to go with the gut instinct for 99% of lawyers is never. Never. The gut instinct in your head should always be, never do I have enough swag, enough riz, enough credibility with the jury to pull a fucking stunt like that. You done? Are you done? Now, I've said some things that are probably borderline, like repeating back the answer in a very condescending tone to the witness. When it's like, I absolutely had to spend that $5,000 on this thing instead of paying child support. Oh, you had to spend that on the thing instead of paying child support. I've done that. I don't think I've ever used the, are you done? Or over here. Never. And here's the thing. Is it improper? Do you have the time as a lawyer to object to something like that in the moment? It's difficult because you're being attentive, but it's not easy to just jump up and object all the time. Plus, sometimes it's one of those where, do I object? That's a judgment call. Do I object to that? Do I object to that? Or do I let it ride? The condescension, the credibility you have to have with a juror, or in my case, like with a judge, like if I'm cross-examining an adverse witness, if the first or second question out of my mouth and they start answering and I say, you done? I'm going to get my head chewed off. But let's say that I've gone through the ringer with this witness for the last hour and a half and they've been evasive the whole time. And then I throw in one of the, you done? Then the judge is going to give me a little slack. Because the judge, I've built credibility. I've withheld from making snide remarks and condescending remarks the entire time. I've sit there and I've been a good boy and I have not yelled at the witness or demeaned the witness until just now when they kind of forced my hand. With the jury is the trier of fact. They're sitting there and watching you. And if you're scoring points and putting points up on the board, and if it's becoming clear that you are consistently treating witnesses in a fair manner and they are being unfair to you and you are fighting back, then you've built credibility. You can do that. You can pull that maneuver. You can say, are you done? And the jury is going to sit there and say, look, this lawyer's put up with a lot of shit the whole time. They put up a ton of crap. I'm going to let him say that because I feel it too. Very, 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 very rarely does that happen. Usually, what the judge looks at me as and what the jury looks at me as, or what anyone looks at you as asking that question, you done, is, all right, asshole, slow your roll. Almost always. Even in bench trials, when it's very clear the witness has been lying the whole time and I pull a stunt like that, you done? The judge is going to say, Miss Morton, cool your fucking jets. They're not going to say it that way. They would want to. And there's one judge who might. But they would basically say, we're not doing that. This is, and it's the constant tone. And it's like, he can't understand it. He can't get it. This might appease some of the people sitting in the gallery, but you're not trying to appease the people sitting in the gallery. You're trying to convince the jury. And I can't see them. What would Judge Girardi do? That would not happen. Let me give you an example. Did it happen in the Depp trial? Did you see it happen in the Depp trial? No. Did you see it happen at all? No way. The worst you got was like a Rottenborn comment here and there. No, she didn't let that crap go. No way am I getting away with that in that courtroom. And I'm not even trying. And you learn real quick not to try. I would get my ass handed to me. And I'm telling you, every judge in Fairfax, I would never pull this bullshit in front of any one of them. None. There's certain judges that piss me off a lot, but no, I'm not pulling any of this.
If you make a mistake in court under oath, would you take the affirmative step on your own and correct that mistake?
I'll allow it.
I would do my best to do that, yes.
Well, when you say do
Shouldn't
best,
be
would
allowed.
you do that? If
It
you
shouldn't be allowed. That was impermissible. It was an impermissible question. Impermissible question, because the witness is not under any obligation or prerogative to answer or correct a mistake made on the record. That is the lawyer's obligation. The witness has no obligation to the court. There's no ethical duty the witness has to the court. The lawyer does. The lawyer has the obligation to correct mistakes made. That question should not have been allowed. That is a bad question, and we know it's a bad question because it was not applied that way when it came to the Commonwealth's own witness.
became aware of it.
I'm going to allow it.
Yes.
Before you testified in a proceeding last year, there was a hearing that you testified in front of Her Honor and other people that were here, correct?
Correct.
I wasn't here.
No.
You were.
Yes.
And you testified about your experience, didn't you?
Correct,
When you were
yes.
sharing your experience with the court, it was important for the court to have an accurate understanding of what your experience was because it was being evaluated in that hearing, wasn't it?
Correct.
When you testified to the court, you testified that you had been qualified as an expert to testify over 20 times, didn't you?
I don't have the transcript. I believe I said
dumb.
approximately 20 times.
The reality is you hadn't. You'd only testified and been qualified 11 times at that point.
Correct. I misunderstood the question. I thought it also encompassed deposition, so I added those two and approximated at 20.
And at some point when you realized you had made a mistake in your testimony to the court, you had a chance to come back when you testified last year and fix it and clarify the record, didn't you?
Correct, which is why
You mean like the witness that tried to clarify their own statement, and because the lawyers didn't ask the question, and because you didn't actually bring up the affirmative question to correct the error made, that it didn't happen? This is a not thing. This is a problem. It is a problem.
I provided a comment with the specific breakdown for clarification.
And when you came back and testified under oath the second time, on the record under oath, did you clarify and fix the mistaken testimony that you had provided 2 days earlier?
I don't recall being asked a question. No.
It wasn't whether you're being asked. The question is, did you take the affirmative step?
This should not be allowed. This should not be allowed. This is an impermissible question. When in any court proceeding have you ever seen a witness simply start speaking and offering something to the court and not get immediately shut the fuck down? When has that ever occurred in any court proceeding ever? Never. You know why? Because witnesses answer questions by lawyers and judges. That's what they do. When they do not answer a question, when they are not answering a question, we say non-responsive and they shut up. Never is a witness allowed to walk into court and be like, hey, so judge, this is my opinion. I'm going to go ahead and recite all the things I want to recite without any evidence. Here, blah, 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 blah. No. 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 This shouldn't be allowed. You can't ask that question. This is probably one of the more egregious errors that Judge Cannoni made today. Like, this is improper impeachment. If you want to say that he mischaracterized his experience, then ask the damn questions that way. Don't ask the questions that somehow tells the jury that a witness has an affirmative obligation to correct misstatements. Don't do that. It is horrible.
The misstatements under oath that you made. Objection.
I'm going to allow it.
Move your motion.
Sure.
That's a bad allow. Like, are you kidding? That is stupid. And Brennan gets to come back and ask it again.
Yes.
In fact, you made a note. I realized in my testimony I said about 20 times when you asked how many times I'd been qualified. I misinterpreted your question, which was my fault, but in looking at my D&T list, it's 11 trials, 7 depositions, 18 testimonies total. Not sure if you want to clear it up or just leave it.
Yes, sir.
Could you just leave it?
I'm not responsible for asking the question, sir.
That should have been the judge's ruling. Why is Dr. Wolfe saying that? That was a bad ruling. That's a bad ruling. That's a bad ruling and a bad line of questioning. I usually try to cut slack where I can. That right there was misleading. You can't allow that to happen. And I know that people are pointing different things that happen in this trial where this happens a lot. I get it. I understand that. I will give a lot of grace. I will give a lot of leeway to one side or the other. But when I see something like that right there to me is a massive red flag. I want to focus on that one that I think is very improper. Exactly. Kristen TM, this is the point I was making. One expert tried earlier. Do you know what happened? They weren't allowed to because that's not how testimony works. You can't walk in and just say as a witness, unprovoked by a question, hey, so I'd like to correct something that I said yesterday. No. Even Judge Cannoni was like, no, you're not doing that. No way. Yes, exactly. I agree. Not Sarah. Why is she allowing this? She shouldn't. It's not proper. It's really not. It's a mess. Oh, we're at the other one.
Do you ever heard the terms confirmation bias?
Yes.
So Hank Brennan, apparently, I guess within his script, he's got I'm asshole phase, and it's like written into like the first half of his questions where it's like, I'm going to be an asshole during this phase of questioning. We're not out of the I'm asshole phase yet. We are still in the I'm an asshole phase, where I'm going to ask questions that are not relevant but are very improper and all of the things. Oh, this is the one that pissed a lot of people off today, and me included.
Do you know what confirmation bias is generally?
Generally, yes.
Do you think that you suffer from any confirmation bias in this case?
No.
Do you have any close family that...
Okay, so at least when Bob Alessi asked the question about confirmation bias, Bob Alessi understood what confirmation bias was. Hank Brennan doesn't. Hank Brennan just says words. He says words he doesn't know the meaning to. Hank Brennan, I would Have we reached the stage of trial where I'm that frustrated right now? Are we there yet? Are we at the point where I can make a conclusion on a lawyer and all the other things? Have I earned that credibility with this jury, the audience, to make an opinion like that? I think Hank Brennan might be a very talented attorney in that he can ask questions in a certain way and make argument and do a lot. I don't think he has... I'm not questioning his intelligence. But I don't think he understands half of the concepts serving as the foundation for the questions that he is asking. Because the questions are asked in a manner that is rather inconsistent with the underlying premise of, I guess, the first part of the question, the foundational part of the question. Are you familiar with confirmation bias? What is confirmation bias? Well, you are undertaking certain things to the disregard of every other thing that would suggest that this is the actual thing. You're disregarding all of that. And instead, you are leaning into this. You're disregarding that because you have a bias towards this one thing. You are basically disregarding, you're explaining away all of the negative things, and you are embracing all of the things that are positive towards what you want, towards your outcome. He is implying, and he's giving the foundation the question of, are you aware of what confirmation bias is? Okay. So in this question, when I would say, Dr. Wolfe, are you aware of confirmation bias or what that is? So when the FBI approached you and they said, we don't think this happened this way, did that distort your analysis? Did that lead to how you crafted your questions, how you crafted your experiments? At that point in time, I can understand the confirmation bias argument, because at that point in time, the FBI has given you what they perceive and believe to be the proper outcome. And I can see that you might be saying, I'm disregarding all the negative inferences and I'm going only with the ones that want to confirm that bias. This is not the proper way of doing it.
It supports one side over the other, not the.
No. Yes.
Do you think that you suffer from any confirmation bias in this case?
No.
Do you have any close family that supports one side over the other, not the facts of the data, but one side over the other?
Close family?
Yes.
Not that I'm aware of, no.
Why would you ask that question? My brother, whom I love dearly, might have very strong opinions. Does that impact my opinion? Is there any connection that I would even know his opinion because he's close family?
Wife?
My wife?
Yes.
I don't really know what her thoughts are on the case.
May I approach?
Yes.
Have you looked at that document? Have you seen that before?
No, I have not.
Never seen that.
No.
Take it back.
My wife, like really? I'm going to reach a conclusion in a case because my wife has an opinion. I'm going to put my entire scientific background, education, experience, all of the goodwill I've built up in the community, all of my past testimony, because my wife might have an opinion on who is guilty or not. Are we not, is this not 2025? This is 2020. Yes, it is 2025. Are we not allowed to have different opinions in a household? Speaking rather emphatically for this household, we're allowed to. We express them all the damn time. In my household, we express our differing opinions quite frequently, and sometimes rather emotionally. Rather loudly. Not loudly. No, we're never really loud. But we have different opinions about all types of topics. Where the proper allocation of public resources should go, proper tax policy, proper education costs, what should be taught in schools. I mean, everyone has disagreements, guys. You gotta be kidding me. Because my significant other who resides in the same home has an opinion on a trial, I am supposed to form the same conclusion, and I am supposed to be presumed to disregard certain facts in furtherance of that conclusion? That's stupid. It is dumb. And it's improper.
You're unaware of anything that may influence you to lean one way or another?
Yes.
Correct.
When you first took a look at some of the facts in this case, you had some information. Since then, you've received a lot more, haven't you?
Correct, yes.
Part of
It's so maddening because the cross is so bad. I want to spend more time on it. Let me get
your
to the other
testimony
points.
today to
Let's
this
see.
jury was to provide opinions that you do not think that the holes in Mr. O'Keefe's clothes are consistent with some type of collision. Is that fair to say?
Yes.
In coming to that opinion, you relied on some of your testing that we saw in those videos, didn't you?
Yes.
And that testing involves a hybrid 3-arm, doesn't it?
Correct, yes.
A hybrid 3-arm is an arm from a crash dummy.
Yes.
That's not the technical name, but that's what it's often referred to.
Yes.
And you and Dr. Runkle have been working together on this case, haven't you?
Yes.
You've discussed ideas and shared thoughts.
Yes.
In fact, you've worked so intimately together, you know some of the things he's going to testify if he comes to testify, you've said many times today, right?
This is Hank Brennan trying to pull in Alessi, just not very artfully. Alessi would constantly do this. He would basically try to impeach another witness through the witness testifying prior to that witness. He did it all the time. We talked about it quite frequently. So this is the inartful approach to pulling an Alessi, trying to basically cross-examine a future witness via the witness on the stand.
Yes.
And so some of the data that you shared, and some of the opinions overlap with each other, wouldn't you say?
Certainly, he's going to rely on a lot of that test data, yes.
When you were forming your opinion about holes in clothes and potential abrasions to somebody's skin, all of those tests, all of those that you did, were using a crash test dummy arm, weren't they?
Yes.
In your report, you cite, or Dr. Runkle cites, 3 different sources regarding testing clothing and skin, correct?
I'm not sure.
Well, haven't you read his report?
I've skimmed it, but I don't know what the basis are for his opinions.
Did you see footnotes 24, 25, 26, 24 being skin tissue cutability and its relation to lacerations, severity, indices? Did you read that?
Let's see if there's a foundation.
No, I didn't.
There's no foundation. He just read. This is a bad ruling too. There's no foundation. There's no foundation. He just said, I am not familiar with the basis of his conclusion. I'm not familiar with that. He said, I have skimmed his report. I am not familiar with his conclusions or the basis for him reaching those conclusions. He just said it. He said it. In the rule of this court, how we are cross-examining experts is if they have not considered it, if they don't know it, if they haven't referenced it, then we can't ask about it. That's the rule that Judge Beverly Cannoni set down. This is violative of her own rule. It's violative of her own rule.
Read that reference.
Did you read 25, the book that is cited, Forensic Pathology, 2nd edition?
I'm going to have you come to sidebar.
And oddly enough, he gets to get back into this. I don't understand. This is inconsistency that is this is a demonstrative example
Ask you about this book that is
of
cited in Dr.
inconsistent
Runkle's
rulings.
report. By the way, have you read Dr. Runkle's report?
As I mentioned, I skimmed through it.
So in all of your preparation with Dr. Runkle, you merely skimmed through his report? You didn't take time to read and study it?
Well, none of my opinions are based on work that he did. He's undertaking a completely separate aspect in the analysis.
But that's not the question. The question I asked you was, did you, in working closely with him, take the time to study his report?
As I mentioned, I skimmed it. I didn't read through, as you mentioned, all the references or what he cited. I didn't do that.
Did you read his report?
I did read the report, yes, but I didn't in depth go through each reference and look at what he was citing.
So you read his report?
Yes.
And when you read his report, did you see there were footnotes for a number of different propositions that he made?
I know that there were footnotes in the report, yes.
Well, on the issue of whether or not crash test dummies should be used during experiments as a basis for an opinion of whether abrasions can happen through cloth or an arm, wouldn't that particularly interest you since you were going to come here and testify about it multiple times in front of this jury?
I'm not sure I understand your question.
You knew you were going to come in here and suggest to the jury that you thought that these tests were inconsistent with causing any type of holes in clothing similar to Mr. O'Keefe's or abrasions on his arm. You knew that was going to be part of your opinion today, yes?
Yes.
As part of forming a valid...
That's conflating the issue. He conceded a point he probably shouldn't have. That wasn't the opinion offered by Dr. Wolfe. Dr. Wolfe was measuring forces. Dr. Wolfe was not offering an opinion as to how lacerations were caused. That's different. Very different.
opinion that people can rely upon, wouldn't you want to do as much study as possible on the background for that opinion before you give it to a jury?
It depends. Let me answer the question. It depends. If I am offering an opinion to the jury about the medical or physiological injuries sustained by a person who was said to have been hit by a vehicle, yeah, I'd want to know that stuff. If I'm offering an opinion on the force calculations or how the impact occurred and how force was transferred from the tail light to the arm, no. I don't care about certain things. I don't care about whether I need to use a crash test dummy, because tell me how a crash test dummy, in this case, when all I am doing is attaching a damn accelerometer to it, that's all he did. That's all he did. He attached an accelerometer to the crash test dummy arm and he measured the acceleration. And he took a cool video so that we could see the acceleration in real time. That is what he testified to. That is the subject of his testimony. That's what you can cross him on. Can you cross him on the resulting lacerations or the injuries? No, because he doesn't know that, because he didn't do that. This is why I got mad, very mad, because this is conflating what the person was asked to do.
I suppose, yes.
Well, you suppose. Don't you think if you come in here as an expert, the jury is relying on your background and education?
Yes.
And they're relying on the fact that you're representing something definitively or with an opinion to a reasonable degree of certainty? You understand that, right?
Yes.
And don't you think when you do that, that it's important that you have proper study and foundation before you just come into court and give an opinion?
Well,
on
I
what?
will note that the ATD crash dummy is a generally accepted test device to use for not only assessing occupant forces in motor vehicle crashes, but also to assess impact forces. So that the use of that device is certainly generally accepted.
When you get uncomfortable with my question.
I wish he would have answered it this way. Here's how I wish he would have answered it. Here's how I wish he would have answered it. Mr. Brennan, the scope of my inquiry was this. The scope of my inquiry was the force transfer. The scope of my inquiry was calculating the force transfer and creating tests that would replicate the force transfer. That was my inquiry. That was the question. That was what I was asked to do. You are asking about abrasions, lacerations, resulting physical injury. That was not within the scope of what I was asked to do. That should be asked to my colleague, Dr. Rentschler. And you know what's great? You're going to have great opportunity to ask those questions. And I hope you do, because I'm sure he's going to have a better answer than I have.
Judge, you generally tend to answer a different question.
Sustain, Mr. Brennan, next question. Strike that, jury.
Let me ask you again.
He doesn't stop. This would get my ass sanctioned. What the hell? He doesn't stop.
ATD crash dummy is a
This is
generally
horrible.
accepted test device to use for not only assessing occupant forces in motor vehicle crashes, but also to assess impact forces. So that the use of that device is certainly generally accepted.
When you get uncomfortable with my question, Judge, you generally tend to answer a different question.
Sustain, Mr. Brennan, next question. Strike that, jury.
Let me ask you again. Don't you think, as an expert, it's important when you come in and you're going to present an opinion based on science or engineering or whatever you want to do, that you study the basis for that opinion before you give it?
Yes.
When you saw in Dr. Rentschler's report references to this very issue about what should be used when you're doing demonstration or study of what can cause tears to clothing, weren't you interested in the basis for those opinions?
Well, again, it was something where Dr. Rentschler and I worked together, and we were in agreement that we could utilize the ATD arm clothed.
When you decided to have an agreement that you could use that arm, did you read the book that he cites as support, Forensic Pathology, 2nd edition?
No.
Vincent
Why
J.
am I
DeMaio?
reading his
Did you
book?
read it?
Why am I
No, I
reading
did
the
not.
book?
Did you brief it?
Why am I reading the
Did you
book?
peruse
Why am
through
I?
it at all?
No.
When you decided to come to this agreement that's going to have a foundation for your opinions, did you look at footnote 26, understanding the acute skin injury?
Did I look at a footnote? The answer is, unless I'm like reading a funny footnote in a pleading, probably not. No, I didn't look at a footnote.
Mechanism caused by player surface contact during soccer. The survey and systematic review. Did you review that?
No, sir.
Wait, was the footnote about soccer? Hang on. Was the footnote about soccer?
The acute skin injury mechanism caused by player surface contact during soccer. The
Oh my God. The footnote was about soccer. Talk about conflating issues. Say anything there about vehicle collision? You just harped on the man's CV about pedestrian strikes and not knowing pedestrian strikes. Now you want to have cross-examination on him on whether or not he read a study about a surface injury during contact during soccer?
survey and systematic review. Did you review that?
No, sir.
Have you seen any articles that support the proposition that a hybrid 3 arm of a crash test dummy is appropriate to use when you're trying to provide a foundation for an opinion about whether or not tears can happen to clothing or abrasions to skin? Do you have any support for that in your report?
Well, again, Dr. Rentschler is going to be addressing the... You're shaking your head.
It's because he's answering the fucking question. I'm sorry. I'm not sorry. I'm pissed. This is really frustrating.
So I'm going to let him answer the question first, Mr. Chairman.
So as I mentioned, Dr. Rentschler is assessing the injuries to the arm, okay?
Yes.
He indicated to me that we could utilize the hybrid arm to assess the injuries to the arm.
So you have no independent experience or research or knowledge. I'm not Dr. Rentschler, you don't have any independent research or science and knowledge to support your idea, your theory, your opinion to this jury about the tears of the clothes into the skin.
I was...
Oh my God. And I don't know how to adequately calibrate the timing belt to it. What the hell does that have to do with anything? He just said the other person knows it.
Relaying the observations from the testing that we conducted with the ATD. Ultimately, like I said, Dr. Rentschler, it's my understanding that he will testify to the abrasions or the lacerations to the arm.
You've given multiple opinions about this to this jury, didn't you?
Correct, yes.
I'll ask you one more time. Name, I'll ask it this way. Name, other than someone called Dr. Rentschler, name the papers, the studies, the lower treatise, name the resource material you relied on as the basis for those opinions. That a hybrid 3 arm can be used in these type of demonstrations as a basis for that type of opinion.
I certainly... ATD crash test dummies can be used for impact testing, yes.
Not impact testing. You're talking about tears to clothes, abrasions to skin. I'm asking you for the third time. Name one journal, one...
He doesn't know because he doesn't know about abrasions. He testified to that on direct. He answered the question in cross. He answered the question several times. You are asking to opine on a journal regarding a topic and conclusion that is outside the scope of his proffered expertise, outside the scope of his direct examination, outside the scope of what he was understood to know. He's not going to give you an opinion. Now, he's not Dr. Welcher. Dr. Welcher would probably give you that opinion. And would be less responsive in the questions and answers too. Like this is very frustrating.
One paper, one study that supports your proposition that you're relying on as the basis of your opinion in front of this jury today. Name one.
I did not cite any in my report, no.
Can you think of one that you didn't cite?
Not that I'm aware of, no.
All right, we're going to keep going. I'm going to have to pull up some super chats that are not question related. I apologize. I usually try to read every single one of them, but we've gone for 5 hours and 18 minutes. I've told you that today was going to be long because we have a lot to cover, because I feel like going through this testimony and breaking it down is really important. So I apologize that I wasn't able to cover more in terms of questions, but I will save as many as I can. I'm going to start working through those because I also, wow, the closed captioning says this is applause. Oh, it's Hank Brennan ruffling pages. Okay. That is apparently applause. Closed captioning for the win. All right. I apologize, but I think that it's important to get through some of the cross because I need people to understand the context. Like Dr. Rentschler is coming in. Well, one, redirect is beginning and continuing on Monday. and it needs to be solid. Because there's a lot of questions that were rather misleading in this cross. 2, Dr. Rentschler. Now I'm very much wanting Dr. Rentschler. I want Dr. Rentschler on the stand now because I have so many questions for him. And then we're going to get to more. But this was, in my opinion, me. And you're watching the channel because I hope you like my opinion. But I have been waiting for the experts in this case. These sets of experts, ARCCA and ARCCA, because human testimony about recollection of past events, I don't necessarily trust it as much as I do the science and data. I just didn't get a lot of science and data from ARCCA, and I wanted more of a period in the case in chief. And I get it from ARCCA, and I want to focus on this. So this is where my focus is. This is where I'm going to be.
You had mentioned on direct examination that when you first started looking at materials some time ago, at the beginning, you were unconstrained in the scope of your study. Is that fair to say?
Are we talking about 2023?
Yes, we are.
Okay, yes.
You were unconstrained. You could have done anything you wanted to.
I don't know about anything.
When you said unconstrained, what did that mean?
Well, the agency that retained us didn't
It means I got to build an air cannon.
ask us to do specific work per se or specific tests.
You didn't do any type of crash test at that time, did you?
Not like was demonstrated today, no.
Instead, you started a working theory that perhaps a glass was thrown at the rear taillight of the defendant's car?
Yes.
This is a conflation. They did not start a working theory. They were trying to eliminate all other possible theories. It might seem not that significant, but it is pretty significant when you talk about the scientific method and how you're trying to confirm or refute a given conclusion. They didn't create that theory. They were trying to eliminate it.
Did someone suggest to you that was a theory?
No.
It's just something that you and Dr. Rentschler thought up together?
Based on the evidence that we had, yes.
When you thought up that as a potential theory, that's why you built the potato cannon?
The pressurized cannon, yes.
Pressurized cannon. And you shot a glass at the rear taillight, yes?
Yes.
You determined that at 37 miles per hour there'd be similar damage?
Yes.
And then you came into court last year, didn't you?
Yes.
And you provided that opinion of consistency to the jury, didn't you?
Yes.
You got up and you said that something to the effect that that speed is consistent with the damage?
Yes.
Now, when you gave that theory last year to the jury, did you know about other evidence in this case? For example, if a glass was thrown at the back of the car, how would the bottom of the glass bounce off the car and land near Mr. O'Keefe's body?
Objection.
Ask it differently.
Did you consider, when you came in last year and opined, gave your theory about a glass being thrown at the taillight was consistent with damage?
Does the condescension work? Like, does it work? Like I said about credibility, you got to earn some fucking credibility before you start to lay sarcastic comments like that. Ugh.
Did you think theory?
Ask it differently.
The car and land near.
I hate it when lawyers do it. I try like hell not to do it. I think that sarcasm just fails almost 10 out of 10. I mean, you got to deliver it perfectly. It just feels yuck. I don't like it when I've made the comment about Yannetti. I made the comment about Yannetti, and I made the comment about Jackson. I don't like when they do it. I'm consistent. I don't like the condescension and the sarcasm in remarks. I don't think it scores points. Not unless you have the credibility to do it.
Mr. O'Keefe's body.
Objection.
Ask it differently.
Did you consider, when you came in last year and opined, gave your theory about the glass being thrown at the taillight was consistent with damage, did you think about how, if a glass was thrown at the rear taillight, the bottom would have bounced off the vehicle, wherever it was, and landed near Mr. O'Keefe's body?
I'm aware that it was found near his body, yes.
knowing that it was found near his body, or you knew his body was about 7 or 8 feet off the road, didn't you?
Yes.
Knowing the bottom of the glass, the broken glass was found near his body 7 to 8 feet off the road, did you consider if somebody threw a glass above that taillight, cross your mind how the bottom of the glass bounced with him to where his body ended up?
No, I did not analyze that part of it.
If a glass was thrown and bounced off that car, did you consider how its legal would be left at the curb?
No, I did not evaluate that.
If glass was thrown at the car and broke the taillight, did you consider how the debris field would end up on the line?
Well, it's my understanding, I think that there were plows that came through that night, so I don't know that where the debris field was eventually found, if that's where it would have been at some point earlier.
Did you ever talk to Lieutenant O'Hara or anybody from the state police to see if the plows went all the way to the side of the yard or were just down the middle? Look into that at all?
No, I did not.
So did you get any careful
No, because I was retained by the feds and I had only reports that was trying to say whether this happened or not so I could investigate the investigation.
consideration to, if the glass was thrown and hit the back of that taillight, how would be a debris field on the front lawn of somebody's yard?
I don't think that was a part of our scope. It was more or less to determine whether or not, if the taillight was impacted by a projectile like a glass, could you get generally consistent damage to that taillight? That was the objective of the test.
So when you came in and testified last time, you weren't considering all of the other evidence that may not support that theory, were you?
I think our...
Stop conflating the issue. The theory was that Karen Reed didn't hit him. Or the theory was Karen Reed hit him. He was trying to determine whether that theory had any flaws and what other analysis, what other hypothetical could work to yield the same results. It wasn't. Stop shifting the burden, Hank.
Our objective was to determine whether or not the damage was consistent with an interaction with Mr. John O'Keefe, and could there be another mechanism to cause the tail light to break?
Is there a reason why you were backing off that opinion on direct examination today?
Objection.
You weren't fully embracing that theory today, were you?
We
Objection.
don't allow that.
Why?
I don't know if I
Why?
agree
It's
with that.
argumentative.
In this case, you provided reports recently.
Yes.
When did you provide your report? Was it April 6th?
That's cute. He's gonna try and make this argument. It's
April
not.
6th?
I mean,
Or was it
I
May
get it.
6th?
I think it's May 7th.
It's clever. He's trying to make it seem like his expert didn't do the most horrible thing. That's what he's trying to do. That's the point he's trying to make. Let's see. For a little bit.
It's important when you do trajectory studies to know where the point of impact is.
If you're going to utilize studies that look at projection of pedestrians when you're contacted at the center of gravity and you get projected some distance, you can rely on those studies, but you have to have an understanding of where the point of impact is and where the point of rest is.
If you don't have the point of impact, if you don't know the point of impact, you don't know the exact body position, that creates variables in your studies, doesn't it?
It seems like a lot of variables that probably should have been cleared up in the case in chief. Like, I'm just saying, it seems like a lot of variables that you are saying you did not know, but are asking the jury to reach the conclusion that beyond any reasonable doubt, Karen Reed's vehicle did the hitting of John O'Keefe that caused the injuries that resulted in his death. With a lot of unknowns.
Well, again, talking about those studies, they're not applicable when you are contacting, for instance, just a limb, or you don't have a center of gravity hit. Those when you're talking about how far will a pedestrian get projected, if it's like a forward projection, or what's known as like a wrap projection, where the pedestrian wraps onto the hood and then becomes decoupled, those studies are applicable there. But when you're talking about where there's minimal overlap between the body and the center of gravity, then you can't utilize those studies.
So you would not want to know where the point of impact is?
In this
Wouldn't matter.
particular case, no, I don't think it would be helpful.
He's analyzing forces. Stop conflating the issue. He's not telling you, Hank, where the body ended up or how the body ended up there. He's analyzing force metrics. He's basically saying this is what it takes to crack a fucking taillight. This is what it takes to break an arm. This is what it takes to do this. He's not analyzing the trajectory of where the arm goes after that fact. Did you see any angles or protractors or things that displayed distance traveled? I didn't at all. I saw break points. I saw accelerometers. I saw acceleration data. I saw delta V. That's what I saw. I saw force calculations. That was it. That was all I saw in all of this analysis, was the calculation of the metrics, of basically just calculations of what force it would take to exert the damage on the taillight that we saw in the picture. That was it. And then what the corresponding force to the human body would be, the force, not the resulting injury, but the force to the human body would be as a result of those forces that would take to break the taillight. The conflation, the issues that are being conflated here, the premises that are absolutely just being lost in these questions. And I know that people are going to say he's doing it intentionally. I don't think it's the case. I don't think he contemplates the difference. I don't think he understands or processes that. I think he sees it as one big amalgamation of issues and facts. And this person just views data as being the data, like to science, like the magical thing that's out there. The data says this. The accident scene told me this. What the hell is happening? This cross is horrible. Horrible. And it's also horribly misleading, which means on redirect, there needs to be a lot of questions asked to clarify these things. A lot.
You would not want to know the body position?
I don't think that it would be helpful in determining, because again, we have to start with, does the damage, is it consistent with a collision?
So you would not want to know the body position. That's what you're telling us. You don't want to know that.
Well, if the evidence indicates that the contact is inconsistent, then that's kind of where the reconstruction stops. You can't go to a point of impact and a point of rest if there was no contact.
So you don't want to know the body position.
How about this? Answer the question by this. I don't care where the body position was, because it doesn't matter for my analysis.
Can you answer that?
I don't understand this question, Your Honor.
When you're doing studies, you don't want to know the body position?
Can you answer that, Dr. Wolfe?
Hank used these vague terms, like when you're doing studies. Hank, when you're doing studies, I can do a study on how long it takes for grass to grow under certain conditions. When you say a term like when you're doing studies without any specificity, this is the dumbass question that comes out of your mouth. And how is an expert, how am I supposed to answer that question when you're asking it that way? This is what I'm saying when I don't think he understands the premise to his questions. When you're doing studies, it's not important for you to know that. When you're looking at data, it's not important for you to know that. Well, Hank, there's a big difference between data regarding what the weather was that day and data between the speed of a vehicle hitting an arm. They're both data. They both have studies done of them. It's remarkable. Wow, isn't that fascinating? It would be great if you could discern the difference between the types of data, the types of analytics, and the types of studies. This is, if there is anyone involved in science or a related engineering field, practical application, on the jury, they are furious right now. Because every trigger mechanism that could be in my brain, and I am just tangentially related to this, is just firing all the time with every question. It's the worst cross that could have been crossed of all crosses in the crossword puzzle that is this cross. I award you no points, and may God have mercy on your soul.
Again, it depends on the type of impact. For the alleged contact in this case, you can't rely on those studies about impact location and point of rest. They're not applicable to
Let's
this.
talk about studies. As far as data, information, you as the person doing tests, would you want to know the body positioning?
And this time we'll get an answer, and that'll be it.
You got an answer every single time.
Can you answer that, Dr. Wolfe?
I feel like I've answered it the best I can, Your Honor.
Okay, next question.
You don't like that question?
Sustained. Strike. Jurors disregard.
Okay. When you were doing these video demonstrations, was it important to be as accurate as possible?
Yes.
Data changes if information changes, right?
I'm not sure I understand your
That's a
question.
tough question. You want to be precise as you can in ultimately having a conclusion regarding data, don't you?
Yes.
Could I have PowerPoint page 12, please?
I missed the part. I'm sorry. I had to use the restroom. I'm sorry. Hang on. This is the part I want to.
Demonstrations. Was it important to be as accurate as possible?
Yes.
Data. When you were doing tests, would you want to know the body positioning?
And this time we'll get an answer, and that'll be it.
Judge Kennedy. Well, that's also a little bit of Judge Kennedy smacking back at Jackson saying, I said no speaking objections, so maybe don't do the speaking objection. But also, don't do that. He's tried to answer it. It's just, he hasn't liked it.
Can you answer that, Dr. Wolfe?
I do like that Jackson is. Look, I've made my opinions on the speaking objection prohibition very clear. That I think you can't do it. I think the judge was wrong to do it. I think that realistically, the lawyers have an obligation to make the record how they see fit. I don't think a judge can really restrain an individual from doing something to preserve the record. Judge Cannoni has laid down this law, and I like seeing the defense counsel pushing back. I like it. Never going to be one to say disregard a court order. I don't appreciate that, but I've also been very clear that I think that there has to be a record made. And you can't let someone just steamroll and do this shit unchecked. I think, I don't know. Judge Cannoni apparently had a bunch of credibility with the jury last go round, and I think she might lose some. If the defense keeps getting these little speaking objections in, and they get a back and forth between the judge and defense counsel, you might see Judge Cannoni lose a little bit. This was wild to me. But Hank Brennan, the audacity, just steamrolling the question.
I feel like I've answered it the best I can, Your Honor.
Okay, next question.
You don't like that question?
Sustained.
To Judge Cannoni's credit, he says, I answered that the best I can. And Judge Cannoni says, next question. You like that question? That is.
Strike. Jurors disregard.
Okay. When you were
The okay, by the way, the okay would have gotten me drag. Y'all asked me what Judge Girardi would have done. Judge Girardi would have heard me say okay and would have been like, we're going to have a sidebar now. Just now. And it wouldn't have been the me asking that you don't like that question. She would have been pissed at that, but it wouldn't have been that. It would have been the okay.
doing these video demonstrations, was it important to be as accurate as possible?
Yes.
Data
All right,
changes,
this is the last part I wanted to cover.
changes, right?
Here we go.
I'm not sure I understand
That's
your
a tough
question.
question. You want to be precise as you can in ultimately having a conclusion regarding data, don't you?
Yes.
Could I have PowerPoint page 12, please?
I want to let me rephrase. Let me ask that question again. Because this is, again, why I say that Hank Brand doesn't know what the fuck he's talking about. You want to be as accurate as you can when it comes to a conclusion involving data. Verbatim, that's what he just said. You want to be as accurate as you can when it comes to a conclusion involving data. What question is that? What type of question is that? How does that exist? In what world is that question even a question? That's not a question. When you do math, you want to do math with numbers, right? Yes, Mr. Brennan. When I do math, I usually like to use numbers when I do my math. That's cool. And when you do the adding, when you do addition in your math, you like to add numbers, right? Yes, Mr. Brennan. When I do addition, I like to add numbers. Thank you. And when you write words, you use letters to write those words, don't you? Well, yes, Mr. Brennan. When I write words, I usually am using letters in the formation of the things that we call words. So dumb. I hate it. I hate it. I hate it. I hate it. Are you familiar with the concept of gravity? Mr. Brennan, you might be a very good attorney. Very good. And you're a skilled litigator, and I'll give you that credit. But man, oh man, if you ever find yourself outside of a courtroom needing work, oof, it might be difficult for you. We've reached that point. We've just reached that point.
Now look at force on the bottom. The first letter F signifies force, correct?
Correct.
And the last two letters, MA, signifies mass. Yes?
Oh,
Correct.
Oh. Wait, where's Grace's face? You about to get real mad. Everyone who does any science or applied mathematics is about to get real mad. Y'all ready? This is gonna piss some people off. Oh yeah, there we go. We're gonna take a linear analysis and we're gonna conflate it. Oh, this is gonna be good. This is gonna be great.
It's a very
Cannot
important
wait.
part of that equation, isn't it?
Yes.
If you change the mass, it can change the whole analysis, can't it?
Well, yes,
I'm
it
not sure I
changes
understand
one
your
number.
question.
Let me make it more simple.
But does it
When you
change
did
it
these
proportionate?
tests,
Like, is it direct
you chose
proportionality?
a arm from a hybrid 3 crash dummy, didn't you?
Yes.
You can take that down, Ms. Gilman. Now, when you made that choice, you knew that John O'Keefe's arm, based on the statistics and his weight of being 216 pounds, you knew that his arm weight would be 11.8 pounds, didn't you?
Yes.
And you knew that he was 6'1" tall.
Yes.
When you decided to choose an arm, in this case, you didn't choose the arm closest to his weight, did you?
It was representative enough, yes.
It was representative enough.
It was close enough, yes, sir.
Close enough. Wouldn't you want to get an arm most closely related to his actual weight?
I don't know that you can have custom-made ATDs.
You probably can't custom make them, but they have one that's 12 pounds. You know that, don't you?
Are you referring to the 95th percentile?
Yes, I am.
Yes.
So there's a 12-pound arm.
It was cute. That was cute. That was cute. Let's give the kudos to the cuteness, because Hank was like, I have a point. And he's like, I know where you're going. And they're like, I'm right here. And it's like, hey, looks cute. Let's talk about it. Cool. Can't wait to hear your take on it. Why don't you give me your opinion? Yay, we're here. We're on the same page. That was really uncomfortable that I just did that out loud. 5 hours and 42 minutes. This is what this does to me, guys. Oh, baby.
Mr. O'Keefe's is 11.86 according to the statistics. You know that, right?
Yes.
You looked it up.
I saw this.
Yes.
You didn't tell us
Thank
that
you.
on direct, though, did you?
I don't believe I was asked that.
No. Instead of choosing the 12-pound arm, which is 0.12 difference, you chose a much lesser weight, didn't you?
It was about 10 pounds, yes.
No, it wasn't about 10 pounds. It was less than 10 pounds. Let's be exact. You're a scientist. Let's be as precise as possible when we're talking about data. It was less.
I don't hate Hank for this. I don't hate Hank for this. This is pretty good. That's how you make a witty response. He can do it, folks. Look, he is capable. He has the mechanisms. He has the tools in his tool belt to make a witty response that actually is somewhat engaging and endearing. He says, let's be precise. You know better. You know it's not 10 pounds. We know. It's just, the problem is it follows 2 hours of bullshit.
Less than 10 pounds, wasn't it?
I think according to the spec sheet, I think it's 9.4 pounds total.
How about 9.38? You keep coming up a little bit. 9.38 pounds.
Sustained
May I
natural.
approach?
Yes.
Argumentative nature of it was, it was.
Showing you a photograph.
It was argumentative as
Is that
hell.
a photograph of your materials in this case?
Yes.
And in that photograph, it shows the arm that you used in your studies, doesn't it?
Correct.
And it shows that that arm weighs 9.38 pounds, doesn't it?
Yes.
And that is less than the 11.86 pounds of Mr. O'Keefe's arm, yes?
Correct. Yes.
You didn't put that photograph into PowerPoint to make it clear to everybody you were using an arm that was a much lesser weight, were you?
No, I didn't put that photograph.
Like, will this be evidence, please?
Okay. Any objection, Mr. Jackson?
Of course, permission, I'd like to show this to the jury.
Just give us a minute, let Madam Court Reporter mark it.
Exhibit 217.
Yes, now you can put it.
This is the arm that you use in all of your videos, right?
Correct. Yes.
And you can see, could you zoom in, Ms. Gilman, on the weight? 9.38 pounds.
Yes.
There's a bigger difference between 9.38 and 11.86 than there is 12 and 11.86, isn't there?
Correct. Yes.
So when you do the math, and have you done the math before on this?
Sorry, I pulled this up without reading it. It's too witty not to read it. Michael Pepper Tech, question: where's the arm and the leg it costs the Commonwealth to hire their experts? That's solid. I gotta give that. That was good.
When
Sorry.
you do the math, it's 26% difference, isn't it?
In terms of more force,
No, of mass, weight, 26% difference,
Okay.
right?
I'm going to trust you. Yeah,
Well, do you have a calculator?
I do.
Can you do it?
Sure.
Okay. And before you do that, you took this from Mr. O'Keefe's 6'1". You used a
We have the 26%, guys. The 26%. The 26%. Y'all ready for the 26%? 26%. You ready for it? Because a lot of those equations were parabolic or had different trajectories to them that were not perhaps linear in nature. So you ready for the 26%? Because we're just going to do a direct application of 26% to all the equations. All of them. I'm just going to do that. We're going to do 26% to everything. You get a discount. You get a discount. You get a discount. You get a discount. All of you get 26% discount across the board. 26%. Let's be precise. Oh my God, that was so bad. It's so bad. Gray space. Physicist, gray space. Don't even talk to me right now. You get 26%. You get 26%. You get 26%. 26% miles per hour off. 26% force per hour off. 26% everything. We're to blanket 26% on all the things. Look, I made it through Calc 4 before I was like, I quit. It's not how this math works. The math does not work that way. It does not work that way. I know that you think it does. But again, you have to understand the concepts. You don't. And it's pretty clear that you don't. I don't apologize for this pause frame on Mr. Wolfe, because Mr. Wolfe is like, yeah, but you're about to say something really dumb, aren't you? You're about to say something really stupid. He is. He's predicting that in his brain. He's going, you're about to say something dumb.
a crash test dummy what is the height on it?
Well, the ATD, I believe, is 5'7". The Rescue Randy, I think, is 6 feet tall.
We'll talk about the Rescue Randy later. We have questions about Randy. But let's talk about this. 5'9".
Really? What Randy questions do you have? The chat has been Randy all night. And they have asked very Randy questions. I can borrow some of the Randy questions and give them to you because you can't form a question that's actually proper. So maybe you could use some Randy questions from the chat.
You said 5'7". It's actually 5'9".
Sorry, 5'9", yes.
And it's 170 pounds?
171, I believe.
Mr. O'Keefe's not 170 pounds.
No, not his whole body.
He wasn't 5'9".
Correct.
Okay. So when you do the math and you take the 9.38 pounds based on the 171 pound doll, and you look at the percentage, doesn't it come out to 5.48% total body weight?
Yes.
And so the difference, when you look at it, it's a 26.3% difference from his actual weight, isn't it?
Oh my
Correct,
God.
yes.
And so
Oh my God.
I'm probably at the 6th grade level on this, but isn't it very basic that the
Nope. Mm-mm. No, you know what? I'll give you 6th grade. I'll give you 6th grade. I'll give you 6th grade. You know what? I might ask Mini Mischief won this.
the more something weighs, the slower something has to go to have damage. And if something weighs less, the other part that collides, the force has to go faster.
Not
The
necessarily.
force is going to be greater if the mass is greater.
So if you throw a 5-pound rock into a window, you can throw it slower to cause the same damage as you have a 2-pound rock.
Not
I don't know if I
really.
agree with that analogy.
You agree
That's-
that based on 26%
That's a really dumb analogy. That doesn't make sense.
difference, in order to actually be accurate, to be specific, to be scientific, you then have to adjust the speeds that you presented on the demonstrations, and you have to reduce the speed by 26%.
Are you fucking kidding? Okay, hang on. We're gonna replay this. We're gonna replay this one for all the math nerds that need to hear it, all the math nerds that need to hear it. Ready? This is the question. We're gonna do the full lead up. We're gonna do the full lead up. The full lead up. Everyone, the full lead up.
You have a 2-pound rock.
I don't know if I agree with that analogy.
You agree
Here, we're starting the question. So you agree? So when I hit unpause, the question begins. So you will agree? So you will agree? You will agree, sir? This is totally going to be an agreeable statement. Ready? You will agree
that based on 26% difference, in order to actually be accurate,
that based on 26% difference, in order to be actually accurate, ready? Based on 26% difference, in order to actually be accurate,
to be specific, to be scientific, you then have to adjust the speeds that you presented on your demonstrations, and you have to reduce the speed by 26%.
oh, there it is, right there. Oh my God, that was phenomenal to hear again. Sir, in order to be exactly accurate, God, I love all my engineering majors. Everyone in the chat is just going, no. Everyone's screaming, no. In order to be actually accurate, scientific, specific, 100% correct when you're portraying this to the jury, based on the 26% difference in the weight, in the mass of the object being hit, in the mass that's being hit, or doing the hitting, and you adjust mass by 26%. So you must therefore adjust speed by 26%. Sir, there was a whole physics lesson in the beginning of Dr. Wolfe's analysis, and the equation did not work that way. It is not a 1-for-1. It's not how that works. Does not work that way. Oh, my brain got triggered during that one. Pause game is all of us. Oh. This math is not math. This physics is not physics. This is not a proper way of analyzing that at all. No.
I don't agree with that.
You don't agree with that. You think that having a lighter arm, so what you're telling us is having a lighter arm will cause the exact same amount of damage to the taillight studies as a heavier arm. Is that what you're telling us?
Well,
No,
if
that's
you
not-
look
that's
at,
a-
for
that's
instance,
not the same.
the 29-mile-an-hour impact test, that's significantly more kinetic energy. So the momentum of a 6,000-pound vehicle moving at 24 miles an hour, 29 miles an hour, that's going to overcome whatever the mass is that it's hitting at that point.
You're sidestepping my question.
Objection.
Sustained. Ask a question, Mr. Brennan. Just ask a question, no more.
My question is, are you telling us that having a lighter arm does not impact the damage in these tests as opposed to using the heavier arm?
Certainly not in the field test, no.
And so you disagree that when you look at the weights of those arms, do you disagree there's a 26.3% difference?
Yes.
You disagree?
No, I'm sorry, what was your question?
Do you agree there was a 26.3% difference in the arm weight that you used opposed to John O'Keefe?
Yes, the hybrid arm compared to Mr. O'Keefe's arm, yes.
And you are denying that there needs to be an adjustment to your calculation because the mass, MA, is different. You're denying that.
I think, again, if you're, and this is something Dr. Rentschler, I believe, will
No, I want
touch
to talk
on.
to you. I don't want to talk to Dr. Rentschler.
Well, because when you're addressing the forces for injury and the mechanisms for injury, right, you would account for the difference in the weight.
So you're saying that it makes no difference that you use an arm that was 26% lighter. Is that what you're saying to us?
No, I don't think it would have made a significant difference, especially if you look at, for instance, if you're looking at the 95th percentile hand and the 50th percentile hand, they both weigh 1.25 pounds. They're the exact same weight. There's about a pound more roughly in the forearm and a pound more distributed in the upper arm.
But that's not my question. It's not whether it's significant or not. I'm asking you, are you saying under oath right now that a 26.3% difference had no impact on the calculations in that study? It would have no impact at all.
The calculations, yes, but in terms of the damage, no, I don't think that 1 pound difference, when we're talking about something that's 6,000 pounds, striking something that's, quite frankly, whether it's 9.4 or it's 11 something, it's not, you're not going to get a difference in the damage.
So why don't you have a 3-pound arm up there?
Well, I think that's unreasonable, sir.
What's that?
I think that's unreasonable.
What's the difference? It's a 6,000-pound car, according to you. What's the difference between 26%?
Technically speaking, nothing. Like, technically speaking, not significant. For purposes of this test, I mean, Hank Brennan kind of throws a little bit of a not soft, I mean, 3 pounds. I mean, at that point in time, it's like hitting a feather. But technically speaking, you can drop that mass down quite significantly and still not change it by much.
40%.
Well, I don't even know that I agree with your percentage because, again, you're accounting for the whole part of the arm that goes up to here, which we did not strike that part.
It's, how much lighter? 2 pounds and what? How many ounces?
Sorry, what was your question?
How much lighter is it, the arm that you used?
In terms of a percentage?
No, in terms of weight. The weight. 9.38.
Right.
And Mr. O'Keefe, 11.86, right?
About 2.48.
And you're saying that makes no difference? None.
Not in the observed damage at those speeds, no.
Why didn't you use a 5-pound arm, sir?
I'm sorry, what was your question?
Why didn't you use a 5-pound arm?
Because we try to keep it in the realm of possibility or reality. That's why. Like, you could have used a tennis ball. You could have, I mean, these are force calculations. It's a 6,000 pound vehicle traveling at 17, 24, 31, pick your miles per hour. 6,000 pounds. How much time, how much force transfer, how much does it take to get a 5 pound, 6 pound, 7 pound, 9 pound, 10 pound arm to match acceleration or match acceleration? How much does it take? Really? You're conflating some very, 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 very basic principles. You're basically just eliminating the whole 6,000 part of the equation. Like that part, that one. You're missing that one. The big one. That's moving really fast. Against a static object. Against the big one. Static object, the big one. Doesn't matter how small the small one is. Doesn't really matter. Because the big one is the big one.
Again, I don't know that they make a 5-pound ATD arm.
You didn't tell us when you did these studies, you didn't disclose in your PowerPoint that you used an arm that was much lighter than Mr. O'Keefe's arm, did you?
I don't know that it was, I didn't give the weight in the presentation, no.
Did it matter? In the grand
Let's
scheme of the
take a
math.
look at some of your testing. The first one was at
Did
10
it
miles per hour,
matter?
test A. You remember that test, right?
Yes.
Now, 10 miles per hour, if you had taken 26% off, would you agree it would change the actual speed from 10 miles per hour to 7.67 miles per hour? If you did out the math, if you did it specifically, accurately, precisely, would you agree, using the wrong arm, you make the deductions in the calculations, that that 10 mile per hour test would actually be 7.67 miles per hour? Would you agree with that?
They are not the same. They're not the same. They're not the same. It doesn't work that way. And if you're going to have Dr. Welcher get up and testify to that, get ready for him to be annihilated on cross.
With that?
I would allow that.
No, because again, the arm is going to get accelerated up to that speed. So that the speed would still, that mass would still be accelerated up to 10 miles per hour.
Yes.
Same thing in the vehicle testing. It's going to be,
because
given that weight difference, it's going to be accelerated up to that speed.
6,000 pounds.
Now, can we see the video of test A, please?
6,000.
Now, this is your study, 10 miles per hour, you claim, with a arm that is 9.38 pounds, correct?
Correct.
Mr. O'Keefe, 11.86 pounds, yes?
Yes.
Yes.
So he replays the videos, which was a choice. I mean, it was a decision. He made it. He stuck with it. He decided it. I can't change it.
Now, this light on the end of this, you're trying to replicate the light on the back of a Lexus?
Correct.
If a Lexus at 6,000 pounds hits a person, the Lexus isn't stopping automatically, is it?
No,
No.
It would move at a common velocity with the arm.
It would continue to push forward through the arm, yes?
It may, yes.
And the arm can push into the light before the body turns, yes?
I don't know that I agree with that, no.
If the light on the Lexus, not at this speed, but if the light on the Lexus was broken or breaks and it hits the arm, it's not going to bounce off the arm, it's going to push.
Okay. You ready? Hank, you're going to like this. You're really going to like this. Let's accept your premise. Oh, let's accept your premise. Now carry that premise to its logical conclusions. What injuries did the arm sustain under what you just posited? It's your hypothetical. I'm just embracing it. What injuries did the arm sustain under your hypothetical?
Push through, isn't it?
It's going to move at a common velocity with the arm.
And that will move not only the arm, it will move the person's body, won't it?
It may, yes.
It may push the body, it may throw the body.
I don't know about throw.
And the light, if broken, will continue to press against the arm until there's separation. Isn't that fair to say?
It could, in some instances, again, it could bounce.
It could, because it's not always the same. It's a dynamic process, isn't it?
It is dynamic,
You
yes.
could do the test many times and get very different results, couldn't you?
I don't know that I agree with that.
Would you get the same result every time?
I think you would certainly get similar results.
Every time.
If you had the exact same impact location and speeds, yes.
Well, that's my point. What if the impact location moved a little bit? Could it change?
Well, is Dr. Welcher changing? I don't know if, again, I was relying on what he provided
This
in
isn't
his
on
report.
Dr. Welcher. I'm asking you. No, it's not.
Okay, so jurors disregard that.
Did they really just get in a pissing match with one another? They did.
And speeds, yes.
Well, that's my point. What if the impact location moved a little bit? Could it change?
Well, is Dr. Welcher changing? I don't know if, again, I was relying on what he provided
This
in
isn't
his
on
report.
Dr. Welcher. I'm asking you. No, it's not.
Okay, so
Oh, the kids are fighting. This isn't on Dr. Welcher. This is on Dr. Welcher. All right, children, stop.
jurors disregard that exchange between counsel. Next question.
If the body position changed, you may get a different result. Isn't that fair to say?
I was going after what Dr. Welcher had represented in his report analysis. So we did testing to analyze his orientation that he had demonstrated in his report.
You don't like that question either?
Sustained.
If the
Dr. Wolfe ain't getting red in the face or pissed off. He needs to answer the questions. Edward Kirkpatrick, AJ should be allowed to clean up that it was the DOJ for the sequestration order. I mean, it could be. I don't know. I like I said, I think you should brief the issue.
Body position changed, it could change the result. True?
I don't know what you mean by body position. Do you mean the whole body, the arm? What part of the body?
Okay, let's start with the arm. If the arm position changes, it could change the result, couldn't it?
Well, I'm not aware of any other orientation that Dr. Welcher provided in his analysis report as to alternative orientations.
If the arm position changed, could it change the result?
Yes, I mean, I presume if you don't have your arm on the taillight, then yes, you'll probably get a different result.
What if it's bent in a different way? Could that change the result?
Again, I haven't reviewed anything that indicates that there was a different orientation that Dr. Welcher suggested.
You're a scientist, right? You can think. I'm asking you.
These are also conflating the issue. This is again burden shifting. This is basically suggesting that the defense has to prove this beyond a reasonable doubt, and that like Hank Brennan, I'm sorry, you don't get to come in and just poke alternative theories. Like you don't get to just say, hey, is there a reasonable alternative to what you posited as the reasonable alternative to my beyond a reasonable doubt? Y'all realize how like Inception that is? If you are saying that even this hypothetical that is being posited, that your alternative scenario is a reasonable probability as an alternative to what Dr. Wolfe is presenting, then wouldn't you say that you have failed to present your case as proving something beyond a reasonable doubt? Because you yourself are trying to interject this as a reasonable doubt to his hypothesis? I know that was a weird way of saying it. I don't know if I can artfully clean that up. Not 6 hours in at 2:42 in the morning. Wow, it's late. This was the kind of where I wanted to like get wrapping up with this stuff.
Over here. If you bend the arm,
Over here.
Could it change
What
the
an
result?
asshole.
It could.
thank you.
Over here. Over here.
Okay.
Over here. Over here.
When a pedestrian is struck, they are not held stationary on a harness, are they?
No.
In this case, the crash test dummy is on a harness,
Yes, he's supported.
strapped
Yes.
by his hips or pelvis.
Yes.
That's not real life. That's not how a pedestrian is usually when they're hit, right? They're not strapped to a harness, are they?
No, and again, the purpose of this test was to evaluate the arm. We're not looking at the whole body here with this test.
And when we talk about injuries, part of injuries is not just the impact, it's the drag, in this case, from the car, isn't it?
It could be, yes.
But when you put the dummy on a harness, restricting or restraining its movement, it is not going to replicate hitting somebody in their movement, including the drag, is it?
I don't know that I agree with that, because it will replicate, again, when we're talking about that impact pulse of 10 milliseconds, it will replicate that. And that's ultimately what we're after, is what's happening in that 10 millisecond window in terms of the contact and the damage and the acceleration.
I know that's what you're after. What I'm asking you is when you end it, when the light stops, unlike a Lexus, and the dummy is stationary, unlike a person, it affects the aftermath, the drag and the push after, doesn't it?
Yes, the kinematics would be different, likely if it's not restrained like that.
In real life, pedestrian usually is not restrained, are they?
Correct.
In real life, a 6,000-pound Lexus, upon contact with an arm, doesn't usually stop on a dime, does it?
No.
Can I have the photo from test A, please?
There's one point I want him to try and make.
And so there is no break, but there is a crack in this light that was a result of this experiment where this light hits that restrained dummy, yes?
Yes.
And this is at 10 miles per hour in your world and 7.67 if you take off the 26% weight.
In your world. In your world.
We can move to test B, please. Now this test B, a similar test, it has the same limitations, doesn't it? This dummy is restrained at the pelvis.
Yes.
Could you show the video, please? There's two videos. We can see the first one. And was the dummy restrained by its head as well?
Yes.
Was its arm restrained in any way?
It was tethered, but it was free to move.
This test you have at 17 miles per hour with the arm that's 9.38 pounds. Mr. O'Keefe, 11.86 pound arm. If you consider that 26% difference, wouldn't it be fair to say that this test, rather than replicate 17 miles per hour, would actually replicate 12.6 miles per hour?
No, can you answer?
No. 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 That is not fair to say, because that's not what this test is.
That?
Not the way it's phrased, no.
And so looking at this test, test B, which you say is 17 miles per hour, can you do a calculation for the 26% difference, or is that something that you don't think is fair?
I don't think that'd be a fair way to characterize it. Again, if no matter what the mass is there, if you're accelerating it, if you're impacting at 17, that arm is going to move at 17.
Well, not just the movement, the damage. If this arm was 5 pounds, do you think the test would have the same exact result?
If it's 5 pounds,
Yes,
probably would be less damage.
it'd be less damage. So to get this amount of damage, you would have to increase the weight, right?
Sorry, what was your question?
To get this amount of damage, you couldn't use a 5 pound arm. There'd be less damage with a 5 pound arm,
Correct.
right? Because the less weight you use, the less damage at that speed. That's
Correct.
basically how it works.
Correct.
Okay. So, in this test,
Did he just laugh? Did he laugh? Did he just laugh?
the 5 pound arm,
Correct.
right? Because the less weight you use, the less damage at that speed. That's
Correct.
basically how it works.
Correct.
Okay. So, in this test,
You better have a lot of whole good points scored up with the jury, because this is, judges and juries don't let you get away with this shit. And the judges let you get away with it, but I don't know how the jury feels.
if we could run that back again, you have a restrained dummy at the hips and the head. There's no follow through of the light or the body that's attached to that arm, correct? And at this speed, you can see the shards of taillight. You can see them move, can't you?
When you say
Shards get scattered. I want to make the last point. 620. No, was that Jackson on the cross? No, that's redirect. Hang on. Damn it.
move, you mean
Where
just,
is he?
Not stationary.
yeah, I mean, they're moving from the taillight as they break.
It's detached from the taillight.
Correct, they're
That
broken.
could create a debris field, yes?
Yes.
And you can see them floating in the air, some of them actually floating and then touching the sweater. Do you see that?
Possibly. Some of it might be, again, some of that polyurethane foam.
Yeah, some might be. And why don't we play it again so we can see clearly? Some might be taillight shards too, right? That black object spinning, that's not poly foam, is it?
No, it would not be.
That'd be taillight shard, right?
Correct.
And so even at this speed, you can see in this type of collision, there is significant, bless you, significant amount of taillight shards that are broken from the taillight and spewing into
Why can you be courteous to the people in the courtroom that are sneezing, but you can't be courteous to other people? Like, what?
the air, yes?
Well, I think on the one of the slides I had, I think I showed the fragments that were left. And from what I recall, I think there was 4 pieces from the taillight, from the lens.
If you could put that back a little so Dr. Wolfe can see it again to the point of the collision. Even at this speed, go ahead. Stop. You can see pieces, large, small, medium, maybe microscopic, are now breaking off from that taillight and being littered into the air, aren't they?
Yes, there are pieces coming off.
If we can go to test C, please.
No seizures.
Now, in test C, you actually use only an arm. Isn't that fair to say?
Correct.
You don't use a body or a crash test dummy.
No.
You don't, in fact, this is not the 12-pound arm either. This is the 9.38-pound arm.
Correct.
And when you do this test, you have the arm, it's basically just an object suspended in the air, isn't it?
Yes.
Yeah.
And you said, I
'Cause-
think on direct examination,
Because what is he trying to test?
I think you said that this is the same as if it was on the dummy. Is that your testimony?
Well, in terms of again, the amount of weight that would be interacting with the taillight, whether it's attached to the dummy or not, what's in direct contact is going to be the same.
Well, the fact that it's just floating up in the sky like that, it's very different than if it was attached to a person or a dummy, isn't it?
For certain metrics that you're trying to get, yes. For certain calculations, I would agree with you, Hank, but not the one that not what this test was for. Stop.
In terms of how it moves immediately after the impact, yes.
Not just how it moves, as far as the impact. Isn't it different?
I don't know that I agree with that.
Okay. Well, wouldn't you say that in addition to the arm, if you had another 200 plus pounds being held down by gravity, that would affect the force that's acting on the arm?
No,
Well,
not really.
the arm again is going to be accelerated, but the center of mass of the body is not going to see that acceleration.
Have you testified before in this?
He was measuring the acceleration at impact. Like, remember? Like that force transfer. Does it matter if it's attached to 200 pounds when you're talking that? No, it doesn't.
This case about the importance of the full body and gravity?
I'm sorry, what was your question?
Have you testified before in this case about the effect of gravity and the full force of a body as opposed to just an arm?
Yes.
Okay. And do you remember whether you thought it important on a previous time you testified that there was significance to the arm would be attached to a 200 plus pound body and there was the issue of gravity that would affect force?
From what I recall, I think that had to deal with whether or not the pedestrian would be projected based upon an interaction with the arm or a full-on center of gravity hit, right? When we're only
Yeah, let's call the question what it is. How stupid was that question in the first place? Do you remember testifying about gravity and whether gravity would have an impact on any of these analyses? Well, yes, gravity is a force that we have to consider in certain tests, but not this one.
hitting the arm, we're not hitting the CG of the body.
You did test B, and you claim it was at 17 miles per hour, test B,
Correct.
and we saw the damage. This is at 15 miles per hour, test C. Could you play this, please? It might be a delay, so you could fast forward a little bit, please.
Where was the accelerating up?
How many times do you think that arm spun around?
I don't know.
That's not
not
what would happen
timed.
to a person who got hit. Their arm wouldn't spin through their body like that, would it?
Correct. It
Their
would
arm
not.
wouldn't spin that many times.
No.
There'd be the pull of their body weight, yes?
I'm sorry, what was your
There'd be
question?
the pull of their body weight,
The body weight, yeah, would affect the movement afterwards, yes.
gravity, yes?
Yes.
Yeah. And so there's a reason why you do this test at 15 miles per hour. Is there a photo related to this, to the damage to the taillight? There is a reason why at 15 miles per hour, the damage is much different than the other test at 17 miles per hour, isn't there?
Correct.
Right, because at 17 miles per hour, you have a dummy that is strapped by a harness in its pelvis. When it's hitting the arm, it's affecting it much differently than just a arm floating in air.
He is conflating every single test and the purpose of the test and what is intended to give the jury in terms of information. Now I want to get to Hank's little question that I think is a problem for me, or one of the problems for me.
Stop right there. This isn't approved crash test dummy, is it?
The Rescue Randy portion, no.
No, it's just sitting there hanging out in the position that this is replacing Dr. Welcher. So this is something that I can hit at 30 miles an hour that when I can't hit a Dr. Welcher. Like, is it approved? Do I care? Is it better than your expert sitting there with a vehicle going 1.9 miles an hour backwards in reverse? Yeah.
It's not instrumented like a hybrid.
Is the arm the hybrid 3?
Yes, the arm is the hybrid 3.
So you took, in test F, you didn't put the hybrid 3 on the Randy, but on this one you did?
No, because you risk these AT devices can range from $100,000 to $150,000, and you run the risk of destroying that equipment in a test like that.
Don't
So in
destroy
test
the
F, did you
equipment.
put the hybrid on the Randy, or did you keep Randy's original arm
It's just the Rescue Randy in the last test.
on F?
Don't destroy.
Correct.
Yeah,
This
yeah,
one,
because it's
you have the
expensive.
hybrid arm on Randy.
Correct.
So you're switching up between tests, what pieces you're using, aren't you?
I would say adding, but
Well, adding and subtracting, it doesn't have two arms, there's one off, one on. One's Randy and one's hybrid. So you're switching.
yes.
Different result.
I'm not sure I understand your question.
Okay.
Are you trying to say a different result between test F and this test? Because they're not the same test.
Oh, I understand. I understand. If we can have us come back a little bit more. Okay, and let it run. Stop.
I understand.
You
I
can
understand.
see
Says the person who
The
does not
shattered
understand.
taillight moving, and most of it's moving in the same direction, isn't it?
Yes.
And that's what creates a debris field after a collision, doesn't it?
Yes. I mean, components will break off and fall to the ground. Yes.
Now, since Randy is on a harness, he's not going to be thrown the same way as it would happen in real life, is he?
Correct. And that wasn't the purpose of this
I
test, sir.
understand. When you chose 24 miles per hour without the 26% deduction, which would make it 17.8 miles per hour, when you chose 24 miles per hour, it's because you had looked at the tech stream data that had been taken from the defendant's Lexus, right?
Correct.
And when you looked at that data, you understood that during that event, 10 seconds of data is captured, yes?
Yes.
But that doesn't define the whole event, does it?
It's this part. This is the
That
last
only
part.
encompasses what was recorded.
And you said you chose 24 miles per hour because that was about the speed at the end of that 10 seconds.
Correct.
Ready? He's about to say something really dumb.
You do realize at the end of that 10 seconds, the car, the defendant's Lexus, was going faster. It was still accelerating, don't you?
Objection.
I'm going to allow it.
From what I recall, the last data point, I believe the throttle was still around 74%.
Well, ARCCA specializes in tech stream data, don't they?
Yes.
Okay. So you are looking at that, you would agree that at the end of the 10 seconds, the defendant's Lexus was increasing in speed.
Well, we don't know, again, beyond that data point, what the data is.
At the end of that 10 seconds, the car was going up, not down.
Go on, Hank.
In speed.
Keep on.
Yes?
Let's go. Keep
Correct.
going.
And you can't tell how much longer that car
Yeah.
traveled for after that
There
10
you go.
seconds, can you?
Keep going.
Correct. We don't know.
Keep going. Keep going. I love this argument. Keep
So when
going.
you chose the 24 miles per hour, it was just based on a data point. It wasn't based on you believing that there was an impact at a certain speed, was it?
No, and the triggering event itself is it's not a collision by definition, and nowhere in that data can you parse out whether or not any contact even occurred.
We know that.
Okay.
The point is,
Do you?
you can't tell how fast the vehicle was going if it was in a collision from that data, can you?
Oh, this is great. Good. Keep going.
Sorry, can you repeat the question?
If that vehicle was in a collision, you wouldn't be able to tell from that data what the speed was at the time of the collision.
If contact allegedly occurred at some point in that data set, no, you would not be able to pick a row in that data and say, this is where the collision occurred.
Or after that data set, you would have no idea.
Or after that data set. You mean to say, Hank, the vehicle was going faster? Well, wow. That would be remarkable. This was, and this is where I'm going to end kind of the commentary on this one, because I know Alan Jackson gets up and does redirect, but I don't have time to go through that. This was where I wanted to end the cross, because ending the cross was at this dumbass point. You don't know if the vehicle was going faster when it struck John O'Keefe. Okay, Hank, let's play this one out all the way through to its logical conclusion. Go ahead. Why not? Because I'm sure there's going to be one juror that's going to do it. If the vehicle is going faster than 24 miles an hour when it makes contact, one, it's already traveled 87 feet. How many feet does it have to travel? How far does it have to go before it has to start decelerating? And when it decelerates, how long does it take to decelerate? Another 80 feet, 60 feet, 70 feet? If it's continuing to accelerate beyond that 87 feet, for how long is it accelerating? And where does it end up when it does? If it accelerates and it's continuing to accelerate, then it keeps going for what, 120? How long are you positing that this vehicle is going in reverse, and how much faster than 24 miles an hour is it going to achieve? That's a wonderful question. Where is it going to go? Where does the vehicle end up under that hypothetical? Because that sounds to me like I have no clue where it goes, because that's a long distance to get it up to 30 plus miles an hour. And then how do you decelerate it without hitting anything? A tree, another vehicle, a lamppost, a lawn, something. That's a long distance for there to be no other evidence of the vehicle hitting something else. So that's point one. Point two, if the vehicle is moving at a higher rate of speed when it strikes John O'Keefe than 24 miles an hour, then that brings right back into the discussion the injuries sustained. Because I just saw what would occur to the human arm. I don't care how you want to characterize it, 9 pounds, 11 pounds, 5 pounds, I don't care. I saw the injuries at 17 miles per hour. You want to ramp that up to plus 20, 25, 26, 27? How far you want to go? What do you want to say? All of that to get you to a cracked taillight. This is the thing. You can't have one without the other. You cannot have the damage to the taillight to the extent that it's damaged without the corresponding damage to the human body that would result from damaging the taillight at that speed. Like you don't get one without the other. It's kind of a funny thing about force transfer. It goes both ways, right? Force transfer. The 6,000 pound vehicle strikes the thing, the small thing that gets overcome by that vehicle. And the more damage you intend to inflict on the 6,000 pounds, funny thing about force is the more damage is then correspondingly inflicted on the thing here. There's more force meeting. You don't get both. You can't have both. It doesn't math. The math doesn't math. That doesn't make sense. Thank you, Gray Space. There you go. Right there. Stopped at the second law, didn't read the third one. Yeah. You cannot have both theories the way that Hank wants to portray them. You actually have to select one. So that's why it was very, very confusing. And I think that this is going to have to be clarified in redirect a lot, because we got into some of it, but realistically, you have to dumb it down. You have to break it down very simply and saying you could not have one without the other. If the vehicle is going faster, then the injuries are more significant. If the vehicle is going faster, then it takes longer to slow the vehicle down. If it takes longer to slow the vehicle down, then you have to compute more distance in doing so. If you compute more distance, then you run into the issue of where the damn vehicle goes when it's doing this extra distance. All of these things have to be factored in. And then you're also positing that there's this magical strike that happens to be on the elbow, held at an awkward position without any elbow fracture, bruising, or anything else, with this magical striation pattern that I am supposed to believe came from the tail light itself, or the hypothetical posed in cross-examination was that it threw him across the ground, and the ground magically caused these puncture wounds, nine puncture wounds on one arm, not the other, one arm, and only one arm, and that was caused by the ground. So Hank has two theories. One, the puncture to the sweatshirt was caused by either A, the tail light. We know that's not the case. It's not possible. You wouldn't see that. It would be tears. It would be remarkable rips. Two, the physics doesn't work. If you're trying to say that the shards accelerated fast enough to go and create tears in the sweatshirt after the vehicle made impact, that doesn't work. The math doesn't math. The vehicle accelerates the arm up to the speed of the vehicle. The vehicle does not accelerate the thing on the vehicle faster than the speed of the arm. Therefore, you cannot puncture the arm after that. So that doesn't work. Or three, somehow these magical cuts or holes in the sweatshirt occurred when John O'Keefe hit the ground, and we're supposed to believe that they occurred when he hit the ground that was grass covered. And it's the cold, hard ground. And by the way, it hit the ground, which isn't the theory that his own expert posited. His own expert says it was caused by the vehicle. So now he's just putting a hypothetical out there that we haven't even considered yet. So now we got to consider a new hypothetical. Oh, it was caused by the ground. All right, cool. I'll follow you there. But why was the entire sweatshirt not torn to shreds? And what type of impact would it take for someone to be thrown that far where you would get a single tear in the sweatshirt? Be a lot more. Be kind of like test F. And we saw how Randy ended up in test F. Where are the injuries? Hank Brennan in this cross-examination, if the redirect is done properly, Hank Brennan just destroyed his own case. We're going to do a dollar for dollar or a one for one comparison of 26% mass to speed. Nope. Not how that works. No. Forced mass times acceleration. Nope. That doesn't apply to the speed of the vehicle hitting the thing. Nope. Different. You're conflating issues. Different equations. They don't work that way. And if Dr. Welcher decides he wants to get up and testify to this on rebuttal, good luck. Good luck. You know, you want to show your math equations on a slideshow? Can't wait to see it. You explain to me. You explain to me how any of this works. You explain to me how the vehicle decelerates or is continuing to accelerate to get that damage. Just show me. Just show me. I don't understand. I don't get it. It doesn't make sense. The cross of ARCCA was completely ineffective. It conflated a lot of issues, and if highlighted properly in redirect, it's going to just destroy the Commonwealth's case. I have never been just with more reasonable doubt than I have right now. That's why I wanted to see the math. That's why I wanted to see the science. That's why I wanted to see the data. What Hank Brennan gave me was none of those things. None. He gave me paint by number and cosplay. And then when he tried to cross-examine a witness in a fashion that would try to reinforce that he knows what science and data is, he conflated and confused the most basic physics principles that I could ever imagine. Physics and mathematical principles that I could ever imagine, to the point where I don't believe a single word out of his mouth if I'm a juror. None. Absolutely nothing. It is what it is. So I have to do a speed round of questions because we're 6 hours and 30 minutes in. Because again, I knew this was going to be long. I didn't know it was going to be this long, but it's 6 hours and 30 minutes in. So I have to fly through questions, and then I will get out of here and skedaddle so that you guys can enjoy your weekend, because today was wild. Bop it. If no use being grown up, if you can't be childish sometimes. Doctor Who. Love it. Mama Wolfe, my 12-year-old daughter, is in the Special Olympics tomorrow. Good luck to her. I hope she does well. I hope she enjoys it and has a great time. Music to my soul. I don't know about your dad. I'm so sorry for your loss. My mom passed from cancer nearly 3 years ago. From music to my soul. Today is her birthday. I'm very sorry. Heavenly birthdays are difficult indeed. Watching the trial with EDB and now you today has been comforting on a difficult day, so thank you. Music to my soul. I'm glad that you're here. Heavenly birthdays are the toughest. So cheers to your mom, who I'm sure is looking down on you. Emily Polito, from Beckham to Leo. Excuse me. I am sorry. That came out of nowhere. From Becco to Leo for saving his mom from her worst nightmare, math. Wonderful. Steve A., I get that this is leading. Why does Bev let Brennan get away with the same leading questions for the Commonwealth witnesses? I don't know. I really don't. I don't. Just, y'all made your conclusions, and I don't disagree with them sometimes, most of the time. Dr. Welcher, well spread loads. Part 1 of 2. What do you think would happen if the jury sent up a note saying they believe she is biased in favor of the state, citing the 40 plus objections, asking, her to let them present their defense, or for her to recuse herself for being unable to set aside her own bias that's negatively impacting the case. Let's just shorten on letters. It wouldn't do anything. They really wouldn't be able to ask that question. I mean, they sent a note, but the note wouldn't do anything. Actually, it might result in some of the jurors getting disqualified. I don't know, because the jurors have to take the law as presented by the judge, whether they agree or disagree. I don't know that we'd ever get that situation. And honestly, I don't know how a judge would handle that if that ever happened. Curious though. Music to my soul. My only question about ARCCA charges was whether the defense brought the exemplar Lexus separately, because that doesn't seem like enough money to include that. Said access to. I don't know if it was access to, purchased by, or if it was access to as in loaned by or donated by. I don't know. Carrie Temple, what's your analysis of Dr. Wolfe's impacts on the jury? I think when you say, what was the basis for your conclusion? And I have seen all the things that you did, and I don't need the answer to that question. When my eyes are not lying to me, that I think is impactful. The virtual juror, Carvey versus Christopher Simmons, Judson Welcher excluded, Carl Steinbeck found. Can we look at some point? I'm curious. We can try to look. KV v. KV versus Christopher Simmons. Send me a virtual juror. If you're still here, send me an email, please. lawandlumber@gmail.com. Catlin Shoot submitted final forms for Special Olympics Summer Games in 2 weeks. Best of luck. Still remember 2024 games, watching FNF. Everyone toasting to all my athletes, even more athletes this year. Love, Law and Lumber, FNF, and chat. Best of luck to all of your athletes. I hope they have a very successful Olympics. John Scott, any thoughts as to why Wolfe wasn't allowed to comment about Welcher? It was a I think Judge Cannoni was confusing and the issue of you cannot attack another expert's credibility. You can't say they are not credible or that they should be disregarded because they're not believable. It's different to attack their credibility and say that guy's an idiot than it is to say that guy made a bad conclusion because he did A, B, C, D, E, and A, B, C, D, E is stupid. But there's fine lines in between there. And I think that Judge Cannoni started ruling pretty quickly down one of those lines that she shouldn't have, and didn't really correct herself. So I think that they should have been able to explore that. They just weren't allowed to. Kristen M96, since the jury is on the wall, can you build them something so they can be a sidebar instead of a jury box? They need a break. They're on the wall. I got to find something. Texas Prime, Mark Garagos, and Adam Carolla have a podcast, Reasonable Doubt. They've been talking about the Karen Reed trial. MG says the trial is like a bad script for a bad episode of the show Suits. And it kind of is. MG is free Karen Reed. This trial is one of the weirdest things I've ever seen in my entire career. Carrie Temple, worst case, if Karen's convicted on count 2, do you think the appeal process would be slow or quick based on public interest? Slow. Appeals are always slow. Josh H., if JOK, John O'Keefe, was holding a glass, it would have shattered on impact. What are the injuries to his hand? That's a good question. I imagine the defense should ask that question to the jury when consideration on argument. Amelia, Rob, I'd love your take on not calling Proctor. I don't know. I'm actually not too opposed to it. This has been, for me, the sticking point. Everything else is kind of noise-ish. This, to me, is what I can hang my hat on. And if a juror fights me on something, I look back at the data and the science and I say no. And I stick my foot in the ground. And they're not yelling at me about some conspiracy theory. And I'm saying, I don't give a shit. The science and data does not add up. Melanie R., Rob, you're thinking like a lawyer. I'm thinking like a regular juror, and colloquially, it appears Dr. Wolfe did answer the question. Fair. Many of the jurors aren't thinking so legally technical. He's relatable. I agree. Excuse me. That's why I said when he's answering the questions or being evasive, he was doing so in a very likable fashion. It wasn't as obvious as when Welcher did it. Michael Peppertech, quote, there are 3 different types of lies: lies, damn lies, and statistics. Very fair. Odin's Martyr, could any of HB's actions risk getting disbarred? Nah, he's on the margins. Roxy Carson, my year of membership is all thanks to being a gifted member. That's very kind of all those who gift. Thanks to all of you who do. The squid, is Hank really this unintelligent, or is he intentionally trying to confuse the jury? Dr. Wolfe clearly is the guy that specializes in measuring forces applied, while Dr. Rentschler is the guy that knows how they affects the body. He's trying to use, unless he did it, but more artfully and with less of a sledgehammer. He's trying to use one expert to kind of build into a cross of the other. Like I said, Alessi was better at it and didn't do it in such a fashion that was so clunky or so obvious. Courtney Lane. I heard that Brennan filed to keep out or hold back discovery from Welcher rebuttal, and Bev is sitting on it. I haven't seen that yet, but I'll take a look. XCDA, I always learn so much when you're going over technical testimony you're interested in. Also, the lawyer skill that passed me by. I love the technical stuff. Katie Hewling, what percentage of the Randy questions were about spreading loads? Probably a lot of them. Music to my soul, what is your prediction so far on whether AJ or Alessi will cross Welcher on a rebuttal? It'll be Alessi. Alessi is very smart, but Welcher gave him grief last time. Alessi will cross. Alessi knows Welcher's subject matter and testimony. It might be AJ. It might be, because if Welcher's brought back, it's to counter Wolfe. So I could see either one, actually. I take that back. I could see either one. Crazy Cat Queen, question for what would happen if a juror said, "Oh, for fuck's sake," out loud after a stupid Brennan question? Mistrial, removal, finger wag. Removal. That would show bias. Gray space. If you can't tell when a collision happened in the data, you can't tell that a collision happened in that time. I don't disagree, gray space. Stacy Labruno, I've never seen a prosecutor spend so much time and effort disproving their own case. He does a lot of it. Crazy Cat Queen, once had to work with this asshole, and my upper said, "You're allowed to be condescending or stupid. You're not allowed to be both." It's a fair analysis. All right, y'all. Thanks for being here. Much appreciated. We have been going for 6 hours and 40 minutes. I think that's a new record, at least for this year. Thanks for being here. I think that this testimony and Dr. Rentschler's testimony are probably going to be the most significant for this trial, for my purposes, because the defense needs to land this one in order to have a defense. And I think they've done pretty well. I like the experts, how they presented, and I'm very curious to see where they go with it on a redirect and where Dr. Rentschler comes in after the fact. Thanks for being here. Much appreciated. For those of you who are here, the 3,000 that are still remaining as we are leaving, please hit the like button. Please do so. Please also consider subscribing. Very much like it. This takes a lot of time to do. Obviously, 6 hours and 40 minutes is another quasi work day after I worked a full work day and had court this afternoon. So thanks for being here. Anyways, all of y'all go into the weekend, get out there, go make something, go do something, go feel better. Until next time, I bid you all a lovely weekend. Be around family and loved ones. Give them all hugs, and I will see you next time. Bye, guys.